All right, good morning. This is the Colorado Energy and Carbon Management Commission. It is July 30th at 9 a.m. This is our business agenda. We will start with a roll call.
Thank you, Mr. Chair. Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner Mesner.
Here.
Commissioner Oath. Commissioner Ogletree. Commissioner Robbins.
Here.
Chair, we have 4 of 7 commissioners present.
Very good. And these are the 4 that we anticipated having. Good to have all of you this morning. Welcome to the 78 people that are listening into our docket this morning. We have one matter on our agenda today. It is docket 221-000-282. It is a comprehensive area plan proposal by Crestone Peak Resources. And we've got a lot of procedural matters to take up here at the beginning. I would ask our hearings manager to elevate the attorneys of record so that we can have entries of appearance, please. And while those attorneys are getting elevated, I would note for the record that the commission held a Rule 511 hearing in Arapahoe County at the Arapahoe County Fairgrounds on May 16th. And we heard from a number of people who testified to us at that hearing. That testimony is part and parcel of the record. Secondly, we held a public comment hearing on July 15th, and we had a number of folks testify at that hearing, and that testimony is also part and parcel of the hearing. I would also note that the 4 commissioners that are with us today undertook individual site visits to the location of the proposed comprehensive area plan with the representative of Crestone. Generally, the only thing that happened was we were provided information as to where the proposed locations were going to be, and we received information of the general location of the proposed locations. No questions or other comments were elicited at the site visits by the commissioners. Those site visits were undertaken sometime over the course of the last year by the commissioners. All right, with those initial procedural matters out of the way, we're still looking for Attorney Mike Foote and I believe Attorney Stephen Lewis Prescott. All right, we've got counsel with us. Maybe what we'll do is I just want to do entries of appearance so that we know that you're here and you're representative of your clients. And then we'll proceed into the hearing matter before us. Ms. Jost.
Thank you, Chair. Good morning, everyone. Jamie Jost of Jost Energy Law, and I, along with my partner, Kelsey Wieselinski, who's also on, represent Crestone Peak Resources Operating LLC on this Rule 314 Comprehensive Area Plan this morning.
Thank you. Good morning, Mr. Foote.
Thank you, Mr. Chair. Good morning, Commissioners. Michael Foote on behalf of Save the Aurora Reservoir, or STAR.
Thank you, Mr. Foote. Good morning, Mr. Lewis Prescott.
Thank you, Mr. Chair. Good morning, Commission. Stephen Lewis Prescott on behalf of Maverick Mineral Partners, to a petitioner in this case.
Thank you, Mr. Prescott. One procedural matter before us for the lawyers that are with us, and this is with regard to the final pre-hearing order time and order of case presentation. In that, the order indicated that Crestone is allotted 6 hours, STAR and Maverick are allotted 3 hours. I am making a substantive change to that. The time allocations remain the same. However, your time starts ticking when you start arguing on your motions. So be aware of that. You are allocated 20 minutes to Crestone on the affected person status of Star. Star has 15 minutes. On the ripeness issue, Maverick has 20, and it's what it says. No, Crestone argument on ripeness is 20, Maverick is 15. You can argue up to those time limits, but do note that's cutting into your case in chief and cross-examination and other time. Everybody comfortable or at least understanding of that point? Okay, seeing nodding of heads in the up and down fashion, I believe that we will start this morning's hearing with a presentation from the Colorado State Land Board. Crystal Corenda, Minerals Director of the State Land Board. If we could elevate Ms. Corenda, we'd love to hear from her.
Hello?
Hey, good morning.
Morning. All right. Good morning, commissioners. Let me share my screen and get situated here. Can you all see my screen?
Yes, we can. Looks great.
Great. 1 second. All right. Good morning, commissioners. My name is Crystal Corenda. I'm the Minerals Director at the Colorado State Land Board. Thank you for giving me some time to speak briefly about the State Land Board's role as the surface and mineral owner out at the Lowry Ranch. I want to point out that the State Land Board is not a regulatory agency like the ECMC, and we defer all regulatory approval to the ECMC and to local governments. The Land Board is a landowner just like any other private landowner, and I will get into that more in my presentation. Today, our agency is not offering an opinion on the proposed cap, but I wanted to provide some background information for you to consider when you're making your decision. So we're here today to discuss the Lowry cap. I'm going to provide some information on the history of the Lowry Ranch, the oil and gas development that exists on the ranch, and the State Land Board's largest oil and gas lease on the ranch that's currently held by Civitas and covers 21,000 acres. In the map here, you can see the outline of the cap in green, which covers about 33,000 acres. And in the background, you can see a black line that represents our ranch boundary. As you can see, the cap includes a large portion of the ranch, but it also includes a lot of private mineral owner estate to the west of our property. And on that note, there's been some confusion about the ownership under the Superfund site. And so I just wanted to clarify that the Land Board does not own any surface or mineral estate under the Superfund site. And I think you can see here on the map that there's a little carve out here of the Superfund site. So it's also not included in the cap. Some history about the Lowry Ranch. Development started on portions of the Lowry Ranch in the 1920s for oil and gas. And in 1938, the land was donated to the Department of Defense and used for 3 decades as a military training site. Specifically, they used the land as a bombing range and a gunnery. And there's also a missile silo on site. This use has left a lot of debris on the property, and there's still about 6,000 acres of unexploded ordinances that are being remediated by the Army Corps of Engineers. And the Land Board took ownership in the 1960s and has been leasing it for a variety of uses ever since. These range from cattle grazing, solar development, there's a model airplane club out there, and of course, mineral extraction. There are other leases in production out at the Lowry Ranch that are oil and gas that have been in production since the 1970s, but today I'm just focusing on the lease that's held by Civitas. Some background on Civitas's lease. In 2011, the Land Board hired a consultant to assist with developing an oil and gas lease for the 21,000 acre parcel. At that time, we'd only really leased something around 640 acres. So this was the first large lease of this size that we would be offering. And the board at the time decided to create a stewardship strategy to recognize, enhance, and protect the most important natural values that currently exist on site. Based on the board's recommendation, staff brought in the Nature Conservancy, ERO, environmental consultants, they're out of Denver, Arapahoe County, CPW, City of Aurora, and the Colorado Natural Heritage Program to get advice and guidance on how to best lease for oil and gas on the property while protecting the natural resources. And so all of these parties work together to create the current lease that's in place. Staff also issued a request for qualifications prior to issuing the lease to vet and verify potential bidders to see if they had the resources necessary to comply with the robust stipulations. And as you can see, when it was ultimately put out for bid, ConocoPhillips won. It was later then assigned to Civitas, and we did the same vetting process before approving the assignment to Civitas. I think the biggest thing that came out of the collaboration with all of these agencies are the stipulations that are placed on the oil and gas lease. And it includes this tier map, which I'll kind of walk you through. When we issued the lease, staff placed a disturbance cap on the lease of 650 acres, which is 3% of the total surface area of the lease. The concept of the map was to push development on previously disturbed lands and avoid lands with natural values. So in this map, the green is a tier 1 and it's no surface occupancy. And the other 3 colors, they allow for surface occupancy, but they count different toward that disturbance cap. And the concept was to push pad locations onto previously disturbed areas and prevent locations on identified sensitive areas. So on the map, you can see the pink, that is previously disturbed area. And that is where we're really trying to have pads be located and gives them the best incentive, so to speak, toward that disturbance cap. Having all these parties at the table when we created the lease also led to robust stewardship stipulations and requirements. The lease requires annual biological surveys on the property. And since inception, the operator they conducted these surveys. They cover multiple species, including amphibians, migratory birds, pollinators, soil, groundwater studies, to Piedmont grassland studies. And I put up here raptors and swift fox. Those are important things out at the ranch. Many of these research studies would not occur without this lease stipulation. A lot of these surveys go above and beyond what is required under the ECMC permitting process. Staff utilizes these surveys when we're doing pad stakings and determining where to locate oil and gas pads. And there's also an annual lease lessee meeting that we do with Civitas, where they go over the results of all of their studies and their surveys, their drilling plans, and we make sure they're compliant with the lease. So beyond the oil and gas lease stipulations, our agency also has a lot of monitoring on this property. The property has an enhancement fund that was created by the board that's funded from royalties from the oil and gas lease to restore, maintain, and enhance the ranch. And there was a special advisory committee that was created to manage and utilize those enhancement funds. There are also 2 long-term land management plans that our agency created, and I've listed those on the screen that guide planning and use into the future. Now that you have some background on this lease, I'm going to provide a little information on why it's important to our agency. The shortest description of the land board is that we're a state agency that owns and leases 3 million surface acres and 4 million mineral acres for our trust beneficiaries, which is mainly public schools. The rent and royalty that we collect from our leases flow directly to our trust beneficiaries. And in the past decade alone, the State Land Board has generated $2 billion for public education in Colorado. Although the ECMC is our sister agency and we both fall under DNR, our mission is a little different than the ECMC's mission. So we have a dual mission. We have one half that's focused on earning revenue for school children, and the other half is focused on stewarding the land for future generations so they can continue earning revenue off the land. And that's why we define stewardship as an ethic that embodies the responsible planning and management of resources. It's stewarding our assets today so they can earn equal revenues for future generations. And this slide also references fiduciary duty. I want to mention what that means. At the land board, all of our staff and our commissioners are acting as fiduciaries for the trust beneficiaries. meaning we have a legal and ethical obligation to act in the best interest of the school children of Colorado and not the citizens as a whole. This is an infographic that goes through our oil and gas leasing process. An interesting fact is that 3% of our mineral estate makes up 70 to 80% of our revenues every year. So a very small amount of our land that's leased has a large impact on our agency. The oval on the screen is where we are in the process right now. The process that is described above the oval on that first row is our typical leasing process. And for this lease out at Lowry, that happened back in 2011. So when you look at that first row, you're going to see that our normal leasing process has a lot of internal and external reviews. But the important thing to note is that every lease that we issue is presented to our board at a public board meeting where we allow public comment. And in this case, that happened back in 2011. The process that's circled below is where your agency comes into play. Before an operator can develop, they have to go through all of your rules and regulations, participate in your public board meetings like the one here today. Then they have to do the same with the county. And in the end, if they make it through all of the required processes and develop, the royalties generated go to the school children of Colorado. So in this process above, the land board does not make any regulatory decisions, and our board solely makes the decision whether or not to lease land for a particular use. The ECMC and the county will have full regulatory authority over the development of the land. I wanted to give some local context on Arapahoe County since that's where the CAP's located. We are incredibly proud to be the primary funding source for the Building Excellent Schools Today program, or BEST program. It's a capital construction arm of the Department of Education. In regard to Arapahoe County, 24 grants have been awarded to schools there, totaling roughly $105 million. And the grants fund projects that range from HVAC repairs, asbestos abatement, to entirely new buildings as the one you see in this picture, which is the Deer Trail School. But to be clear, our agency earns the money and then we distribute it to the Department of Education. So where we earn the money, meaning the location of the mineral estate being developed, is entirely disconnected from which school receives the money. The development in Arapahoe County could benefit school children all over the state. The next two slides hit on two important things to understand about us, but are both commonly misunderstood. First, we are not a regulatory agency. We don't issue permits or create regulations. I've mentioned this a few times. I think my communications person really wanted me to hit this home. But I think we get confusion because most of our sister agencies at DNR are regulatory, like CPW, ECMC, DWR, DRMS, but we are not one of those agencies. Second, we and anyone who does business with us are required to comply with all local land use regulations. Just because someone has a lease with us, they still have to get a permit from the state and at the county level. And we ultimately rely on ECMC in the county to be the regulatory authority and issue permits or decide not to issue permits. To wrap it all up, going back to our dual mission, our staff believe that this is being achieved at Lowry Ranch. The Lowry Ranch is one of our agency's most valuable assets, and it's our highest yielding property. To date, the Civitas oil and gas lease has earned over $209 million for the school children of Colorado. And if oil and gas development continues on the property, the State Land Board anticipates future revenue generation of $300 million or more. And I'd like to point out that with oil and gas development happening throughout the ranch, it's considered an exemplary property that reflects award-winning land management practices while also supporting multiple uses. I appreciate your time today and for letting me share this information. That is the end of my prepared remarks. Are there any questions?
Thank you very much for being with us and presenting to us. I'll start with a couple of just sort of high-level questions. The land board has owned this property since the 1960s, it appears. Do you know, can you provide some perspective of how the property ended up with the land board? Like, I know that generally land board property was sort of set aside when the state was created in its different sections across the state. This seems to be a little bit different.
This was done through a transaction in the 60s. I don't know how we acquired it from the federal government. I can get you that information. But yeah, typically we got our land through a land grant. We got section 16 and 36, but there was a lot of land that we could not get due to Native American territory on the western slope. And so we were given large land holdings elsewhere to compensate for the land that we weren't allowed to get in that region. So I'm not sure if that was part of that, but I do know that we acquired it from the federal government in the 60s.
Okay, let me ask the question in a different fashion. Does the state land board treat this land, co-equal to the other
Yes.
lands that it owns, like it's treated in a similar fashion?
Yes, all the lands that we manage are trust lands.
Okay. And then you mentioned that starting in 2011, you hired a consultant, you brought in the Nature Conservancy, you brought in Arapahoe County, Colorado Parks and Wildlife, all of which was to sort of create some stipulations for how an oil and gas lease would be generated for the land. And did I get kind of that right? And you in a quote robust stipulations about that. Can you talk a little further about that?
Yeah, sure. So at that time, all of those parties came to the table and we just got input, feedback. We did surveys to identify natural resources on the property. We wanted to make sure that those were protected. And that's how that tier map came into play. We were able to focus on these lands have been previously disturbed. There was a mining lease out there that was doing sand and gravel mining. And so there was a lot of disturbance from that sand and gravel mine. And that's a lot of the locations that they wanted to put pad locations on where it was previously disturbed from this mine. And so all of these parties came together to help create the lease. It's a very extensive lease. I think it's 60 pages long. And they help create the different requirements and those stewardship stipulations that are in place that do require those surveys annually and things that go above and beyond what typical ECMC permitting would.
Does the state land board undertake that sort of robust process for each and every mineral lease that it leases?
That extent, no, but our current process that's in place, I didn't necessarily walk through it with you, but we do a very large internal review and then we do an external review where we get comments from CPW, Denver Water, Colorado Natural Heritage Program. We review like the state archaeologist's website. We make sure that, and then we also contact local government designees. We get input from all of those parties and we will write special stipulations to address any concerns. So if there are identified biologic concerns, things of that nature, we will write stipulations. At that point, we may decide it's not available to lease if it's on Greater Sage-Grouse Select and we don't lease. But if we decide it is available to lease and we can have a stipulation that protects the interest or the concern, then we would recommend it to our board for lease. It goes before the board at a public board meeting.
So that is different from my perspective as a regulator of oil and gas from the ECMC perspective than what we normally see where an oil and gas operator perhaps goes to a surface estate owner that has the mineral estate underneath it and they get a surface use agreement. Why does the state land board go through such a arduous protective process with regard to its mineral estate leases?
I think a part of it is like our dual mission of stewarding the land because we want to make sure that the land is able to generate revenue for future generations. And so we want to make sure that different concerns, like biologic concerns, different resources are being protected so that land is able to, generate revenue for the school children in the future. And we've always, tried to work in collaboration with CPW. If they have specific biologic concerns, we, may lease, but say no surface occupancy. And so we do try to take in everyone's concerns and see if we can come up with the best solution for it. So I'm I'm not sure. Since I've been here, that's always kind of been the process.
Okay, no, I appreciate it. Noting that you're not a regulator of oil and gas, but that you are the owner of the lease and you have these strict terms or robust stipulations, as you called it, with regard to the lease. Does the state land board have a position, and I think you can give me this information, even though you're not a regulator, as to whether the comprehensive area plan is consistent with the terms of your lease?
I don't know if I could speak to that because I haven't reviewed all of the comprehensive area plan documents. I mean, a lot of the cap goes and extends beyond our land, and I've seen that green map of where it's located, but in terms of all of the information that they've provided or submitted, I haven't reviewed it, so
Okay.
I'm not sure if I can speak to that.
Let me ask this question a different way as well. So taking outside the areas that are outside of your lease, is the proposal that is within the lease with the state land board consistent with the 60 pages of terms of the lease?
I haven't seen their cap proposal, so again, I haven't reviewed it to know that.
Would the
Yeah.
state land board, I mean, if you've got a lease and you've got 60 pages of robust stipulations, I assume you're going to make sure that it's consistent with the terms of the lease, like whatever they do with their leased minerals.
Yes, we monitor our lease and make sure to date they have followed all of our lease terms and requirements and
Okay.
all of our, everything that is in our lease, we monitor, we meet annually, we ensure that they have checked every box. But in terms of what they have put in the cap, I have not reviewed it, so I'm not sure what's
Yeah,
been included in that.
totally fair. I just wanted to make a record in terms of like, you didn't create 60 pages of robust stipulations and then just like shelve them and not ensure they're complied with.
No, I get calls weekly. We are always talking about the lease. We are always looking into provisions and ensuring compliance. Yes.
Great. Thank you, Ms. Corunda. I really appreciate your answering the questions that I had. My fellow commissioners may have questions as well. I'm looking around to see if they have questions. Commissioner Cross?
Thank you, Mr. Chair, and thank you, Ms. Corunda, for your presentation today. It's very helpful. The majority of my questions were covered by Chair Robbins, but I did want to touch on one thing you mentioned towards the end. You talked about it being, I think you said, considered an award-winning managed land area. Is that correct?
Yeah. Yes, that's correct.
Could you go into that a little bit more? Has it won awards for land management? How do you make that consideration?
Yeah, it has won awards. So we have agriculture leases out there and we do rotational grazing. And so we've won various awards for the rotational grazing and the agriculture practices that are happening out at the ranch. So that I know specifically, it's, I don't want to say like the crown jewel, but it is one of our best, most exemplary properties. We also brought students out. We bring students out all the time to discuss the rotational grazing and for them to see how we layer leases. So what I mean by that is, out at the Lowry Ranch, we have an agriculture lease, we have a solar lease in place, we have the model airplane club, we have all these different leases and oil and gas all on top of each other, and they're all able to generate revenue at the same time. Well, we all coexist. They all coexist.
And can you describe where those agricultural leases are, the rotational leases? Can you describe where they are compared to where we are focused on for this cap application?
I think it's the entire ranch. I'd have to verify with our ag. I'm not in charge of the ag leasing, but I believe that it covers the entire black outline on that map. If you need me to share it with you, I'm happy to share it with you. But our entire ranch is leased for agriculture.
Okay, thank you. And to build off a little bit of what Chair Robbins was asking as well, can you compare or describe some of the differences in the lease stipulations and the lease requirements and you talked about several things, the model airplane club, the the agricultural leases, et cetera. Can you the solar leases as well? Can you describe some of the stipulations in the lease and some of the BMPs that are applied compared to what's being done in the 60 pages here?
Yeah. So I guess what might be the best, I should have probably just provided you all a copy of the lease and the stipulations. I'm happy to do that. But I think the surveys are one of the main things that I think about that go above and beyond, and meeting annually to discuss the surveys. Typically they outsource all of the surveys with an environmental consulting firm. And that is something that we don't always see. You know, they're doing air monitoring, water monitoring, all sorts of things. And then we're getting the results of those surveys each year to see, okay, how are the pollinators doing? Where are the raptors located? So that's all very helpful when we are doing pad sightings. But I think the biggest thing is that tier map. I mean, we have a large portion of the ranch that they are not allowed to put a pad location on due to an identified biologic concern. And so that ultimately is off the table. Then there's a tier 2 where you could put a pad location on tier 2, but it's going to count double toward the disturbance cap. So if your pad's 20 acres, we're going to count it as 40 against that cap. And so it's really trying to hinder them from putting it on those locations because we've identified something of a little bit higher value. And then again, we just really are trying to push things to that pink area where things were previously disturbed. So, and as of right now, they are nowhere near that disturbance cap. And it doesn't seem that per their comprehensive area plan, they will come even close to hitting that cap.
The limitation on their usage.
Yeah, they're allowed to disturb 650 acres. And from looking at their cap plans and where they plan to put pads, they won't come close to disturbing the entire 650 acres. So,
okay. And one final question with respect to that, the layering that you discussed. You did mention, for example, the solar leases there as well. Is there layering with respect to some of what's happening in the oil and gas and extractive leases compared to the solar leases? Or is where the solar leases are located, is that some of what's considered the no occupancy restrictions in that map?
So yeah, other leases on the property are not subject to that tier map. No other lessees have a tier map that was just created for the oil and gas lessees. But just knowing our staff internally, they would not put a solar lease on some sort of identified biological concern. We work with CPW when we're citing any of our leases if it's going to be some sort of disturbance on the surface.
So you'd be specifically looking at high priority habitat for the no occupancy areas, the tier 1 that you're talking about. It's not that, well, we put a solar lease there, and because there's a solar lease there, we don't want oil and gas near the solar lease, and therefore that's not okay.
Yeah, the solar has just come out recently, more recently in the last couple of years. We've added some of the solar farms out there. So oil and gas has been in existence for quite a while longer. But yes, the way you described it is correct.
Okay. I think those are the only questions I have for now. Thank you.
Yeah, great. Thank you.
Thank you again. Commissioner Messner.
Thank you, Mr. Chair. And thank you, Ms. Coranda, for being here and presenting for the State Land Board. I've got a number of questions, if I could. So I wonder if you could go into a little more detail on the tier structure that's developed for this piece of property. And I think I've heard you a number of times indicate that the intent of the tier structure is to push people towards the pink. But there's a number of different tiers here, and I imagine there's different criteria associated with each of the tiers. And so if you could provide more detail, that'd be great.
Yeah, would it be helpful if I put the tier map back
Yeah.
up?
Yeah,
I was gonna say the same thing. I think it would be helpful.
Okay. Let me get to that slide. Okay. All right. Okay, so, and I do apologize because this map was created in 2011 and I was not here at that time. So, some of these questions, if I don't know specifically, I'm happy to find out the answer from staff that was there at that time and kind of get back to you. But from what I understand on this tier map, you can see the green areas are no surface occupancy. And I believe these are two creeks that run through the property. And so I think the no surface occupancy was considered to protect the creeks and their beds. And then there are there's the two planned reservoirs out there that were also no surface occupancy. And then the tier 2, my goodness, is controlled surface occupancy. Any disturbance on a tier 2 is going to count double toward the disturbance cap. Then we have tier 3, which is the gray, and all of the gray area counts 1 for 1 against the disturbance cap. And then the pink area, the preferred surface occupancy, does not count toward the disturbance cap if they can locate all of their pads in that area.
okay. So really, the tiers are, they're not designed to necessarily avoid particular impacts or utilize any of the, I guess, studies to determine whether it could be there or not. It's really just determining allowance towards the 650 acre cap. Is that correct?
Well, I think that the tiers were created based on biologic concerns. So there's like the blue area, which is tier 2. I think a lot of that was Piedmont grasslands that they were trying to protect. So they were trying to really make that count double toward the disturbance cap because they want to encourage not putting a pad on that location. So all of these tiers were created based off studies that were conducted by TNC and the environmental consultants, identifying where the key resources were or biologic concerns were, and then they created each tier based off those concerns. So I do think, all of these different tiers were created based on what they're trying to protect.
Okay, and as far as your review of particular siting, I think you've indicated that you have not reviewed the cap or the cap documentation. And so you're reviewing it just to determine whether or not, how to calculate the acreage. Is that right?
Yeah, for our purposes, we would check with the tier map to make sure that it doesn't, fall into a no surface occupancy location. Wherever it does fall, we would calculate it toward their total disturbance. We also check with all of their surveys and studies they've done to see if it's compatible at that location. We have staff that will go out and walk the site with them and say, here is a mule deer winter range, so we'd rather have the pad be over here. So they walk out and look at all of the surveys and the information and help determine where a pad should be located.
Has that occurred for this particular situation?
Yeah, all of the pads that currently exist out at Lowry that they've already drilled, we've done that.
What about the proposed pads?
Well, I do know that we have staff that have gone out to the proposed locations, but they have been changing very rapidly. I think based off like community concerns and things. So I think we're at this point, Civitas will contact us when they're ready to actually stake something. But from my recollection, yes, we are out there with them constantly, looking at their new proposed locations and whether it will work. But I'm not sure. In the last couple of weeks, I know in the last few months, things have changed a little bit of where they're looking at putting a pad.
So in this structure of review that you highlighted, and in the position that we're at, do state land board provide an opinion as to whether or not the sites that may be proposed meets at least the state land board lease requirements and the requirements associated with these different tiers?
Yeah, if I were to get their final, like the current pad locations that they're looking for, we could definitely give some sort of, yes, this meets our lease requirement. And from my understanding, I believe that it does, but I would like to actually double check and review that to make sure. But yes, we could give you some sort of confirmation.
And does the lease requirements associated with these different tiers require additional steps beyond your review? Like, are there consultations that need to occur? Is there evaluations? What are the stipulations that are necessary to happen in order to create that opinion?
Well, we typically do reach out to CPW, but now that is all wrapped up in the ECMC process. That was something we always did prior to it being part of your permitting process. I would have to talk to our, we have a field technician that does all the sightings with them. But I think my review would be the only thing that would need to be done.
Does do access roads count towards surface disturbances and pipeline infrastructure?
Yes.
Okay. And I assume that those would not be allowed to go through no surface occupancy areas, is that correct?
Yes, unless they receive special approval. I know I can think of one instance since I've been at the land board, and I think it's the only instance where a pipe had to go through some no surface occupancy, but we brought the matter before our board and had a public board meeting to ask for approval. They asked for approval of the pipeline. And it's been reclaimed at this point.
Okay. And then understanding that you're not you've indicated you're not a regulatory agency, but at the same time, you've got stipulations associated with the lease and have some siting responsibilities associated with your lands and some oversight, I would assume, of the lands. Who monitors and enforces any lease stipulations associated with state land board leases?
So it depends on the different provision. If we're talking about their drilling requirements and obligations and whether they're meeting production, I deal with those for this lease. But if you're talking about the different stewardship stipulations, we have a conservation services manager here at the land board that meets with their the people that do all of their studies and works with them. Specifically, we have a field inspector that goes out and inspects the pads himself. He used to work for the ECMC, so he's very familiar with your rules and regulations and talks with your staff all the time. But he goes out just to check these different pads to see if there's anything wrong with them. And if he finds it, then he contacts the ECMC. But he also enforces a lot of these stipulations as well, or he does a lot of the double checks. If they say a pad is going to be 10 acres, his current audit he's doing is it actually 10 acres? And, if we find out that it's actually 11 acres, then we go back to them and we do what we need to do to get it remedied. So we have different staff at the land board that monitor and enforce different provisions of the lease.
Okay, thank you.
Mm-hmm.
Commissioner Ackerman, I believe you were next.
Thank you, Mr. Chair, and thank you, Ms. Coranda, for being here. And thank you to the State Land Board and to the staff and to the board members for their significant expertise and their work managing land for multiple uses on behalf of the people of Colorado. That's a difficult task, to be sure. You talked about this being a multi-year effort, including contacting subject matter experts from a number of management categories, as you talked about. And I would specifically note that CPW stated that due, at least in part, to the efforts you discussed, this is one of the most extensive wildlife data sets of any oil and gas consultation that they've seen. I do have a few public process questions for you, if I can. You briefly mentioned that public input is taken at board meetings, and that the board meeting applicable to this project was held in 2011. Can you talk a little bit more about what that public process looks like, how the public was engaged, and how the public is informed of topics that are being heard before the State Land Board?
Sure. I can speak to how it's done today. Again, for the exact specifics of 2011, I can look into that and get back to you. But since I've been at the land board, which has been almost 10 years, the way our process works is people in the public can ask to be put on a list to be notified of all of we have monthly board meetings, and they can be asked to be on a list where they are emailed our agenda. So our agenda is publicly posted on our website about 2 weeks before a public board meeting. Or it is emailed to the parties that want to receive that list. And then at the public board meeting, it's very similar to your format where there'll be a presentation, and then the public is asked if there's anyone that wants to speak or comment on a matter, and they are given that opportunity.
Thank you. I appreciate that. And this is reaching back since it was in 2011. But are you aware, with this being such a large effort, was there any specific outreach to neighboring communities or leaders or the neighboring public in any way? And again, I understand this was quite some time ago.
From what I understand, there wasn't much out there at the time. There was not a neighborhood community. I think that was built after our leasing process. And so I believe there wasn't anyone to contact at that time, from my understanding.
Thank you. Yes, that's my understanding as well. Was 2011 the last time for formal public input then to the State Land Board on the oil and gas leasing plan, or does the State Land Board receive comments on their actions at any time?
I mean, we always can receive comments and review them. But in terms of our lease, once it's issued, it's a contract. And so we have a contract with Civitas. We have granted them those rights to develop, and it's something that we can't, take back at this point unless they are in breach or in default.
Sure, understand. Thank you. And so 2011, as I understand it, was the last time for any formal public input to the State Land Board on this issue. Can you discuss any other community outreach that the State Land Board does on its mission on this issue, especially to potentially impacted residents, or on the State Land Board mission in general, including generation of revenue through minerals leasing?
I would love to get you in touch with our communications person. She has done wonders at the land board. We have outreach videos. We have a lot of information. They've done like a PBS special on the land board. But in terms of this item in particular, I think when we started getting phone calls and realizing that this was a community issue and people were concerned, we put a page on our website specifically discussing the cap and our ownership and our lease and our mission and our mission. So we have that. We participated at the local county, Arapahoe County, when you did a hearing there for public comment. We went and presented there to try and provide some information on the land board and our lease and the robust stipulations in place. And we take emails and questions all the time from community members and public calling and wanting to know more information. We happily take those and walk them through our lease or any questions that they have. But
Thank
that
you.
is, yeah, that's what comes off the top of my head. But our communications person, she probably is like, you didn't list 100 things that I do. She does quite a bit. So
Thank you. Appreciate you being here.
thank you.
Ms. Corenda, one last question or maybe a task for you, if you don't mind. And this is with regard to the lease, and you mentioned that you could get us a copy of it.
Yes.
I believe that the lease is in the record as Exhibit N from Crestone. That's Bates pages 26 and beyond in Volume 3 of Crestone's exhibits. If it's sometime in the next, could you just go to that and I can get staff to send that to you? I just want confirmation from the State Land Board that that is indeed an accurate copy of the lease.
Sure. Absolutely.
Okay, that would be great. Any further questions from commissioners for Ms. Corenda? All right, seeing none, we thank you very much. We thank the State Land Board for the presentation today. It's very helpful information as ECMC, as the regulator, makes a record and determinations on this matter. We'll let you go. We'll look forward to getting confirmation of Exhibit N as being the accurate copy of the lease, and we'll move to our next matter. Before we do that, let's take a 5-minute break, folks. Let's return at 9:59. All right. Good morning. We are back on the record in docket 221-000-282, the Lowry CAP. And at this time, we will move forward with the next piece of our agenda, and that is the termination of preliminary substantive and procedural matters. We've got a argument from Crestone concerning whether Starr is an affected person. We've got Ms. Jost available. As I mentioned earlier, the pre-hearing order identifies 20 minutes of argument on this. Ms. Jost, as a seasoned lawyer, I'm sure you can get through your argument in less than 20 minutes. Would note that that does count toward your overall 6 hours of time. Would note for the record for all of us that Mr. Peskin, as our hearing manager, will be the timekeeper for the lawyers. If you ever want to get a sense of what time is left, just ask me and I'll make sure Mr. Peskin provides us with that. Would want to make sure that Mr. Foote is listening into the argument because he's got 15 minutes for response to the argument concerning affected party status. So with that, Ms. Jost, you are recognized.
Wonderful. Thank you so much, Chair. And we have just one PowerPoint slide to pull up for the beginning of my argument, if we can. Thank you so much, Kelsey. Wonderful. Well, good morning, Chair, Commissioners, Council, and members of the public. My name is Jamie Jost. I'm the managing shareholder of Jost Energy Law, and I, along with my partner, Kelsey Wieselinki, represent Crestone Peak Resources Operating LLC on this Rule 314 Lowry Ranch CAP Comprehensive Area Plan application today. Crestone's first preliminary matter to be addressed is Starr's lack of standing to participate in this hearing as an affected person under Commission Rule 507. By way of background, Crestone was prepared to submit a motion to dismiss Starr's petition soon after it was filed on May 23rd. For the reasons you'll hear this morning, however, Crestone, Starr, and Maverick were informed by the hearing officer on June 6th that there will be no dispositive motions authorized. Pursuant to Rule 503H1, applications for comprehensive area plans must be heard by the Commission, and Commission practice has been that in such matters, only the Commission retains authority to deny petitions and dismiss parties. This was in a June 6, 2024 email to all council. Due to this prohibition on pre-hearing motions regarding standing, the ECMC hearing officer, Crestone, and Starr have been forced to prepare for hearing as if Starr is a party to this docket. This preparation should not deter the Commission from ultimately applying its rules and applicable Colorado law to rightly find that Starr is not an affected person and that its petition should be denied or summarily dismissed. Crestone has 5 primary reasons for requesting that this Commission deny or summarily dismiss Starr's petition for affected person status under Rule 507. The first point is from the outset, STAR's petition failed to meet Rule 507 F2, 3, and 5 requirements. STAR expressly stated in its petition that STAR has been diligent in reviewing the Lowry Ranch CAP application, which is extensive. However, STAR has not decided upon the points it intends to focus on in its pre-hearing statement and presentation to the commissioners. Witnesses could include any of the individual STAR members who've petitioned for affected party status, which none provided such petition, other community members, and individuals who have expertise in relevant subject matter areas. STAR's pre-hearing statement finally disclosed its issues of concern. However, such disclosure was almost 30 days late in violation of the rule. STAR's petition was filed by counsel, not an individual citizen, where this commission generally grants more leeway. STAR's failure to comply with Rule 507 F2, 3, and 5 at the outset of filing its petition should be considered by this commission, and its petition should be summarily dismissed on that basis alone. The second point is that STAR's pre-hearing statement confirmed that it did not satisfy Rule 507 A3 affected person status. STAR has taken the position that it will be automatically granted affected person status in the Lowry Ranch CAP proceeding without being required to prove such status under Rule 507 A3. After failing to provide any information to support its claim for affected person status in the petition or pre-hearing statement, STAR then provided the same laundry list of individuals that STAR included in its petition and attempted to claim that each one will be uniquely affected by the Lowry Ranch CAP application if approved. However, repeating this list does not change the fact that a list of concerns does not equal standing. This is especially true, as shown on this slide, when none of the listed individual STAR members are within 2,000 feet of a working pad surface of the conceptual oil and gas locations in the CAP. And in fact, none of the listed STAR individual members are even within 3,000 feet of the working pad surface of the conceptual oil and gas locations in the CAP, again, as shown on this slide. STAR merely cited Rule 507A3 in its petition and subsequent filings, but made zero attempt to provide any legal analysis in an attempt to prove that STAR meets the requirements of an affected person under the Commission's rules. STAR only attempts to claim that several STAR members' concerns automatically make them negatively impacted by the Lowry Ranch CAP project. This is not acceptable support to prove standing. Kelsey, we can drop the slide. Thank you so much. Rule 507A3 mandates that for all persons other than those listed in Rules 507A1 and 2, the person's petition will, 1, identify an interest in the activity that's adversely affected by the proposed activity, allege such an interest could be an injury in fact if the application is granted, and 3, demonstrates that the injury alleged is not common to members of the general public. STAR did not provide one example of how STAR or its members meet any of the 3 criteria in Rule 507A3 in its petition. The reason being is because STAR knew and still knows that it cannot meet all 3 requirements, and it's hoping this commission will be lenient with its rules and Colorado law and let STAR participate. This is an unprecedented legal maneuver by an activist group and one that is not supported by ECMC rules or Colorado state law. This is because none of the STAR members named in STAR's petition or responsive pre-hearing statement have an interest in the Lowry Ranch CAP area, as they were not notice parties under Rule 314 F1, the ECM rule governing the proposed activity, which is the request for approval of the Lowry Ranch CAP application. Secondly, STAR did not allege that STAR's members' interests will suffer an injury in fact, and there's no legal interest to be protected of those STAR members under Colorado law. STAR merely cited Colorado's standing case with no legal analysis or application of such case to STAR's claims. And most importantly, STAR cannot demonstrate that the alleged impact is not common to members of the general public. STAR's entire position is based on Creststone's oil and gas operations' purported impacts to members of the public, meaning birders, hunters, cyclists, dog walkers, as stated by Mr. Foote in yesterday's media article. This is a broad assertion that would be common to the general public, as evidenced by STAR's own public statements and ECMC filings. Additionally, while STAR references Rule 507A4, It does not provide a singular example or legal position to this commission or even consider the factors specified in the rule. Specifically, STAR did not provide any analysis on whether the interest claims are ones protected or adversely affected by the application, meaning a current claim and an actual claim, whether a reasonable relationship exists between the interest claims and the activity regulated, the likely impacts and magnitude of impacts of the regulated activity on the health, safety, welfare, or use of the property of the person, or finally, the likely impacts of the regulated activity on the impacted natural resources or wildlife used or enjoyed by the person. The commission cannot now, on its own volition, conduct such an analysis in an attempt to find a way to give STAR affected person status when STAR failed to comply with Rule 507A3 and conduct this analysis itself. The third point is that no individual STAR member has petitioned this commission for individual party status, nor did the named STAR members and witnesses have a right to receive notice of the Lowry Ranch CAP application pursuant to Rule 314F1. While STAR petitioned as an association, it failed to provide any legal analysis on how STAR has standing to receive affected person status in this proceeding. Under Colorado case law, associational standing is only granted when its members would otherwise have standing to sue in their own right, which they do not. The interest it seeks to protect are germane to the organization's purpose, and neither the claim asserted nor the relief requested requires the participation of individual members of the lawsuit. STAR immediately fails the first criteria for associational standing because its named members do not have a right to petition the Lowry Ranch CAP under Rule 314F1 because they are surface owners and they are well outside 3,000 feet of any working pad surface of a conceptual oil and gas location within the Lowry Ranch CAP. Since STAR cannot meet the first of the three required criteria established by Colorado Supreme Court, no further analysis is necessary. STAR does not have associational standing in this matter. The fourth point, STAR, as an activist organization that touts, quote, it was formed in 2022 in response to the Lowry Ranch Comprehensive Area Plan, a proposed hydraulic fracturing project encompassing the Aurora Reservoir and surrounding land, has used every opportunity to delay the original Lowry Ranch CAP hearing of June 26, and such tactics have resulted in prejudice against Crestone and an abusive process without recourse by this commission. For example, STAR filed its non-compliant petition on May 23rd seeking a denial or alternatively a stay of the Lowry Ranch CAP application until later this fall after cumulative impacts rulemaking was concluded. Once the petition was filed, STAR refused to make itself available for the pre-hearing conference mandated by the Lowry Ranch CAP notice of hearing, therefore resulting in an email chain regarding pre-hearing matters about this critically important application. Then, STAR failed to meet the first pre-hearing statement and exhibit filing date and asked for a last-minute extension of an additional 3 days for more time to prepare, which was granted. STAR then joined in Maverick's motion to consideration of the second scheduled hearing date of July 18th and 19th, which was granted and moved to July 30th. And finally, STAR and its members completely ignored Rule 512C, which prohibited STAR members from providing comment at the July 15th public comment portion of this Lowry Ranch CAP application hearing, as many STAR members did attend and provide comment to this commission. Crestone, on the other hand, has complied with every aspect of Rule 314 and 504, has complied with every date and filing requirement set forth in the original case management order, the amended case management order, and the final pre-hearing conference order, yet little consideration has been given to Crestone's due process in the pre-hearing filing or scheduling matters. This commission has provided extensive amounts of flexibility and grace to STAR and its counsel. However, the time has come where such flexibility and allowing STAR to ignore procedural rules of process, ECM rules, and Colorado law regarding standing must end. This fifth and final point is a bit delicate, but it must be made to preserve the record. Standing is not discretionary. Either STAR has it or it does not. As already positioned, it does not. The commission needs to look at STAR's attempts to gain affected person status for what it is: a facade and a hope that this commission will do the work on its own to find standing that STAR otherwise failed to do. There is no factor supporting law under which this commission can rely upon to find STAR to be an affected person on its own volition. The burden is STAR's and STAR's alone, and it has failed to meet its burden of proof to provide that it is an affected person. Despite their activism, the number of STAR members, 330, represent a very small minority compared to the 5,940 interested parties rightly receiving notice of the Lowry CAP application. You may think that because STAR was formed in 2022 to directly oppose the Lowry Ranch CAP application, and because its members have participated in the Lowry Ranch CAP application process via letters to the commission, meetings with the commission staff and the director, attended and spoke at Crestone's Arapahoe County Open House, attended and spoke at Crestone's Rule 314F informational meeting, attended and spoke at the ECMC Rule 511 local public hearing, provided public comment at the July 15th public comment hearing, and have participated in Arapahoe County oil and gas regulation amendments, that this would give them standing. It doesn't. STAR's involvement with the CAP is absolutely commendable, and Crestone recognizes that STAR has played a significant role in influencing Arapahoe County's amendment of oil and gas regulations to require larger setbacks from current and proposed reservoirs. In fact, as you will hear later, the Lowry Ranch CAP has evolved because of STAR's involvement. Citizen groups are a healthy and anticipated part of the development of a CAP, and Crestone acknowledges the time, effort, and work that STAR and its members have put into their cause. This effort, however, does not automatically mean that STAR meets the standing requirements under Colorado law or Rule 507A3 or 507A4. Based on STAR's filings and lack of legal analysis, Crestone believes that STAR will be looking heavily to this commission to help make STAR's request for affected person status become a reality, because STAR itself knew that it could not meet the requisite criteria. Crestone requests that this commission resist the urge to conduct STAR's work for it and find that it does not have standing as an affected person for purposes of this CAP hearing. To conclude, STAR failed to provide any form of legal support for its purported standing, and even if it would have attempted to make such an argument, it would fail. Rule 507A3 is a mandatory rule that applies to all petitioners attempting to gain party status. STAR cannot be allowed an exception to this rule, as that would fundamentally undermine the purpose of standing and would undermine the ECMC rules. It is not this commission's role to grant affected person status to an association who did not comply with the rules, nor is it this commission's role to create a new category of affected person standing simply because STAR has been commenting on the Lowry Ranch CAP application for over a year. Based on the foregoing, STAR's petition for affected person status should be denied or summarily dismissed. And then Crestone would like to offer up that if the commission feels it necessary to hear from STAR as a form of public comment today, Crestone would not object to STAR providing 20 minutes of public comment prior to Crestone's opening and direct presentation. Thank you.
Okay, thank you, Ms. Jost, for the argument. We now will hear from Mr. Foote.
Yes, thank you, Mr. Chair and members of the commission. Well, it seems as though Crestone must be reading a different petition than what STAR submitted, because they missed or misstated an awful lot of the petition in their argument this morning. The commission has been clear, as it's stated in its 200 to 600 mission change statement of basis and purpose, that it quotes, intends to consider persons directly impacted by an oil and gas operation as an affected person. And that's page 191 of the SBP. STAR and its members are directly impacted by the proposed oil and gas operation, as opposed to the interests being held in common with other members of the public. Those who are directly impacted are not limited to those that can receive notice, as Crestone continues to claim without any kind of support in law or the rules. The STAR petition is far from the person or represents persons who are generally concerned about the impacts of oil and gas operations on climate change in a different county. It's far from the person who is concerned about air quality but lives elsewhere in the non-attainment area. It's far from the person who is generally concerned about wildlife impacts of oil and gas operations, but lives in Colorado Springs. I actually do like the Crestone exhibit GGG that was put up at the beginning of their argument, which visually shows where 11 of the 12 of the STAR members who are part of the affected person petition live. They all live in the densely populated area that will be directly impacted by this cap. It clearly shows they all have a unique interest because they all live and recreate in an area that will be adversely impacted by the oil and gas operations if this cap is approved. The 12 individuals in the affected person petition are members of STAR who live and recreate near the proposed cap or inside the proposed cap. They believe, and the ECMC rules clearly support, that they should be heard as affected persons because they are directly impacted, as the rules say, and have at least as much at stake in this application as Crestone does. The Commission has always recognized that impacts of oil and gas operations occur beyond a 2,000-foot radius. That's the whole point of having a category like Rule 507A3 available. If the Commission meant to limit the affected person status to just governments or residents within the 2,000 feet of a location, or even those that would statutorily or by rule receive notice, it certainly could have done so and not enacted 507A3 at all. But the Commission did enact 507A3 because you all recognize there's a lot of people who will be directly impacted by oil and gas operations other than those that live within 2,000 feet or those who are required by the rules to receive notice. So Crestone has argued that STAR has not shown associational standing because STAR members wouldn't be able to sue in their own right. And to support that argument, they cite the Colorado Union of Taxpayers case. The relevant case previously cited by the Commission and also by STAR in its petition is the Buffalo Park development case. And looking at that case, as well as the taxpayers case, it's clear that STAR has established all three elements of associational or representative standing through its affected person petition. First, each individual member of STAR named at the petition would be able to gain affected person party status in their own right. They have shown potential injury, which is what is required under this element. And I think it's important to spend a little time briefly restating the information from our filings because it doesn't really seem that Crestone has paid much attention to that in their argument at least. And this information supports the first element because it shows each and every one of the STAR members mentioned in the petition could enter in as an affected person in his or her own right. So starting with Justin and Lori Christensen, they live less than a mile from two proposed locations within the cap boundary. Their children attend school within the cap boundary, and their family often recreates in and around the Aurora Reservoir, which is in the cap boundary. Which, by the way, the Aurora Reservoir will be impacted, greatly impacted, by at least 3 separate sites to the northeast, east, and the southeast of the reservoir. Tisha Fjord, lives and works within the cap buffer area, and her son attends school within the cap boundary. She and her family frequently recreate at the Aurora Reservoir, as detailed further in the petition. Stephanie Garrett lives and works within the cap boundary, and her children attend school within the cap boundary. She and her family also frequently recreate at the Aurora Reservoir within the cap boundary. Wendy Hanafy frequently hikes, bikes, and bird watches around the Aurora Reservoir and suffers from asthma, which could be exacerbated and would be an injury if exacerbated by the poor air quality around the proposed oil and gas locations. Robert Kahn is a mineral owner within the cap boundary who is likely to get force pooled if this cap is approved. He also frequently recreates around the Aurora Reservoir. Jason and Shannon Rendells live approximately 3,500 feet from one of the proposed locations in this cap, and they frequently recreate in and around the Aurora Reservoir. Their son has been diagnosed with reactive airway disease, which could be exacerbated and would be an injury by the poor air quality around the proposed oil and gas locations. Debbie Rubin lives within the cap boundary and also frequently recreates in and around the Aurora Reservoir. The same goes for Janet Snell Bergian. She probably uses the reservoir and surrounding areas 175 to 200 times per year, which includes cycling on the roads around the reservoir that would be directly impacted by the increased truck traffic. And finally, Sean and Lisa Vincent live within the cap boundary and recreate frequently around the Aurora Reservoir, just like all of the other petitioners. So the second and third elements of the representational standing would be satisfied here too, and I'll briefly go into them just so the record is clear on those. The second element is whether the interest of the members of the organization and the organization itself align. In other words, does the organization advocate for the same result as the individual who would be part of the organizational standing? In this case, that's abundantly clear because STAR came into being as a result of proposed oil and gas development in and around its members' community. STAR's interest is to protect the community from oil and gas impacts, just as the same as its individual members seek to do. The third element is whether individual members are required to participate as opposed to a group being allowed to participate on a member's behalf. There's nothing in the ECMC rules that require only individuals to participate as affected persons. In fact, it's often groups of people who participate as affected persons, although not all the time. So that element would be met. And I want to emphasize that while all of the 12 STAR members named in the affected person party petition would be granted affected person status on their own, had they petitioned as individual affected persons, the commission needs only to find one of those 12 meets that qualification for STAR's petition to be granted. Now, regarding organizational standing, in other words, can a community group like STAR represent its members in a proceeding such as this one? Case law is clear that a membership organization such as STAR may assert an injury that its members could individually assert and be granted standing. The Buffalo Park case is on point for that. Also, another one I'll cite is the National Wildlife Federation v. Cotter, and that's 665 P. 2nd 598. It's worth mentioning that granting the affected person petition in this case would be consistent with previous ECMC precedent, and not granting it would be inconsistent with that precedent. For example, a similar petition related to unique interests under 507A3 was granted in docket number 2309-00291 related to a public hearing request for a UCI aquifer exemption, and docket number 2210000275, which was an OGDP application on the Western Slope. I'm not aware of a similar petition being denied by ECMC, and Crestone has not cited one in any of their filings or their argument today. Finally, on point, granting STAR, I should say on this point, granting STAR affected person status representing 12 members of the organization is in the interest of efficiency for this commission. As we have already established, the 12 members of STAR in the petition could have asked and received affected person status on their own. That would have meant 11 more affected parties than are currently represented in a much longer and likely duplicative hearing. I doubt that would be a result for the commission that the commission would be looking for, and it makes sense to consolidate parties to provide for a more orderly hearing in this case. So I want to talk a little bit about 507A4 as well. When determining whether a petitioner is an affected person under Rule 507A3, 507A4 requires the commission to consider all relevant factors, including but not limited to whether the interest claimed is one protected or adversely affected by the application. In this case, all but one of the petitioners live in close proximity to at least one of the proposed oil and gas locations. All but two live within the cap boundary. Several of the petitioners work within the cap boundary. Several of the petitioners have children that attend schools within the cap boundary. One of the petitioners is a non-consenting mineral rights owner and likely to get forced pooled if this cap is approved. All of the petitioners indicate they frequently recreate in the area in and around the Aurora Reservoir, which is in the cap boundary, and will be directly affected by at least 3 proposed locations in this cap. These areas will be adversely impacted by, among other things, emissions, noise, traffic, and visual impacts. The commission should also consider whether a reasonable relationship exists between the interest claimed and the activity regulated. That's 507A4B. There is a reasonable relationship here between the interest claimed and the cap, namely that the petitioners live, work, and recreate within the area that's going to be directly impacted by operations within the cap. C, likely impacts and magnitude of impacts on the regulated activity on health, safety, welfare, the use of property of the person. The likely impacts on the petitioners are clear here. For those closest, like within 3,000 or 3,500 feet of one of the locations, the cap will have large impacts on their home. For everyone that uses the reservoir, there's going to be large impacts given that at least 3 of the proposed locations will directly impact the reservoir and all of the people that use it. The commission should consider likely impacts of the regulatory activity on the impacted natural resources or wildlife used and enjoyed by the person. This was an area that was extensively briefed in the petition. The impacts on wildlife will be significant, and the impacts in the area around the reservoir will also be significant. We know there will be significant emissions over the lifetime of these projects. We know there will be noise impacts. We know there will be nuisance impacts. We know there will be significant traffic impacts. All of those things have been admitted to by Crestone, and all those things will change the wildlife habitat and change the way people use the Aurora Reservoir. Finally, what I'll mention in response to one of the arguments here is about the sufficiency of the affected person petition. So the affected first person petition was filed on time under the rules, which was approximately 30 days before the initial hearing was set. And it said, and it stated, according to Rule 507 F2, that all petitions must include a general statement of the factual or legal basis for the petition based on the application. There's nothing in the rules that say that you have to even decide upon or advocate for what your positions are ahead of time. It's a general statement of the factual or legal basis for the petition based on this application. And frankly, even if we could, or even if we wanted to, we couldn't in this case, because as you've seen, this application has evolved over the course of time, particularly over the last couple of months. The amount of information that's been disclosed over the last couple of months has been extensive. It's been hundreds of pages of discovery that Crestone has disclosed to STAR. It's been 67 new exhibits that have been disclosed as part of Crestone's pre-hearing and response statements. So even if STAR wanted to state with specificity, which it's not required to under the rule, it really could not or be in a position to have to change its position because of all the new information. So again, I'll just emphasize, this information has been made clear through the petition, through general statements of the factual or legal basis for the petition based on the application. And based on the information that was disclosed in the petition, we asked the commission to approve the affected party status because STAR members are directly impacted by this CAP application.
Thank you, Mr. Foote. Ms. Jost, you're recognized for any rebuttal.
Thank you, Chair. Just a brief rebuttal. Mr. Foote's attempts to position STAR as an affected person continue to fail, and no part of his argument today should be relied upon to change STAR's failure to prove an injury in fact to a legally protected interest under the Colorado standing regulations and case law. STAR failed to comply or even provide legal analysis in its petition with Rule 507A3 and 4, and the mere citation to the rules in the petition does not automatically result in standing. Colorado law is clear on standing under the Colorado Supreme Court case of Wimberly v. Ettenberg and Ainscough v. Owens. STAR must satisfy as an association the two-pronged test for standing as well as the three-pronged test for associational standing that both Mr. Foote and I mentioned. First, STAR as an association must show an injury in fact, an actual injury in fact to its members. And secondly, STAR must show that the alleged injury is a legally protected interest. STAR can show neither, and the argument this morning proved that neither of those two factors exist. The injury in fact under Colorado law must be real, actual, or an immediate danger. It cannot be indirect, incidental, or speculative. STAR's claims fall in the latter category, indirect, incidental, and speculative. Nothing has been approved by this commission, and nothing has been drilled or developed by Crestone because there are no approvals at this point. STAR's position, even after hearing it this morning, is better suited for the OGDP and drilling and spacing unit application phase of CAP development, not this morning at the Lowry Ranch CAP application hearing. The injury complained of are effects to dog walkers, bird hunters, hikers, cyclists. These are not injuries in fact to a legally protected requirement by statute or constitutional provision. STAR did not cite a statute or constitutional provision that provides a legally protected interest to its members because there is not one. Each of its members listed in the petition and the responsive pre-hearing statement and relied upon today by Mr. Foote, they're not interested parties under Rule 314F, and they are not within 3,000 feet of the conceptual oil and gas locations. And what they are general members of the public. Everything argued today results to the same application of alleged impacts to the general public. These are not unique interests. Further, under Commission Rule 507A3, STAR also must demonstrate that the injury alleged is not common to members of the general public, as I just noted. So really, to conclude, STAR has not satisfied its claims for standing under Colorado case law, under Wimberly or Ainscough. It has not satisfied its requirements for associational standing under Colorado law. It has not met its requirements under Rule 507A3, and the Commission should deny STAR's petition for affected person status. Again, Crestone reiterates that it would welcome a public comment portion from STAR prior to its opening, but the affected person status request should be denied. Thank you, Chair.
Thank you, Ms. Jost. Commissioners, we have before us this motion or this matter concerning affected party status for STAR. Some preliminary comments from me as chair. One, I would like us to adjust how we address these sorts of things so that the parties are not in the situation where they're making a determination of whether someone is going to have standing or not at the day of the hearing. I think this is somewhat unique, but if this issue arises again, I would request that our hearings officer bring this to the attention of the commission well before the actual date of the substantive hearing, so that everyone, whether they're the potential affected party or the applicant, is aware of what needs to happen. I apologize to all the parties ahead of time that you had to basically get ready for hearing with the idea that potentially everybody's going to be an affected party because you had to. So we will adjust procedurally how this happens in the future, and that's my direction. I assume folks are probably comfortable with that. It just makes litigation sense in terms of coming before us. Having said that, I appreciate the perspective that we've heard from Crestone. However, I believe that standing, generally speaking, courts look at standing from more of a perspective of allowing standing, provided that there are allegations that meet the three factors, allegations of that there's going to be potential adverse impacts, allegations of injury in fact, and that the allegations are particular to particular people. While I don't know that those so I find that the members of STAR have satisfied those issues from an allegation perspective. My perspective is that whether that's proved up or not is to be determined. But I would be of the opinion that STAR should be allowed to be considered an organization that has affected persons based upon the allegations of the pleadings. I am not excited. I'm not quite sure that the piece that I have the most concern is that the allegations are particularized and they're not members of the general public. But in a situation in which I think we should look to this and be conservative in our approach, I would allow STAR to be an affected party organizational status. Those are my initial deliberations. Others with deliberations on this point? Commissioner Cross?
Thank you, Mr. Chair. And if possible, I'd like to try and ask a couple questions of counsel to try and get a better understanding of some of the allegations made and the arguments presented.
Do you want counsel Foote or counsel Jost?
I have some questions for both, but
Mr. Foote, if you could.
Might be easiest to start with Mr. Foote.
Okay.
And Mr. Foote, is to make sure that I understand, as we talk about the injury in fact and the affected interest, is one of the arguments you're trying to make that the recreating in and around Aurora Reservoir an affected interest?
Yes, that will be negatively impacted if this cap is approved.
So would we then be able to grant standing to anyone that recreates in and around Aurora Reservoir?
I don't know if I would go that far. In this case, that's not the question that's before you. The question before you are those that live and recreate near the reservoir on a very frequent basis. And I think the answer to that question should be yes. If they're recreating an area on a frequent basis, then they should be granted affected person party status, just as the example that's given in the statement of basis and purpose talks about. It says if there's a hunter that frequently hunts in an area, or a mountain biker that frequently bikes in an area, or something to that effect. I don't have it in front of me, so I can't quote it, but the SBP talks about, I think it really distinguishes between someone that just goes there once or twice and somebody that goes there frequently, or it's part of their normal routine. And the STAR members clearly match the latter of the category.
And with respect to the frequency that you talked about there, you also mentioned living nearby. And so I'm curious as to how you think we should adjudicate the issue of what you called a densely populated area around the Aurora Reservoir, but yet this not applying to the general public. How do you make that distinguishing assessment to say there's a lot of people that live over here or live near here? How do you say, but they have to live within 1 mile, they live within 2 miles, they live nearby? It's not unique because it's just the people that live here, but at the same time saying it's densely populated. So I'm kind of curious how you make that assessment of this is not the everyday person that might go there once, they're frequently there because they live there, but this is also not the general public, even though it's densely populated.
Well, it's a good question. I can see why you're thinking that, because of course you're thinking along the lines of, well, what does this mean for the future, kind of precedent that's set for the future. But I would submit that the affected person party status determination should be made on a case-by-case basis. And in this case, let me back up. If one or all, I guess I should say, if all of the folks that from STAR are petitioning to be part of this affected person party status were folks that just lived in the community and there's no other distinguishing factor, then I could see how that question would be determinative. But that's not the case here. There's folks that live in the area and they also recreate in the area. Many of them have children that go to schools in the area. Many of them work in the area. So based on that, I would say, I guess if you are in fact concerned about establishing a precedent, I'm not sure that I don't think it would establish a precedent of somebody that just happens to live in the area or in the neighborhood could be granted affected person status, because that's not what's presented to you all as part of this petition. And that's just, I don't think would be an issue that you would have to decide on to grant the affected person party status here today.
And I guess my question with that partially goes into what you said there as well. You said it's not just that they live there, it's that they live and recreate, or they live and recreate and have kids that go to school. But if this is truly a densely populated area, like you said, isn't that the case with a lot of these people? I mean, one of the things that jumped out to me is, especially as you look at just your response, just going back and highlighting the different statements of interest that you mentioned, you specifically talk about the ability to live and recreate in and around the reservoir will be affected. And for the vast majority of those that you cited, it was a copy and paste of the same information other than the names. And so I'm just curious as to how that's unique if it's still a densely populated area and it's the same thing for each of these people.
Well, it's unique to each of these people because I presume that there's a lot of folks within the state of Colorado, even within Arapahoe County, that don't recreate at the Aurora Reservoir. And if they do, they certainly don't recreate to the same frequency as the folks that are named in this affected person petition. And so I can speak for myself. I hardly ever go to the Aurora Reservoir, but I don't live there either. So we're talking about folks that live there, and one in particular that I mentioned in my argument, she recreates around the Aurora Reservoir something like 175 times a year. So basically every other day. And I think that fits squarely under what would be a unique interest for her. just like in the statement of basis and purpose, where it says if someone frequently hunts in an area or someone frequently mountain bikes an area, they could be considered an affected person. This is it's modeled after the statement of basis and purpose and what the commission decided after the mission change rules. And certainly there's nobody that I think would fit under a unique category of someone that lives, say, in Boulder County or Larimer County that just happens to visit the area every once in a while. That's not even close to what's been submitted here. And as to your first part of the question about other people in the area and whether or not they should be part of the petition or something along those lines, I can tell you there's plenty of folks in the area that would be happy to be part of this petition, but we submitted a dozen in this case. And those are the dozen and we laid out facts and circumstances that would allow them to be uniquely oriented to be affected persons. And again, going back to the mission change rulemaking, I think what the commission was very concerned about would be somebody that's concerned about climate impacts that lives in Denver, or someone that's concerned about the ozone non-attainment that lives in Larimer County. The commission went to great pains to make sure that those types of folks were not going to be affected persons. But there's also people that would be directly impacted, and it says directly impacted by an oil and gas operation. They could be affected persons. And in this case, we've made the case that all of the folks that are in the affected person petition would be directly impacted by this oil and gas operation, either through where they live, where they recreate, where their kids go to school, where they work, or some combination thereof.
And I have two more questions for you, Mr. Foote, and then one for Ms. Jost. The first question is going back to what Ms. Jost was talking about in her rebuttal, and that's with respect to the injury in fact. What is the injury in fact that is being asserted here? And how can you say that it's not a speculative injury in fact? What is making it that it needs to be decided at this CAP application where no drilling is being authorized as compared to an OGDP?
Well, in several instances, not all, but several of the individuals that are in the affected person petition, it names, in one case in particular, respiratory illnesses that certainly could be exacerbated by increased emissions. I don't think it's speculative that there will be increased emissions as a result of this. It's also not speculative that increased emissions from oil and gas operations can cause and do cause negative respiratory issues, particularly those with pre-existing conditions. And so that in and of itself, with I think 2 or 3 individuals, maybe more, if I remember correctly, would not be speculative. And the case law under Wimberley, et cetera, is clear. It's not something that has to be proven. It's something between being completely speculative and something that's proven. In this case, the emissions issue I already indicated, but there's also many other impacts of oil and gas operations, noise impacts that would negatively affect folks that are recreating at the Aurora Reservoir, traffic impacts that would negatively affect people that are running or cycling on the roads around the Aurora Reservoir. Those are not speculative because Crestone has indicated there will be noise impacts. There will be truck impacts. There'll be extensive truck traffic impacts in the roads around the Aurora Reservoir. There's plenty of folks that ride their bikes and run and otherwise walk around that area that's going to be directly impacted by this cap. And that's even with BMPs and other mitigation measures. There's just no debate that there's going to be a large amount of increased truck traffic. There's no debate there's going to be an increase in noise. There's no debate there's going to be visual impacts or emissions impacts. So that's not speculative at all. How it impacts the individual, we can't say because we can't tell the future, but it's certainly enough to get to standing. I think as Chair Robbins indicated before, there's a difference between establishing standing so that the issue can be argued and whether or not it's proven to the decision maker. We're at the standing phase, and standing is generally liberally applied by the case law. And so I would submit this isn't merely speculative, but it's not proven because we haven't gotten there yet in this proceeding.
And I'll kind of mix a response question to that with my final question for you. What makes this the appropriate venue, the CAP hearing, to talk about those impacts, particularly when one of the pads is described as the one that's going to be the most impactful, as opposed to the OGDP phase of this. And relatedly, will STAR be participating or seek to participate in the OGDPs as well? And if so, which?
So to answer your second question first, I can't tell you standing here, whether or not STAR will participate. I mean, they participated in many other proceedings, including county proceedings and ECMC proceedings. So I think it's a fair assumption, but I could not, stand here and guarantee that to you. Certainly there's a lot of folks that are very concerned about this and would be participating whenever they have the opportunity. To answer your first question about why the cap instead of the OGDP, it's because the very reason why Crestone is seeking a cap is because of the benefits the cap conveys. One of those benefits is that it really does expedite the OGDP process. It smooths, it greases the skids, I guess. It smooths the way for the OGDPs to be approved. That's part of the reason why the operator would seek a cap as opposed to doing 8 or 9 separate OGDPs. Once the cap is approved, it's very likely the OGDPs are going to be approved. And so, and I suspect if the roles were reversed and STAR was participating for the first time in the OGDP, the question would be, well, where were you when the cap was debated? And so STAR thinks it's appropriate to participate at every phase and to express concerns and talk about protections at every phase, because every phase is substantive. Every phase can be determinative. It's the cap is not meaningless. That's why Crestone is going after the cap. The cap means something. It provides value, and it's something that STAR should be participating in order to make its concerns heard.
Perfect. Thank you for that. And Ms. Jost, my question for you is with respect to, and let me make sure I get the name correctly here. I believe it was Mr. Kahn. Yes, Mr. Robert Kahn. One of the issues identified as an injury in fact there is that he is a mineral owner as well. And what are your thoughts on Mr. Kahn's position as a mineral owner and that being an injury in fact?
Great, thank you for that question. We don't think that that position actually provides any support for STAR's argument because one, Mr. Kahn did not object to the petition on his own individual basis. But secondarily, Mr. Kahn will also have the opportunity to participate in an OGDP as well as a DSU application hearing that's further down the line. There's no ability for Mr. Foote right now to say that it's a non-consenting mineral interest owner when we haven't even hit a pooling application stage. So frankly, we think it's irrelevant. There is no actual injury. Commissioner Cross, I guess to your point that you were asking Mr. Foote is that, aren't these listed individuals still general members of the public and their alleged injuries are those that general members of the public would incur? And the answer is yes. The injuries put forth, there's 330 members of STAR. They reside in the Aurora Reservoir area, but they're made up of general members of the public. Everything that was stated could be affected by general members of the public that frequently, go to the Aurora Reservoir. I could live in Fort Collins and frequent the Aurora Reservoir every weekend. And then under this claim, that would give me affected person status. I don't think that's necessarily the intent of Rule 314. That's not the intent of Rule 507A3. And at the end of the day, there's a lot of information that's been provided, but to have this commission relax its rules on standing versus only relaxing its rules on evidence as allowed would undermine the commission's rules and would result in a violation of Colorado law. So I'll leave it there, but we don't think that Mr. Kahn provides any standing for purposes of this argument today.
Okay, thank you. And Mr. Chair, that's the only questions I have for council. I'm happy to hear from other commissioners before providing my deliberative thoughts.
I think I saw Commissioner Messner with a hand up.
Yeah, thank you, Mr. Chair. I'll just be brief here and share my thoughts. I do think the applicant has met their burden of proof. I think first, the distances associated with 507A2, the 2,000-foot distance is not applicable here, as that only applies to OGDP situations. So the prescriptive distance consideration is not something that I considered. I do think that they've determined a unique interest, and I think that unique interest is that the vast majority of individuals included in the petition lie within the cap boundary that has no preliminary siting for the sites closest to these petitioners. And so where those actual sites will be is amorphous at this point. And so I think the uniqueness is that these individuals actually lie within the cap boundaries, and I think that's an important consideration. And I think they've clearly shown direct potential impacts, including possible medical conditions, wildlife viewing impacts, water quality potential impacts, recreation and scenic value potential impacts, which are all considerations in ECMC rules and are legally protected. And so I would support approving the petition and including them as affected persons.
Thank you, Commissioner Messner. And just to sort of reiterate, I agree that the recreate and live nearby, sort of the duality of those two things, is an important consideration. I would disagree that not having both would somehow, grant standing to somebody that lives in Fort Collins who comes to the lake once a week. I would not agree with that. So with that, other deliberative thoughts from commissioners? Commissioner Ackerman?
Thanks, Mr. Chair. I don't have any questions, but I generally agree. I am worried about a vague precedent being set to granting affected party status based on what I would consider to be a pretty significantly inclusive interpretation of rule number 507. But I would note that STAR is a formally organized group whose individual members have made significant assertions of interest in the activity that is purported to be adversely affected by the proposed activity. They've also made various allegations that such interest, as a group, that such interest could be an injury in fact if the application is granted. So it comes down to me to rule 507A3C, as we boiled it down to, whether the injury alleged is not common to members of the general public. And I think that boils down to the interpretation of general public. If general public is understood to be the general public around the reservoir, I would determine that the standard is probably not met. But if the general public is understood to be the general public of Denver or of the state or of the nation, I would determine that the standard is probably met by an organized group that lives and recreates within the cap boundaries. Further in rule number 507A4, it requires us to consider all relevant factors in examining this issue, including if the interest claimed is one protected or adversely affected by the application, which is one of the primary assertions of STAR, whether a reasonable relationship exists between the interest claimed and the activity regulated, which is another primary assertion of STAR, likely impacts and magnitude of impacts of the related activity on the health, safety, welfare, or use of the property of the person, also asserted and likely to be a significant topic of this hearing, and likely impacts of the regulated activity on the affected natural resources or wildlife used or enjoyed by the person, which is also asserted and likely to be a significant topic of this hearing. So to me, the totality of these circumstances, together with the formal organization of STAR into a group with the sole purpose of specifically being affected by this action, along with, as Mr. Chair stated, the judiciary's general leaning toward inclusion, leads me to lean towards supporting affected party status for STAR for the purposes of this cap hearing specifically. Reiterating the chair's comment that this is, in my opinion, a relatively unique situation. And I do expect to hear future applications for party status on their own merits, as opposed to their juxtaposition to this situation. Those are my thoughts, Mr. Chair.
Appreciate that, Commissioner Ackerman. Commissioner Cross?
Thank you, Mr. Chair. I think I'll start with ultimately how I feel and then provide a little input on it. And I'll say that I do believe that STAR should be considered an affected person in this and should be a part of the hearing. Part of the reason I wanted to ask some of the questions, particularly of Mr. Foote, is because I do think that this is a unique situation. And Chair, I do concur with what you said on the fact that it's unfortunate that this argument had to occur at the beginning of the hearing and did not occur ahead of time. And I agree that this is something that should be handled ahead of time in the future, even if it has to come before the commission to determine if it should be a party to a petition and then have the hearing at another time. I just want to make sure that not only the parties here, but others listening in understand that it's not simply starting a group that can make you get standing under the law. It's not simply saying, oh, well, we use this sometimes, that can make you have standing in a situation like this. I think part of my concerns, as Commissioner Ackerman just alluded to, is, what is the general public? Are we talking about the people of Colorado? Are we talking about the people of the Eastern Plains? Are we talking about the non-attainment area? Are we talking about the people just that live nearby there? And I do have some serious concerns about whether, as Mr. Foote said, this is a densely populated area. If it's a densely populated area where we're hearing often, again, what seem to be copy-paste arguments of, this is my affected interest. It's not really unique if it's everybody's, well, I live and recreate in the area. I live and recreate in the area. I live and recreate in the area. I do have some concerns about that. I also have some concerns with respect to the timing of this, specifically the fact that nothing will be approved through the CAP application that would lead to the injuries alluded to by Mr. Foote. We still have to go through the OGDP stage, and that's where everything would go from more speculative to, yes, they will be able to file Form 2s and begin drilling in the future at that point in time. I think of particular note, I did have some concerns with the fact that, as Mr. Foote said, it makes it easier to approve the OGDP and is very likely will be approved if the CAP is approved. I do take issue with that because we do have to look at each application separately. And it's important to make sure that the public is aware that we are not simply saying, well, they passed the CAP, so therefore we're going to pass the OGDP. And we've had some situations come forward in the past where there's been a lot of questions that have come up in future OGDPs based off of what had previously happened in the CAP, and are they continuing to follow that? Are they continuing to meet what was required under the CAP or the CDP with respect to some of the older applications as well? I think ultimately what it comes down to for me is that, number one, as the Chair alluded to and Commissioner Ackerman noted as well, courts do take a very liberal interpretation of standing. And it makes sense to do that. We don't want a situation where standing could be challenged later on. You go through an entire process and then on appeal, it's, oh, this should have been a party. And then we have to go back and go through the entire process again. And so it makes sense for standing to be liberally viewed. I think number two is I view this akin to a federal leasing challenge. And that's that even at the leasing stage, it's not that something is immediately happening then. You still have to go through your environmental assessment and make sure that the appropriate analysis is done on a specific project. But at the same time, you still will get interveners coming in to try and say, it's important to look at this because we do want to have a say in determining whether something should be leased. And I view that at the same way here. I do have concerns with the fact that the real injury, in fact, I think would be more likely to occur at the OGDP stage. But I do think it's important because of the amount of BMPs that will apply to all OGDPs in the future, that anything that may come up in future OGDP hearings involve all the parties at this point in time during the CAP hearing as well. So for those reasons, I would also be in favor of STAR being granted affected person status. But I did want to make sure that it was clear that it's not a decision that I take lightly. And I do think that it is a close call in this situation, but I do think it is appropriate at this time.
I would move to approve STAR as an organizational affected party on behalf of its individuals.
Second.
Motion and a second. Is there further discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? Motion carries. Let's take another 5 minutes before we take up the next motion, and let's return at 11:09. All right, welcome back, folks. We're back on the record in 221-000-282. We now will hear argument on the ripeness claims on Maverick. I believe we'll hear from Crestone first. Again, 20 minutes allocated to Ms. Jost, followed by 15 minutes allocated to Stephen Lewis Prescott. Ms. Jost, you're recognized.
Great. Thank you so much, Chair. Again, good morning, Commissioners, Councils, members of the public. For the record, again, my name is Jamie Jost, Managing Shareholder of Jost Energy Law, and I, along with my partner, Kelsey Wazelinki, are representing Crestone Peak Resources Operating LLC on this Lowry Ranch Comprehensive Area Plan. Crestone's second preliminary matter to be addressed is the prematurity and unripeness of Maverick's petition and the claims set forth therein. To get straight to the point, Crestone is moving to strike Maverick's petition for lack of standing under Colorado Rules of Civil Procedure 12B5 for failure to state a claim and ECMC Rule 501B and G, and is asking this commission to summarily dismiss Maverick from this proceeding. Maverick's entire claim rests on alleged drainage interference of future horizontal wells, purported waste potential, and speculative harm to correlative rights of an offsetting non-operator leasehold owner that acquired its offsetting 69 acres of leasehold interest in the adjacent CAP boundary lands after the Lowry Ranch CAP was submitted to the commission. In fact, Maverick does not challenge the Lowry Ranch CAP itself because it holds 8 acres of leasehold within the CAP, and it does not challenge any of the proposed or conceptual oil and gas locations discussed in Crestone's Lowry Ranch CAP filings. Despite attempts by Crestone and Crestone's counsel to explain that the initial CAP process to Maverick and Crestone's confirmation that Maverick would likely have a future opportunity to petition the subsequent OGDPs, DSUs, Form 2As, and Form 2s through the ECMC's appropriate process if reduced setbacks were sought, Maverick still progressed with its petition mandating that this commission must decide on horizontal well drainage radii, prevention of waste, and protection of correlative rights at this Lowry Ranch CAP hearing. Any decision allowing Maverick to participate in this Lowry Ranch CAP hearing where 6 of the 7 new oil and gas locations remain conceptual in nature, and the 1 proposed oil and gas location is not located near Maverick's offsetting leasehold interests would be clear error and in violation of the commission's own rules. A decision allowing Maverick to participate today is also a waste of administrative resources when Maverick's claims are clearly unripe and are better suited for future OGDP and DSU applications associated with the Lowry Ranch CAP. Crestone has 5 points to support this motion to strike or motion to dismiss Maverick's petition. First, the doctrine of ripeness mandates that this commission forego consideration of uncertain or contingent future matters because the injury is speculative and may never occur. To be ripe, the issue must be real, immediate, and fit for adjudication. Based on Colorado law and Maverick's own stated positions, Maverick cannot show that there's any real or immediate issue to be determined during the Lowry Ranch CAP application phase of this project, and all of Maverick's claims are speculative in nature. This is especially true if the Lowry Ranch CAP is denied based upon Maverick's petition relating to its 69 acres of offsetting non-operated leasehold interests. Crestone could decide to completely reevaluate the development plans for the 32,000 acres of the Lowry Ranch CAP, which may or may not include the Maverick acreage it purports to own. All future development within the Lowry Ranch CAP is contingent upon 2 things. First, the ultimate approval of the Lowry Ranch CAP application itself, and 2, Crestone's filing of subsequent oil and gas development plans, Form 2As, and join and spacing units for the corresponding development after CAP approval. For the second point, the Commission's own Rule 314 confirms the unripe and premature nature of Maverick's petition. Rule 314 does not include one requirement or even one reference to drainage, waste, or correlative rights for purposes of the ECMC staff or the commission's review of a comprehensive area plan. The exclusion of this language and analysis is intentional by the commission. Each of these three items are exclusively addressed in subsequent ECMC permitting stages governing the oil and gas development process for minerals to be developed by a CAP, not the CAP process itself. Maverick will argue that the correlative rights reference in the statement of basis and purpose is related to any individual's correlative rights that may be impacted by the CAP. This is incorrect. The correlative rights reference in the statement of basis and purpose relates to the exclusivity of operatorship incentive of a CAP, not an offsetting non-operating leasehold owners' purported correlative rights claims. Maverick's argument on correlative rights is skewed and illustrates its failure to understand the initial CAP process and then the subsequent OGDP, DSU, Form 2A, and Form 2 process for the development of the CAP itself. Rule 314B confirms the subsequent permitting and unit application process following an approval of a Rule 314 comprehensive area plan. Specifically, Rule 314B6 provides in pertinent part that approval of a CAP does not constitute approval of an oil and gas development plan, drilling and spacing unit, Form 2A, or Form 2. Operators will submit all oil and gas development plans, drilling and spacing units, Form 2As, and Form 2s as ordinarily required by the Commission's rules for all locations and wells within an approved CAP. The language of Rule 314B6 illustrates the Commission's intent to review and determine the subsurface issues of drainage, waste, and correlative rights at a later date. Further, neither Rule 314E informational requirements for CAPs nor the ECMC November 30th, 2021 operator guidance on CAPs requires an operator seeking a comprehensive area plan to submit confirmed drilling and spacing unit boundary outlines, confirmed well paths, and confirmed number of wells per future drilling and spacing unit. It does not require them to submit Rule 505 engineering testimony, drainage calculations, or to determine subsurface setbacks for future drilling and spacing unit applications. Again, this is because each of these items are reserved for oil and gas development plans and drilling and spacing unit applications determined subsequent to the Commission's decision on a Rule 314 CAP. Rule 314E9's reference to minerals only requires a map and a narrative that 1, demonstrates the location of the minerals the operator owns or has secured the interest of mineral owners to develop, and 2, describes the percentage of interest the operator owns or has secured the consent of mineral interest owners to develop. The purpose of this rule provision is to ensure the Commission that the operator seeking a CAP has an interest within the planned CAP boundary and that its percentage of interest is substantial enough to warrant a determination of exclusive operatorship over the CAP acreage pursuant to 314B1. This requirement does not mandate that Crestone provide a map, narrative, or plan confirming drilling and spacing units, number of wells, or subsurface setbacks to develop the minerals that it owns or has secured consent for. Finally, with respect to Rule 314, and most importantly, the only reference to the statutory term for waste and correlative rights, excuse me, in the ECMC 300 series rules is located in Rule 305B, the application for drilling and spacing unit, where the rule requires the Commission to consider whether the drilling and spacing unit protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources, prevents waste of oil and gas resources, avoids the drilling of unnecessary wells, and protects correlative rights. Again, that's the ECMC Rule 305B. As Maverick well knows, there is no Rule 305 drilling and spacing unit application pending before the Commission with the Lowry Ranch CAP application that are offsetting Maverick's acreage, and any decision by the Commission to address Maverick's waste, drainage, and correlative rights claims would be in violation of its own rule. For the third point to dismiss Maverick, Maverick refuses to understand, or at a minimum, acknowledge the Commission's CAP, OGDP, DSU, Form 2A, and Form 2 process. This is evidenced by two unsupported points that Maverick will attempt to argue this morning. The first point being that based on Rule 314F, Crestone did not notice mineral owners outside of the CAP, which means Crestone cannot develop minerals outside the CAP in the future. This claim is factually wrong. Crestone did, in fact, notify offsetting mineral owners on offsetting acreage of the Lowry Ranch CAP boundary in order to ensure that they had notice of the Lowry Ranch CAP project from the beginning. Should Crestone, in a future OGDP and drilling and spacing unit filing, choose to request reduced subsurface setbacks. This extra notice is not required by Rule 314F and was a purely voluntary decision on behalf of Crestone. In reality, the notice issue is irrelevant for purposes of Maverick's claims and should not even be considered when determining Maverick's petition is unripe and premature. Additionally, Maverick will argue that the Crestone CAP unnecessarily causes adverse cumulative impacts because Crestone illustrated potential surface locations for the development of Maverick's minerals in defense to Maverick's claims that there are no surface locations Maverick can use to develop its offsetting 69 acres of Section 18, Township 5 South, Range 65 West minerals. Maverick is now attempting to convince this commission that Crestone, by defending against Maverick's unripe and unsupported position and offering an illustration of surface location potential, will cause adverse impacts outside the Lowry Ranch CAP. This reverse cumulative impact argument has no bearing on the Lowry Ranch CAP plan, and this commission should not be swayed by Maverick's attempt to use its petition and positions as both a sword and a shield. Further, this reverse cumulative impacts argument was never disclosed, argued, or supported in Maverick's petition, pre-hearing statement, or responsive pre-hearing statement, and this was only included in Maverick's July 19th PowerPoint hearing presentation submission for this oral argument. Maverick has no exhibits addressing this reverse cumulative impacts argument for its evidentiary slides. Maverick is throwing a Hail Mary with this new undocumented position in an attempt to gain standing in this hearing. The commission should not be swayed by Maverick on this claim and should remain focused on Maverick's core arguments: drainage, waste, and correlative rights. If the commission accepts Maverick's unsupported position, this would set an unwarranted precedent and would open the door to hundreds of additional potential petitions in future CAPs and OGDPs on the basis of non-inclusion of offsetting minerals. For example, every single mineral owner to the west of Lowry Ranch CAP could argue that Crestone should be drilling longer wells or changing to different wellbore orientations to develop their minerals or leasehold, and failure to do so would then lead to adverse surface impacts. This is not precedent the ECMC should be considering as part of this Lowry Ranch CAP application. The fourth point, Maverick has implied that the director of the ECMC is also wrong and doesn't understand the ECMC rules because the director's recommendation does not include an analysis of drainage, waste, or correlative rights. This implication is set forth in Maverick's responsive pre-hearing statement. If allowed to participate, you will hear testimony today from Maverick's witnesses that they attempt to paint the ECMC director, as well as Crestone, in a negative light for their alleged failures to address subsurface development as part of the cumulative impacts review process associated with the CAP. Not only are these issues outside the scope of the CAP, the drainage, waste, and correlative rights of a Rule 314 CAP application, but it will also result in an extensive waste of administrative resources to address subsurface development issues for an offsetting non-operator leasehold owner in a primarily surface-focused CAP review. Maverick attempts to convince this commission that because mineral owners get notice of a CAP that's meant to address cumulative impacts from the larger comprehensive development plan, this notice immediately results in standing to all mineral interest owners receiving notice in order to challenge the ultimate future development of the minerals within the CAP. This is not just the case. This is not the case, nor is this the intent of Rule 314. And then finally, Maverick claims that 75% of the minerals in Section 18, Township 5 South, Range 64 West are stranded. This is a misleading statement because it makes it appear that Maverick owns the entire 75% of mineral interest in Section 18. In reality, Maverick only owns a leasehold interest in approximately 69 acres of that part of Section 18, and the remaining approximate 411 acres of minerals in Section 18 that are outside the CAP are primarily unleased minerals held in fee. None of the other unleased fee interest owners have objected to this Lowry Ranch CAP application, and Maverick has no standing or right to make claims as to the impacts on minerals it does not own. This statement should be disregarded by the commission. As it boils down, Maverick is willing to risk the development of the entire 32,000 acre Lowry Ranch cap for 69 offsetting acres that were obtained after the Lowry Ranch cap was filed. This risk should not be rewarded by this commission. Based on relevant case law, there's no factual or legal basis for Maverick's petition to the Lowry Ranch cap application. Maverick's alleged injuries are purely speculative, and they are unfit for adjudication at this point in time. And Rule 314 does not support Maverick's purported claims of waste, drainage, and correlative rights protections during the Lowry Ranch cap application process. Maverick's unwillingness to recognize the ECMC rules, processes, and procedures has already resulted in a significant waste of administrative resources. As a result, Crestone requests that this commission summarily dismiss Maverick's petition under Colorado case law, its own rules, or any other authority granted to the commission to determine standing and prevention of waste of administrative resources. Thank you.
All right, thank you for the argument. We now will hear from Stephen Lewis Prescott.
Thank you, Chair. Good morning, Commission. I do have some prepared slides and remarks to share with you. I assume you can see the PowerPoint.
Yes.
Thank you. This is a motion on the pleadings, so I will assume the pleadings have been reviewed. Crestone challenges the ripeness of Maverick's claims, arguing that alleged injuries are speculative and better suited for OGDP and DSU consideration. Crestone is wrong for multiple reasons. So Maverick's interested party here. Maverick owns leaseholds within the cap and both inside and outside the cap. As you can see in this depiction, the yellow shows where their leases are, a little bit in the north half of section 18. The remainder 69 acres of leasehold outside of the cap in section 18. Maverick petitioned for 3 reasons, challenging the cap based on the resulting waste of oil and gas subject to Maverick's leasehold interest outside the cap, because the cap precludes any and all surface locations from which to develop the leaseholds. The cap and the wells within the cap will drain the oil and gas subject to Maverick's leaseholds adjacent to the cap. And the cap violates Maverick's correlative rights. Now, I'm going to stay on this slide for a minute because the depiction alone really cements the ripeness of Maverick's positions. This carve out that you see, kind of the peninsula of land that's not within the cap, that's been removed. The first iteration of the cap from 2022, second iteration of the cap in 2023 included section 17 and 718. This January 2024 second amended cap application removed this. It's unprecedented. The only time you see this type of carve out in a cap is when the area is in an existing or proposed OGDP for alternative development. You never see this otherwise. And here, there is no pending development. There cannot be pending development, and that's what we need to focus on. Look at the land surrounding section 18. To the west is a wall of surface development. There's nowhere to put a surface location west of section 18. Immediately east in section 17, that surface owned by Aurora, adjacent to Aurora Reservoir. It's not available for a surface location. That would leave Maverick or any other operator to look elsewhere for a surface location in order to develop these leaseholds. East, north, south, all Crestone's cap. However, Crestone has requested to have sole operatorship therein. So there's no way to develop section 18. Crestone's monopoly on all viable surrounding lands prevents development of Maverick's leaseholds, period. That is a cognizable injury that has been in place since January 2024 and continues if the cap is approved as proposed. Now, Crestone argues that maybe someday in the future it can incorporate Maverick's leaseholds in an OGDP within the cap, so they are not stranded or drained. Crestone can't cite a rule to support this argument. Rather, this argument is pure conjecture, speculating that they would do it and that the commission would approve it, i.e. approve lands outside the cap to be developed by surface locations, OGDPs, DSUs within the cap. The point is, Crestone wants to hold Maverick's leaseholds hostage. Crestone wants to have its cap approved, then decide later if it wants to try to develop Maverick's leaseholds. This is not how oil and gas development works. Crestone does not get to prevent Maverick from developing their leasehold, then argue to you that Maverick is not injured by it. This is real, and this is immediate. That's ripeness in a nutshell. No competing rule or SPP interpretations are needed. That ends the discussion. And Maverick asks that you deny the motion. I'm going to go through some additional slides and arguments to preserve the issues for appeal, but I think your decision can be made right there. So Crestone's position in a nutshell is that Maverick's leaseholds located outside the cap boundaries can be included in an OGDP or DSU within the cap sometime in the future. And therefore, they're arguing that it's not right now. The argument should be made when those OGDPs are submitted to you. This ignores the plain language of the mission change rulemaking, SPP. The commission will consider mineral ownership percentage and correlative rights as among the factors that are relevant to the decision about whether to approve or deny a cap. We were talking about correlative rights here. SPP clearly states that that is relevant to a cap hearing. It's unambiguous. If it is only applied to interests inside the cap, as Crestone suggests, then the rule provides no protections for mineral interest owners outside but negatively impacted by the cap. There's also no basis in the rules or the act for Crestone's position. Rule 314 FAC states, within 5 days of the director issuing the completeness determination, the operator will provide notice to the following: all owners of minerals that would be developed under the cap. Crestone did not notice mineral owners outside the cap, although Ms. Josh just said they did so out of the kindness of their hearts. However, the rule doesn't require it, which indicates to all of us the rule contemplates development of the minerals only within the cap. Thus, if Crestone were to come and attempt to develop from the cap minerals outside it in the future, well, now we have a due process issue because there was not notice granted to those outside the cap now being developed by locations within the cap. Crestone's position lacks common sense. Why establish an area, here 32,000 or so acres, where an operator has monopoly power if its development rights can extend beyond those boundaries? The rules don't contemplate what Crestone is essentially arguing, that they can someday use their monopoly power in the cap to develop minerals outside it. Crestone argues Maverick can develop its Section 18 leasehold from a location adjacent to the cap. Wherein Crestone Maverick's concept of stranding, specifically that Civitas is failing to develop its minerals, ignores the fact that Maverick has every opportunity to pursue its own OGDP to develop its minerals. That's Crestone's response statement. That argument alone is saying to you, hey, we should get another surface location somewhere outside the cap to develop these minerals. As discussed, that's not possible. It's just frankly not. And there'll be plenty of testimony to support this. However, your decision here is based on the pleadings, and pleadings clearly state that these can't be developed from a surface location outside of the cap. So I think as a theoretical argument at this point, based on Crestone's positions. Crestone also ignores the plain language of Rule 314A, and I'm just gonna, for the sake of simplicity and efficiency, focus on oil and gas development in a broad geographic area. The rules for caps pertain to development of oil and gas within the cap boundaries. Again, there isn't a world where Crestone gets to come back to you and say, hey, you know, we've got this cap, we want an OGDP, but we're going to pull in some minerals outside of the cap. We don't get the opportunity to make this argument in the future. The cap defines the boundaries of development. This is our shot. Crestone argues cap applications are only subject to surface and not subsurface considerations. Again, I point to 314 FAC. You're given notice to mineral owners within the cap. That really confirms that we're only talking about development within the boundaries. And the impacts of development within those boundaries, outside of those boundaries, is ripe for review right now. In fact, Crestone has already told you in their pleadings that they've removed Section 18 from development and they no longer plan to develop it. So we know today it's not speculative. It's not hypothetical. Crestone has pled that it is not developing Section 18. So we are ripe for hearing on this right now. I want to bring to your attention some sections of the Act. They apply to all of your decisions, particularly CAP applications, which impacts 32,000 plus acres. Crestone wants to focus on only the rules. They ignore the Act, and the Act is in play here. There's a requirement under 102(1)A to protect the public and private interests against waste. We've created a donut hole. We've created an area that cannot and will not be developed because of how Crestone carved it out. It was their decision to create these boundaries the way they did. Until January of 2024, there was not this carve out. They intended to develop 18 as they should have in order to prevent waste, protect against drainage, to protect correlative rights. By carving it out, they essentially said, hey, these minerals, these leaseholds, not going to get developed. Section 107 states that waste of oil and gas in the state of Colorado is prohibited. 106.3, again, references the prevention of waste in approving oil and gas development. Again, some more references to 102, 103, and 117, all talking about the requirement to protect co-equal and correlative rights by taking away all viable surface locations and having a monopoly within the CAP. Crestone has taken away the ability for Maverick or another operator to develop Section 18, the oil and gas associated therewith. These are the questions Maverick raises that are ripe for your review. Does the CAP preclude Maverick from developing its leaseholds? It does. Does the CAP result in waste of oil and gas? It does. Will wells drilled in the CAP illegally drain Maverick's leaseholds? The evidence will show that it will. Does the CAP unnecessarily create adverse cumulative impacts? Potentially, if there were another surface location, as Crestone suggests, for Maverick to develop the minerals. There aren't, but based on their argument, that's what they're essentially saying. Go find another surface location in Aurora to develop this. Not possible, but if we did, we're just asking for another surface location in the immediate vicinity. I do want to call to your attention some legal standards. First, Stella v. Boulder, County Department of Social Services. In the interest of judicial efficiency, courts will not consider uncertain or contingent future matters because the injury is speculative and may never occur. In deciding ripeness, courts look to the hardship of the parties of withholding court consideration and the fitness of the issues for a judicial decision. And then GRCO LLC, which cites to an appellate court decision, Metal Management West. A conflict is ripe for judicial review, even in the context of uncertain future facts, so long as there is no uncertainty regarding the facts relevant to the dispute and no pending actions that might resolve the issues prior to the court's determination. Two similar standards. I don't think it can be questioned that we meet both. Ms. Jose already referenced is it real and immediate? I think we've already covered that as well. If Maverick is not given the opportunity to challenge the CAP boundaries now, when will it be able to challenge the CAP boundaries to protect its correlative rights, prevent waste, and protect against drainage? These boundaries are the central issue of Maverick's position. Ms. Jose is correct. We're not challenging the CAP premise. We're challenging the boundaries created and proposing that they be extended to include the leaseholds owned by Maverick so as to avoid the violation of correlative rights, so as to avoid drainage without compensation, so as to avoid waste. And it's one of those, we have to protect ourselves. We have to exhaust our remedies. The CAP is the right time for it. If we weren't here today, if we didn't put forth our case today, then there's an issue later of why didn't you raise your arguments when you had the opportunity, when the CAP boundaries were determined, when the boundaries of oil and gas development were determined. That's what this is about. So based on the foregoing, I'll just submit to you that these issues are ripe for review at the CAP stage of the process, and I'm happy to answer any questions. Thank you.
All right, let's listen to Ms. Jost in rebuttal, and then we'll open the panel up for questions.
Great, thank you, Chair. Just a few points. First, the OGDPs and DSUs that would be adjacent to Maverick's 69 acres of offsetting minerals are not set in stone, and neither are the subsurface setbacks. So Maverick's claims of drainage are premature. Additionally, Maverick claims that Section 18 creates a donut hole. This is a false statement. Maverick's own map showed that Section 18 is on the edge of the cap area and has numerous lands and minerals to the west for its consideration to develop its own minerals. Maverick claimed that Crestone has requested exclusive operatorship for the Section 18 lands that are offsetting the cap boundary. This is also a false statement. Maverick claimed that there are no locations outside of the cap to develop Maverick's minerals, and these were not in the pleadings. This is also a false statement. Crestone's pleadings and Maverick's own pleadings and maps do show that there's locations that to develop Maverick's own minerals, and Maverick misstated this position. Further, if Maverick intends to develop its own minerals, which it does not, it's relying solely upon Crestone to develop its leases that it acquired after the cap was submitted, it can request the commission to permit its location inside the cap boundary. In fact, the commission has allowed this situation in the Crestone Box Elder cap, where both Crestone and GMT have oil and gas locations within the Box Elder cap. Again, Maverick's adverse cumulative impacts claims are new. They were not disclosed at any point in the pre-hearing process. It's seeking to include such claims now in order to attempt to remain a party in this rulemaking. We would view this as an abusive process under Rule 501. Maverick's attempts to apply 3460-102 to a cap is unsupported by the language of the statute itself. 3460-102 provides that the commission is directed to protect the public and private interests against waste in the production and utilization of oil and gas. A cap does not ultimately approve the location, the spacing, or the wells that result in production and utilization of oil and gas. A cap provides a boundary for such development of oil and gas, and then the production and utilization of oil and gas is ultimately governed by subsequently filed and approved permits for drilling and spacing units and wells. The same concept applies to Maverick's attempt to apply 3460-102-1A to a cap, and that argument remains unsupported by the language of 3460-102-1A and 1B. Again, a cap does not ultimately approve the location, spacing, or wells that would determine if an owner has a right to receive its just and equitable share of production. Those approvals rest in the subsequent OGDP, DSU, Form 2A, Form 2, and pooling filings. Crestone doesn't disagree that the legislative mandates of the Oil and Gas Conservation Act, however, they do object to Maverick's continued attempts to apply the mandates to prevention of waste and protection of an offsetting, non-operated leasehold interest owner in a cap setting. This was not intended by the adoption of Rule 314 in the mission change rules, and this concept cannot be unilaterally applied to this singular Lowry Ranch cap application. Crestone acknowledges that Maverick may have an opportunity to petition a future OGDP and DSU application that includes cap lands that are adjacent to Maverick's offsetting leasehold if Crestone chooses to reduce setbacks from the 600-foot statewide setback. However, it will not automatically agree to Maverick's standing on any future petition. Maverick is represented by counsel and can navigate those waters once the appropriate time comes. Maverick does not control Crestone's development or operational plans. Maverick's pre-hearing statement and corresponding exhibits reflect an entitlement to take over Crestone's development and operations in Section 18. Maverick failed to develop its own 69 acres of minerals itself and is now looking for an out for its own failures to develop those minerals under its respective oil and gas leases with its own mineral owners. Maverick is now looking to this commission to mandate that Crestone develop its minerals because it failed to do so. Maverick acquired the leasehold interest to its 69 acres of offsetting minerals to the Lowry Ranch cap boundary in the following months: January 2023, February 2023, March 2023, April 2023, and October 2023. All of these were after the Lowry Ranch cap application was filed on October 27th, 2022. At the time of speculatively acquiring such leasehold interests, Maverick was well aware of the pending Lowry Ranch cap application and took those leases subject to the pending application. which is always subject to evolution and modification and amendment prior to receiving a determination of completeness by the director under the commission's own rules, and that's Rule 314D4. Maverick knew or should have known that taking an oil and gas lease in an area with a pending Rule 314 comprehensive area plan is a risk. Maverick cannot now pretend to not understand such risk and blame Crestone for its own poor business practices. Maverick's claims are unripe, and the inclusion of Maverick in this Lowry Ranch cap hearing would be a significant waste of administrative resources and the commission's time. This is especially true when Maverick has future opportunities to bring their drainage, waste, and correlative rights claims before this commission at the OGDP and DSU application stage. Thank you.
All right. Matter is argued up. Commissioners, do we have questions for the folks, or do we want to move into deliberations? Seeing no questions, we can have both lawyers unvisualize themselves and just have the commissioners here to chat amongst ourselves. Are folks ready to try to divine our way through this legal issue? Do you want to do an executive session with our lawyer to get some legal advice on this? This is a case of first impression, as best I can tell. We've had comprehensive area plans come before us, and we've never had a dispute between mineral acreage that is not before us. Sort of speaking off the cuff, I do think this is a drilling and spacing unit issue, and that's not what's before us today. But I do wonder what happens when the OGDP comes in and the DSU comes in, and at that point in time, the Maverick type mineral estate raises an issue of correlative rights and waste. And that's not something we've dealt with either. And it's a little bit outside of my surfboard in terms of like making sure that I understand this, but I think I'm leaning to that this is not really right at this stage because we don't really deal with DSUs at the comprehensive area plan stage. And I think we can recognize that Mr. Stephen Lewis Prescott and his client have raised these issues now. And if and when they become ripe, we can, look back to this and say, well, we're going to reconsider this, and we may reconsider the boundaries of the cap if this does indeed create waste or correlative rights issues. But I'm like 51-49 on that position. Anybody else want to weigh in? Commissioner Messner?
Thank you, Mr. Chair. I would appreciate an executive session on this because there's enough legal questions that I have that I don't know as I can make any deliberative thoughts until I have those opinions.
Okay, I think that's a good idea. I would move that we go into executive session to receive legal advice on this matter. I'm looking at AG Davenport to see if we need to do more with regard to said motion.
Thanks, Chair. I think I'd just add that I believe when you said this matter, you're talking about to receive legal advice and analysis on the ripeness of Maverick's petition. Is that accurate? Do the commissioners want to expand the topics for executive session at all?
Commissioner Messner?
I mean, ultimately, I think that's the legal questions, but I have questions about the legal topics that were brought up in both testimonies provided by, or testimony provided by both parties. So I would like to ask legal advice generally about some of the legal arguments brought up in testimony.
Okay. I think the question of ripeness probably would encompass those questions, but we'll just expand the scope so we're clear for the public that we're also dealing with any related legal arguments or questions that the parties have, that Maverick and Crestone have made today in relation to the ripeness and whether or not Maverick should continue with its arguments today. Does that work?
Yeah, consider the motion so edited. Do we have a second?
Second.
Motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. All right, for the 162 people that are listening in, what we do now is we're going to go into an executive session, which is going to be a different Zoom meeting that is just the four commissioners and our attorney to receive legal advice. We're allowed to do this via by way of Colorado law. We will not make any decisions in executive session, and once we return, we'll come back to this meeting. I would suggest we tell the parties that we'll return to open meeting at 1 o'clock today. That'll give us time for an executive session as well as time to get a little lunch. So if that is the case, then we will return at 1 o'clock. We're going to take a lunch break and we're going to do an executive session, and we'll see everybody back at 1. This is the Colorado Energy and Carbon Management Commission. The commission has come back to our regular Zoom business agenda meeting. We conducted an executive session. I'll turn it over to AAG Davenport.
Thanks, Chair. The commission has exited executive session. The purpose and topics in that executive session were to receive legal advice and analysis on the issue of Maverick's petition to participate as a party and whether or not it was ripe. The commission received legal advice and analysis on that issue and related legal questions. No deliberations were had in the executive session and no votes were taken. Mr. Chair, we now need a motion to exit executive session.
So moved.
Second.
Motion and a second to leave executive session. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. We are back in normal business agenda docket 221-000-282, the Lowry Comprehensive Area Plan. Commissioners, I believe at this point in time, we are set for deliberation on the motion by Crestone to, I guess, strike Maverick as a party at this time due to ripeness considerations. Does any commissioner desire to initiate deliberation? Commissioner Messner?
Thank you, Mr. Chair. I think as indicated in the rules in the statement of basis and purpose, one of the purposes of the CAP is to facilitate evaluating and addressing cumulative impacts from oil and gas development in a broad geographic area by identifying plans for one or more operators to develop oil and gas locations within a region while avoiding, minimizing, and mitigating impacts to public health, safety, welfare, the environment, and wildlife resources within that region through systematic planning of infrastructure, location, best management practices, and centralizing facility. I think this mineral area that's being debated in this petition to participate as a party and whether or not it's ripe or not is a known issue. It was initially contemplated within the CAP boundaries. It does have potential CAP implications from both a cumulative impact standpoint as well as a surface and subsurface planning standpoint. And while draining and correlative rights are dealt with at the OGDP stage, not addressing it in some form at the CAP application stage as a known issue as potential future implications. Should the CAP application be successful, to require significant modifications to the CAP or reevaluation of elements of the CAP application, the potential implications, including denial of any associated OGDP. So some elements of this would be best initially dealt with in the CAP review process. So I would be in favor of, allowing the petition for participation to stand as a party, and do believe that it is ripe and appropriate to include arguments on this topic within the hearing, but certainly am willing to listen to other commissioners' thoughts.
All right. I remain in my initial position that I do not believe this is ripe at this point in time. I believe that this may become ripe in the future, but that's not a certainty. At the DSU stage, at the OGDP stage, I believe I'm also influenced by the fact that we want to incentivize the utilization of caps. And if we allow a disgruntled, very small portion of mineral estate that's near a cap to be able to undercut the efficacy of the cap, I think we're going against the rules that we've created. I do not believe that not allowing Maverick to participate today undercuts any ability of Maverick to raise its concerns at such time in the future, just as you indicated, Commissioner Messner. And that may mean, if we get to it, that Crestone would need to think about the cap and maybe adjustments to the cap, but that's not necessarily needed in today's deliberation as to the efficacy of the cap for 32,000 other acres or whatever the grand number is compared to the 69 that Maverick has. I'm also influenced by the fact that Maverick purchased these acres with an understanding and that the cap had already been applied for. So I would move to not allow Maverick to participate today and give Maverick the ability to participate at the right day down the road in the future under the DSU OGDP consideration that may or may not occur. That's two of us. Who wants to go next? Commissioner Ackerman?
Thanks, Mr. Chair. I also lean towards deferring this issue to the OGDP stage. I think issues of drilling and spacing units and waste are most appropriately handled at that stage, as was advocated by Crestone. Our Rule 314 doesn't actively require consideration of correlative rights and waste outside of the cap boundaries. But I do recognize that the 69 acres in question are a very small portion, as you stated, Mr. Chair, of the overall mineral rights and operations that we're considering within the cap here. In addition, I would second the point that you made that these minerals were acquired with the full knowledge that there was a pending cap in the area. I do hope that the operators continue to talk to each other. I think, these issues are important from a legal and procedural perspective. I just don't feel it's appropriate to require resolution of this issue prior to moving forward with the cap process. But I also acknowledge that this could cause even significant DSU issues at the OGDP stage. And I understand Commissioner Messner's point on that issue. I can foresee a situation by which the operator Crestone moves down a path of electrification and movement of materials and earth and resources into an uncertain future, potentially with regard to the OGDP stage associated with Maverick here. So I do think it would be prudent for the operators to work together on how they might resolve the issue, but I also do think it's most appropriately handled at the OGDP stage.
Commissioner Cross?
Thank you, Mr. Chair. I'll be brief. I agree this is a matter that is best reserved for an OGDP hearing, so we can talk about it with respect to a proposed DSU or wellbore spacing unit for that matter. It is not a subject that is set forth in our Rule 314, and I don't want to expand what cap applications should have discussed. Simply because an issue might affect the cap. And frankly, I think it's more of a situation where if in the future we're going to run into potential correlative rights issues or potential waste issues, I think that that's just as much going to fall on Crestone. And so I think that that's something that the cap applicant will have to deal with at that time. Yes, it does impact the mineral rights owner, Maverick here, but I think it just as much impacts Crestone. And so I think that that's not really appropriate for this time. I think I might feel differently if this was a situation where there was more of a preliminary siting, there was more of an issue of trying to say, this is exactly where we're going to drill, this is exactly where it's going to be done. None of that's decided at this point in time. This is a situation where we're looking at a cap boundary, we're looking at what's going to happen in a potential cap. But that doesn't mean that this is the end-all question of whether the DSU, whether an additional wellbore spacing unit could be done. That's best left for an OGDP stage when actual approving of of drilling plans will be done. And so I will also be in favor of not including Maverick in this hearing at this time.
Commissioner Ackerman,
Just intended to second your motion as well, Mr. Chair.
further discussion? Commissioner Messner?
Thanks, Mr. Chair. I understand there's a motion and a second, and so I'm just gonna share my dissenting opinion only in the case that if we've got a known issue, it's best to be addressed at the comprehensive or master planning stage rather than wait and cause administrative burden to both our staff and to our process if we've got a known issue. And so it seems possible certainly to deal with it at the OGDP level, and I'll be available to deal with that should that ultimately become the case. But I was hoping that we would be able to at least hear arguments on it now so that we can identify issues as I think comprehensively we want to do in the CAP application. So, but I respect all of your opinions on this. So thank you.
Yeah, no, I appreciate that, and I respect your opinion as well. I remain influenced greatly by the fact that this would open up the floodgates. Anybody that has 1% of mineral estate within or near a proposed cap would have the ability to tangle up cap, and I really do like the concept of comprehensive area plans for all the good things that it does. And I also believe that the operator ought to be able to determine what are the boundaries of his comprehensive area plan that they want to bring forward to us. And this still gives, other operator or other mineral estate owners that are concerned an opportunity down the road. So with that, we'll stop deliberating and we will call for a motion. All those in favor signify by saying aye. Aye.
Aye.
And all those opposed signify by saying aye.
Aye.
So the motion carries 3-1. Maverick is dismissed from the proceeding at this point in time, and will have an opportunity to raise their concerns if the opportunity arises down the road, or, and that presumes a lot of things, including all the work we still need to do on the comprehensive area plan before us today. I will make an adjustment to the final pre-hearing order by striking the efforts of Maverick to be involved in this. And with that, we will move to the next agenda matter in this docket, which are the opening statements, first from Crestone and second from Star. And before we do that, could I have Mr. Peskin provide us with time allocations?
Certainly, Mr. Chair. We have Crestone with 5 hours and 20 minutes remaining, and I have Star with 2 hours and 46 minutes remaining.
Great, thank you. Ms. Jost, you are recognized.
Thank you so much, Chair. And if Mr. Foote could show himself on video, I just have a couple questions that, if this can be off our time, is a preliminary matter dealing with just kind of logistics of the remainder of the hearing, if I may.
Go ahead.
Okay, thank you so much. And Mr. Foote, this is really just to confirm with the commissioners that we have stipulated to exhibits for purposes of admissibility, not content. Would you agree?
Yes, that's outlined in the stipulation.
Okay, thank you so much. And then Chair, Mr. Foote and I have also communicated just about the style of presentation for today. It being a more of a presentation style format in many instances rather than a direct question and answer of each of the witnesses. Mr. Foote did not object to a presentation style format, and we both agreed that cross-examination of the witnesses could occur at the end of each of our direct presentations instead of in between. Would the commission be okay with that form of presentation?
Yes. So I'm all in favor of presentation style, as opposed to the more formal lawyering Q&A. And then, just so that we all understand, cross-examination would occur not after each individual witness, but at the conclusion of your case in chief, and then vice versa.
That is what Mr. Foote and I communicated about. Mr. Foote, would you agree with that?
Yes. And Mr. Chair, regarding the presentation style, I can appreciate the chair's preference for presentation style. We had indicated that we were looking to do some kind of a hybrid between presentation and more of the Q&A style in order to make sure that our witnesses stay on track.
Yeah, no problem.
Okay.
This is, you know, we relax the rules of evidence here, and however you want to get your case across to us, we're fully receptive. So hybrid, all Q&A presentation, it's y'all's call.
Great, thank you, Chair. And then just one further thing with respect to our expert witnesses, we have not stipulated on the witnesses, and we would, from Crestone's perspective, would ask that the admissibility and qualifications of each expert witness is determined before their testimony. And I'm assuming Mr. Foote would put up his expert witnesses and would qualify them. And if we had an objection, we would just like the ability to object prior to that testimony if we felt an objection was necessary as to the admissibility. Would the commission follow that rule 702 of the Colorado Rules of Evidence?
Yeah, and so commissioners, what she's saying is that she may want, or either side may want to put forward a witness that would be considered an expert witness, and so their testimony on opinions would go toward, you know, be a level beyond just a layperson. And so what we'll do is we'll have, before you start asking your expert witness questions, we would have you undertake a voir dire and provide the credentials and all that information. Commissioners will then make a determination. I may try to make an initial determination to make sure that folks are comfortable with it. And then you would go into your examination of your expert. And then we would also give the other side the opportunity as to whether they'll just agree that this witness is an expert. And if that's the case, then we won't have to make a contested determination. Does that all sound good? Ms. Jost?
Oh, yes, Chair. My apologies. I didn't know if that was to the commissioners or if that was to us. Yes, that sounds wonderful. Thank you.
Mr. Foote, you're good too?
That's how I plan to do it.
All right. Commissioners, are you all good as well with all this? All right.
I had one thing I'd like to bring up, Mr. Chair, and this is given the commission's ruling on Maverick not participating at this point. The time allocations were set so this could be a 2-day hearing. Obviously, Crestone has the burden, so it received more time. But the 3-hour split between Maverick and Star was determined, I think, because there was assumed there was going to be 2 affected parties. Star should have the 6 hours in order to present, but given the fact that Maverick, which had 3 hours, is not participating at this point, I would ask the commission to grant Star some more time so that we could make a presentation, and we don't think this is going to cause any issues because the hearing's not going to go more than 2 days as a result anyway.
Why don't we do this, Mr. Foote? Why don't you present your case? Don't feel like it needs to be truncated, and if we get to the 3 hours and it appears that you still have, you know, substance that we want to hear, we'll address that and provide additional time at that point.
That sounds good. Thank you.
All right. Anything other procedurally before we move to opening statements?
Nothing from Crestone. Thank you, Chair, for entertaining that.
All right. Just FYI, I'm going to turn off my video because I had other things happening during lunch hour and I need to eat some lunch, but I will be listening and taking notes. Ms. Jost, you're recognized for opening.
Wonderful. Thank you so much. Kelsey, if we could go ahead and share the presentation. And then we will start on slide 5. Thank you so much. All right. Well, again, good afternoon, Chair, Commissioners, Council, and members of the public. For the record and for any new listeners, my name is Jamie Jost, Managing Shareholder of Jost Energy Law, and I, along with my partner, Kelsey Wieselinki, represent Crestone Peak Resources Operating LLC on this Rule 314 Lowry Ranch Comprehensive Area Plan application today. Crestone Peak Resources Operating LLC is a wholly owned subsidiary of Civitas Resources. The Civitas team, our subject matter experts, and Jost Energy Law are grateful for the opportunity to present the Lowry Ranch CAP project to you today. This comprehensive project has been over 3.5 years in the making. pending with the commission for almost 2 years, and if approved, will provide significant benefits to the state of Colorado, local governments, our local schools and communities, and our citizens. The Lowry Ranch CAP presented to you today is the direct result of a collaborative effort between federal agencies, state agencies, including the ECMC, CDPHE, CPW, Colorado State Land Board, local governments, emergency responders, oil and gas operators, mineral owners, community organizations, and Colorado citizens. Civitas would like to thank each and every person, agency representative, community organization, and mineral owner and operator who took the time to engage with Civitas on the development of the Lowry Ranch CAP project, including Star and Maverick. The input was hearty, thoughtful, discerning, and even challenging at times. However, it all led to the Lowry Ranch CAP application before you today with the director's recommendation for approval. The Lowry Ranch CAP application solidifies Civitas' commitment to responsible, protective development of 32,000 acres, 50 square miles of mineral resources with 166 horizontal wells from only 7 new, limited in size surface locations and 2 existing locations, all of which are located on the Colorado State Land Board-owned Lowry Ranch. As you will hear today, the Lowry Ranch CAP represents a comprehensive plan that embraces the intent of the mission change rulemaking. The geographic location of the CAP on Lowry Ranch and the lack of residential building units by the proposed and conceptual oil and gas locations make this part of the state a prime location for oil and gas development, especially considering the exclusive state land board lease for oil and gas development and the state land board's mission to monetize its holdings for the benefit of public schools. The Lowry Ranch CAP project is protective of public health, safety, welfare, the environment, and wildlife resources, and it will also significantly reduce surface impacts through demonstrable consolidation of surface locations by nearly 50%. The Lowry Ranch CAP also establishes operational efficiencies that reduce time on each location, reduces stresses on local infrastructure such as roads and traffic, and significantly reduces emissions. Civitas has developed and will implement an extensive set of best management practices and coordinated infrastructure development that will dramatically aid in avoiding, minimizing, and mitigating impacts from its operations. These include robust, continuous, and transparent air monitoring, as well as the commitment to electrical power for the operations and production phases of the development at 4 locations as of today. Civitas has also purchased a third-party midstream operator to secure the availability of oil pipelines and gas pipelines for fluid transportation from each location as of the date of first production. Civitas is dedicated to safely developing the energy resources that are so vital to everyone's modern lives, and it fully recognizes and accepts the obligations to the communities that accompany its license to operate. The Lowry Ranch CAP is evidence of Civitas's intention to develop this area in the proper and most protective manner, and sincerely thanks this commission, the director, and its staff for the thoughtful review and analysis and consideration of this best-in-class approach to developing oil and natural gas resources. Next slide. The Lowry Ranch CAP proposes the development of 32,000 mineral acres with 166 new horizontal wells on 7 new oil and gas locations and 2 existing locations. The area is rural in nature, and each new oil and gas location is located on the Colorado State Land Board-owned Lowry Ranch. There are no high occupancy building units, schools, child care centers, or public water supplies within 2,000 feet of a proposed location, and in total, there is 1 residential building unit within 2,000 feet of the 9 oil and gas locations considered for CAP development, and Crestone has obtained informed consent from the singular residential building unit owner. As you heard this morning from Ms. Caranda of the Colorado State Land Board, in addition to owning and enforcing surface development on the Lowry Ranch, the Colorado State Land Board also owns 21,000 acres of mineral interest underlying Lowry Ranch. Among other things, the Lowry Ranch lease contains specific land stewardship stipulations in order to minimize the amount of surface disturbance on the ranch. Specifically, the lease only allows for a maximum surface impact of 650 acres, or 3% of the total leased area. and the surface access to those 650 acres is subject to controls and limitations under a tiering structure determined by the State Land Board. Crestone is the leasehold owner of the Lowry Ranch oil and gas lease. It has plans to develop the lease lands as part of the oil and gas development plans and drilling and spacing units to be filed in the future should this cap be approved. Civitas, the EMC, ECMC, CDPHE, CPW, State Land Board, federal agencies, local governments, emergency responders, oil and gas operators, mineral owners, and community organizations and Colorado citizens have been invested in coordinating and collaborating on this CAP project since before its filing on October 27th, 2022. Through these efforts, the Lowry Ranch CAP application has evolved and has changed due to various factors and input from the multiple groups of stakeholders, including STAR. This evolution is intended and frankly encouraged as part of the Rule 314 CAP process. As a result of discussions and input from Arapahoe County and the ECMC, Crestone evolved the CAP project and submitted a first amended application on April 28, 2023. Upon review of the first amended CAP application, changes in Arapahoe County oil and gas regulations, and community and citizen group input, as well as Crestone's consultation with the EPA, BLM, state agencies, and local governments, Crestone submitted a second amended application on January 30th, 2024. On February 27th, 2024, Crestone sent the second amended Lowry Ranch CAP application and notice of hearing to 5,940 interested parties, and that notice of hearing allowed for a 120-day notice, well beyond that required by Rule 314. On April 11th, 2024, Crestone held the Rule 314F informational meeting, where it invited 5,940 interested parties to attend, and on May 16th, this commission held a Rule 511 local public hearing at the Arapahoe County Fairgrounds. From that point on, you are familiar with the progress of the Lowry Ranch CAP. Crestone received 2 petitions, one from Maverick, which has been dismissed, and one from STAR. Over Crestone's respectful continuing objections to both Maverick and STAR's attempts to delay the hearing, the CAP hearing was ultimately rescheduled twice to today's date, 647 days after the CAP was filed and over 182 days after the second amended application was submitted for staff review. Comprehensive area plans are complex. They are detailed, they are lengthy, and they are a tremendous amount of work for everyone involved. But this is the purpose. They are meant to be comprehensive. CAPs allow an operator to zoom out and look at larger geographic areas of minerals and surface to determine the best way to evaluate and address cumulative impacts as a whole, and to avoid, minimize, and mitigate impacts through systematic planning. This is exactly why Crestone continues to seek CAPs in this area of the DJ Basin, as evidenced by the submission of its Rule 314 Arapahoe Comprehensive Plan on January 24th, 2024. The Commission's continued encouragement of the use of CAPs is recognized, and this is exactly the reason that Crestone chose to propose development on the Lowry Ranch on a comprehensive basis. CAPs do provide incentives to an operator receiving approval of a Rule 314 CAP. Exclusivity of operatorship is one incentive, but the more important advantage to Crestone is the 6-year duration of the CAP and the subsequently approved OGDPs, Form 2As, DSUs, and Form 2s. Comprehensive development on a 32,000-acre scale takes time, and extended permit durations are key to achieving the planned comprehensive development that will protect public health, safety, welfare, and environment and wildlife resources. Crestone acknowledges the Rule 314 incentive of expedited permitting for OGDPs, DSUs, Form 2As, and Form 2s upon CAP approval, and no Form 2B submissions. However, these incentives have not been applied in practice on CAPs preceding this one. If approved, Crestone desires those incentives to take root and have meaning as the subsequent permitting of the Lowry Ranch CAP occurs. Crestone is seeking one location for preliminary siting approval, the State La Plata South location, and if approved, Crestone recognizes the rights conveyed by the CAP order, as well as the Commission's ability to include additional BMPs, best management practices, on that site during the OGDP portion of the permitting stage. If the Lowry Ranch CAP is approved, Crestone recognizes and understands the permitting process and confirms that any approval of the Lowry Ranch cap is not the approval of the subsequent OGDP, joint and spacing unit application, Form 2A or Form 2 filings for the development of the minerals from the 9 locations within the cap boundary. The commission is not, by the plain language of its own rules, in a position today to make any determination on a not yet filed subsequent OGDP, DSU, Form 2A, or Form 2. As you will hear from Creststone's witnesses today, Creststone has met each and every requirement under Rule 314, specifically 314D, 314E, and 314 as a whole, and has provided this commission with a rule compliant and approvable application for your review and analysis. More specifically, Creststone has analyzed, evaluated, prepared, and submitted each of the Rule 314E informational requirements, which resulted in several hundred pages of documents for your review. As I spoke to earlier, the collaboration and coordination process with stakeholders is a critical part of the Lowry Ranch cap development and evolution. Civitas takes community outreach and feedback seriously, and as you will hear today, that feedback resulted in several key changes to the Lowry Ranch cap in order to provide more protections to public health, safety, welfare, environment, and the wildlife. The slide is very important to Creststone as it reflects 2 key items: the comprehensive planning Creststone has taken to avoid human receptors as part of the oil and gas development, and the extensive nature of the community and public involvement as part of the evolution of the Lowry Ranch cap. Creststone has engaged in significant measures to protect our fellow citizens as part of this Lowry Ranch cap development, and these numbers are indicative of those efforts. 0. There are 0 residential building units owners within 2,000 feet of a proposed oil and gas location that's in a disproportionately impacted community. Creststone has ensured that no location is proposed within a disproportionately impacted community or a cumulatively impacted community. 1, there is 1 surface owner for each of the 7 new locations, the Colorado State Land Board. 1, there is 1 relevant local government that is overall supportive of this cap application. 1, the Lowry Ranch cap has 5,940 interested parties, yet there is only 1 residential building unit owner within 2,000 feet of a proposed oil and gas location, and that residential building unit is not in a disproportionately impacted community. Creststone has obtained the requisite informed consent from the residential building unit owner. 3, there are 3 proximate local governments that are supportive of this cap application. 5,900. There were 5,901 mineral owners within the Lowry Ranch cap boundary and offsetting lands that received notice of the Lowry Ranch cap application, and not 5,900 of them did not petition or protest the cap application. We have 1 community group, STAR, with its members located more than 3,000 feet away from the nearest Lowry Ranch cap conceptual oil and gas location, none of which have met the affected person status required by 507, as we argued earlier, and then less than 0.1% of the nearly 6,000 interested parties within the Lowry Ranch cap, 1 petitioned. The silent supermajority clearly do not object to the Lowry Ranch cap, and you heard multiple public comments on July 15th in support of the Lowry Ranch cap from various stakeholders and citizens. In addition to ensuring that Creststone's early and consistent outreach, evaluation, and planning with stakeholders resulted in a substantially protective cap application to present to you today, it held a virtual informational meeting where 109 persons attended out of the 5,940 that were invited. And Creststone has also responded to hundreds of citizens who submitted public comments to the ECMC or private comments to Creststone stakeholder relation teams that are dedicated to serving the Lowry Ranch cap project. Creststone's work on the communications and responsiveness to the public and private comments is no small feat, and that is an effort that Creststone takes and will continue to take very seriously. Back to why these numbers are important today. The Lowry Ranch cap has the overwhelming support of the 5,900 mineral interest owners who will benefit from this comprehensive development. and a majority of the stakeholder agencies, local governments, and most importantly, the director of the ECMC. The director's recommendation is meaningful, and it should be given significant weight in the commission's review of the Lowry Ranch cap. In addition to the commission's statement that it has no objection to Crestone's request for preliminary siting approval of the State La Plata oil and gas location and its detailed evaluation of Crestone's cumulative impact analysis, the director, after almost 2 years of detailed and complex analysis of the Lowry cap application, expressly found that the ECMC staff has reviewed the Crestone Lowry Ranch cap and has determined the information provided sufficiently demonstrates compliance with the requirements set out in Rule 314E, and none of the proposed Lowry Ranch cap is in conflict with the ECMC rules. Staff's review of the application materials results in the following determination. The director has obtained and fully reviewed all required and supplemental information necessary to evaluate the proposed Lowry Ranch cap operation and its proposed impacts on public health, safety, welfare, the environment, and wildlife resources. Through this review, the director has determined that this cap complies with all applicable requirements of the commission's rules and recommends approval by the commission. This final sentence of the 95-page director recommendation confirms that the Lowry Ranch cap application is approvable, and we will provide substantial evidence in support of the director's finding. Crestone maintains that the commissioner should approve the Lowry Ranch cap application pursuant to its standard in Rule 314H3. The Lowry Ranch cap complies with all requirements of the commission's rules that are expressly found by the director, and the Lowry Ranch cap protects and minimizes adverse cumulative impacts to public health, safety, welfare, the environment, and wildlife resources. Before I conclude with Crestone's requested relief, it is appropriate to address STAR's unsupported claims and why the commission should not be swayed by the information they will attempt to provide today. As you heard in preliminary matters, the main purpose of STAR's testimony is to have this commission believe that Crestone has done nothing to protect the Aurora Reservoir or the citizens of residential communities that are located more than 3,000 feet away from the nearest conceptual oil and gas location within the Lowry Ranch cap boundary. If you reviewed all of the documentation submitted by Crestone in support of the Lowry Ranch cap application, it is abundantly clear that this could not be further from the truth. STAR's primary focus is based on its perceived unsupported seismicity concerns under the Lowry Landfill Superfund site, although Crestone has expressly stated and amended its cap to reflect that it will not be drilling under the Lowry Landfill Superfund site as part of this cap project. And again, it modified the Lowry Ranch cap boundary to confirm this lack of development. STAR will also focus on, but will not provide any credible evidence to show, that Crestone's conceptual Sunlight Long oil and gas location, which is more than 3,000 feet from the Aurora Reservoir in compliance with both Arapahoe County oil and gas regulations and ECMC regulations, and also more than 5,290 feet from an unbuilt future planned reservoir, is also in compliance with both Arapahoe County and ECMC regulations, that location will eventually contaminate the Aurora Reservoir. STAR fails to acknowledge the multitudes of protections provided by Crestone in its cumulative impact analysis and cap application to, in fact, protect the Aurora Reservoir. STAR also attempts to make noise an issue in an almost completely barren area of the Lowry Ranch. However, STAR's testimony will fall short of providing any finding that noise will cause a concern to the 0 humans that are located within 2,000 feet of 6 of the conceptual oil and gas locations, or the 1 human that is located within 2,000 feet of the State La Plata oil and gas location that has provided informed consent for the site. The commission should take note when listening to STAR's testimony that none of STAR's witnesses that will attempt to testify today are from Colorado and have not listed any Colorado-specific experience on their CVs. In fact, STAR's experts illustrate outright bias in their purported expert reports. In comparison, Crestone witnesses are from Colorado. They work in the Colorado oil fields, and specifically the oil fields in Arapahoe County. Most have testified in front of this commission on numerous occasions, and they have time and time again established their credibility with respect to the ECMC, CDPHE, CPW, and other state agency regulations that serve to protect public health, safety, welfare, environment, and wildlife resources. Crestone requests that this commission view STAR and its unqualified biased expert witness testimony for what it is. It's an activist group that's set to stop oil and gas development in the state of Colorado and specifically Arapahoe County. Notwithstanding the unsupported and premature arguments and the positions that you'll hear from STAR today, one thing is certain: the Lowry Ranch CAP application is approvable. It has met all of the requirements of the commission's rules, and it will serve to protect and minimize adverse cumulative impacts to public health, safety, welfare, the environment, and wildlife resources. Comprehensive long-term development projects in rural areas are what this commission encourages, and Crestone has delivered on exactly that. As you deliberate after the closing of the record, Crestone will ask you to grant approval of Crestone's Lowry Ranch CAP and find the following: that the establishment of an approximate 32,000 acre Rule 314 Lowry Ranch Comprehensive Area Plan serves to protect and minimize adverse impacts to public health, safety, and welfare, the environment, and wildlife resources, and will protect against adverse environmental impacts on any air, water, soil, or biological resource in compliance with Colorado Statute 3460-106 2.5a, and will also allow for the development of oil and gas and associated hydrocarbons from the Codell, Niobrara, Greenhorn, and J-Sam formations. That the Lowry Ranch CAP will facilitate evaluating and addressing cumulative impacts from oil and gas development in a broad geographic area by identifying plans for Crestone to develop oil and gas locations within the application lands, the CAP application lands, all while avoiding, minimizing, and mitigating impacts to public health, safety, welfare, the environment, and wildlife resources in the region through their systematic planning of infrastructure location, best management practices, and centralizing and consolidation of facilities. We would request that the commission find that Crestone is entitled to the rights to be conveyed in Commission Rule 314B1 through B4 for the development and operation of the Lowry CAP. We would request that the commission grants and conveys to Crestone the rights set forth in Commission Rule 314B1, 2, and 4 for the development of operation of the CAP, and that the commission will grant and convey to Crestone the rights set forth in Commission Rule 314B5 for the development and operation of the State La Plata oil and gas location in the Lowry Ranch CAP. And then finally, we would request that the commission grant Crestone the 6-year duration for the Lowry Ranch CAP to start on the date the commission approves the application, if that's where it goes, and confirm Crestone's reservation of rights to seek extensions thereof pursuant to Rule 314C2. Thank you very much.
All right. Thank you very much, Ms. Jost, for the opening. Mr. Foote, you're recognized for your opening.
Great. Thank you very much, Mr. Chair and members of the commission. The Lowry Ranch CAP is simply not protective. It doesn't protect public health, safety, welfare, the environment, and wildlife. You've heard hundreds of community members say it. You've seen letters raising concerns from the EPA, a congressman, a state representative, the relevant local government, and a city council member from a town that's gone through it before. You've read the pre-hearing and response statements that cite concerns with a whole slate of issues. In its response statement filed with the commission, Crestone claims these concerns are just the result of STAR's, quote, fear-mongering. But it's far from that, and Crestone's discounting of community concerns outside of a markedly different tone taken today in front of you should in and of itself be an issue for this commission. What we've seen is people from all walks of life and various levels of oil and gas knowledge looking at the Crestone CAP application and realizing something isn't right about it. It's not protective. The commission's mission is to protect public health, safety, welfare, the environment, and wildlife, and this CAP application just doesn't do that, and it should be rejected. Crestone is trying to have it both ways with this CAP. On the one hand, Crestone says it has complied with all the disclosure requirements in Rule 314, and that Rule 314 just requires CAPs to show a bigger picture level planning and not get into specifics about individual locations. On the other hand, when Crestone wants to, or is required by an agency like the State Land Board. It gets into all kinds of specifics about its plans and BMPs for things like emissions and wildlife for each of its individual locations. What that has turned into is Crestone arguing that the public and the commission should just trust them when it comes to filling in the blanks later on a whole host of issues. When it comes to noise mitigation, for example, Crestone has artificially inflated the ambient noise measurements in the area, which could then lead to higher noise levels, especially during the pre-production period, which happens to be when a large number of community complaints about excessive noise come in. When that was pointed out in STAR's pre-hearing statement, Crestone's response was the cap is just for general information and they'll be more accurate when they file their individual OGDPs. But they provided no further details and basically just said, trust us. When it comes to induced seismicity concerns brought up by STAR, Crestone's response isn't to show the studies they've done to address that issue, but instead to make a general statement about how they have extensive 3D seismic testing information, but they fail to disclose details that would allow the public and the commission to determine whether the testing is really as sufficient as Crestone claims that it is. In other words, nobody can check their work. With water quality monitoring, when questioned about the adequacy of baseline testing, Crestone deflects and they say simply they'll follow Rule 615 without going into any kind of detail. Again, just trust us, they say. When it comes to a transportation plan and an overall assessment of truck traffic that will occur as a result of approved operations within this cap, Crestone says that's not required as part of the cap and they'll deal with it later. Truck traffic and the minimization of it is one of the more prominent measures of cumulative impacts, but no matter, it should be deferred until the OGDP phase, according to Crestone. Water usage is a major cumulative impact, and the operations in this cap would be using a huge amount of water with zero reuse or recycling whatsoever. But Crestone merely says they are looking into it and doing some kind of a pilot project somewhere else. However, they don't go into more detail and instead just say, trust us. Then when it comes to emergency management, and in particular avoiding a catastrophic wildfire near a densely populated area, which we all know can happen because it has happened, Crestone simply says they're working with the local fire protection agency on site-specific plans and leaves it at that. You'll hear it appears the local fire protection agency in this case seems to be in the dark as much as we are at this point. When it comes to implementing drilling setbacks from the Lowry Landfill Superfund site, as the EPA has recommended, Crestone doesn't bother to address that at all. Instead, they just say that they agreed not to drill underneath the Superfund site. But as for protective setbacks away from the Superfund site, as the EPA has recommended, apparently that's off the table with Crestone. So Crestone is very detailed in this cap until it isn't. They don't show their work or attempt to fix many of the issues. They just fall back on their argument that they'll deal with it later because the cap shouldn't be about the details. But then sometimes they produce a huge amount of details. Protecting the public shouldn't be subject to an incomplete grade to be determined later. They're either protective or they aren't across the board. And there's two main problems among others with Crestone's argument here. First, they don't actually fix their deficiencies with the individual location applications. We see that plain as day with the individual location applications they filed with Arapahoe County, particularly with the Sunlight Long location. The same problems we've seen with their cap are the same problems we see in their individual location applications filed with Arapahoe County. So they don't actually fix it, and the trust us argument hasn't held up so far. Second, it doesn't comply with the rules of this commission. It doesn't adequately address cumulative impacts, for one. Mainly, this cap is just a combination of 8 separate OGDPs turned into a cap. Crestone does not address impacts in a cumulative or a comprehensive way. It just implements measures that it would implement anyway if it filed in individual OGDPs. Not to mention, it completely offloads a large batch of cumulative impacts by allowing another operator to put a surface location with 20 additional wells within the cap boundary in the appropriately named secret stash location. You wouldn't know this by looking at all of the Crestone cap materials, but to the impacted community, those cumulative impacts are just as real as anything Crestone will talk about in this hearing. And Crestone's managed to somehow make those impacts disappear, at least for its cap application. Your decision on this cap is not simply a matter of Crestone checking all the disclosure boxes to get to yes. At the end of this, you have to decide, substantively, whether the application is protective. At the conclusion of this hearing, the commission has three choices as outlined in Rule 314H. You can either approve, deny, or stay the application. And the language in that rule is important to emphasize here. Under Rule 314H3, it says, quote, the commission may approve the cap that applies with the requirements of the commission's rules and protects and minimizes adverse cumulative impacts to public health, safety, welfare, the environment, and wildlife resources. These three separate clauses in the rule are not just three separate ways of saying the same thing. The crux of Crestone's pre-hearing statements and their opening statement here today has been they are complying with the requirements of Crestone's, or I'm sorry, the commission's disclosure rules, and therefore the cap should be approved. Even if that were the case, and Crestone had disclosed everything it needed to, that's not sufficient. Crestone doesn't meet its burden by just disclosing everything the rules explicitly require them to. Crestone also has the burden to show its cap is protective and that it minimizes adverse cumulative impacts. We get the same kind of distinction in the denial language of Rule 314H4, which says, again, quote, if the commission determines that a cap does not provide necessary and reasonable protections for or minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources, or fails to meet the requirements of the commission's rules, the commission may deny the cap. So you'll hear during this proceeding that Crestone application does not meet any of those three clauses. It doesn't protect, it doesn't minimize adverse impacts, and it doesn't meet the requirements of the rules. But mostly what we ask you, the commissioners, to consider throughout this hearing is whether this cap actually protects public health, safety, welfare, the environment, and wildlife. And what you'll hear from star witnesses in the discussion throughout is this proceeding is that it clearly doesn't. It doesn't protect. Once presented with all of that information, the commission should not approve this cap. Instead, it should deny the cap because it's not protective, or at the very least, stay the cap because Crestone has a lot of work to do to get it to be protective. So thank you, commissioners. We appreciate the opportunity.
Thank you, Mr. Foote, for the opening argument on behalf of Star. We'll keep rolling here for a bit before we take an afternoon break. We will recognize Ms. Jost again for the start of her case in chief.
Great. Thank you so much, Chair. Mr. Davenport, I saw you come on. Do you need to jump in at all?
Betcha he's wanting to swear in witnesses.
Okay.
Thank you. Yes.
Okay. So we would need to have Mr. Nathan Bennett, Mr. Dan Harrington, and Ms. Kathy Stearman promoted to panelists, please.
Hey, I believe I see all the witnesses now. I'm going to start with Mr. Bennett. If you'd please raise your hand, state your name, and say that you swear to tell the truth.
My name is Nathan Bennett. I swear to tell the truth.
Thank you, Ms. Stearman.
My name is Kathy Stearman, and I swear to tell the truth.
Thank you, Mr. Harrington.
My name is Dan Harrington, and I swear to tell the truth.
Thank you.
Great. Thank you so much, Mr. Davenport. Kelsey, if you can pull up the PowerPoint, please, on slide 26. Wonderful. Thank you so much. All right, we're going to go ahead and start with Mr. Harrington. Mr. Harrington, can you please provide your name and business address for the record?
My name is Dan Harrington, and my business address is 555 17th Street, Denver, Colorado.
Great. And what is your role with Crestone?
I am an asset development manager.
Okay. And what is your educational background?
I have a BA from Amherst College and an MS from the University of Texas at Austin in geoscience.
And how many years have you worked in the oil and gas field?
23 years.
Can you please provide the commissioners with a background on your experience with oil and gas development in the state of Colorado?
I've been working oil and gas development in Colorado since 2011 for Shell Oil, Crestone Peak Resources, and Civitas, including the Raton Basin, Sandwash Basin, and the DJ Basin.
Thank you. Can you please provide a short background on your experience with oil and gas development in Arapahoe County?
I've been working on this specific asset since Crestone's acquisition of it from ConocoPhillips in 2020.
Thank you. And can you please provide your familiarity with the Lowry Ranch CAP application that's being heard today?
Yes, I'm the primary architect of the Lowry Ranch Cab Development Plan, and I've been working on it since late 2021.
And have you been a witness in front of this commission before?
Yes, approximately 15 times.
Okay. And have you prepared exhibits in support of the docket at issue today?
I have.
And did anyone assist you in preparing these exhibits?
Yes, various subject matter experts.
And have you reviewed the final exhibits to be submitted to the commission today?
I did.
And to the best of your knowledge, are they true and accurate representations of the interest and information they purport to show?
Yes.
Great, thank you so much. Chair, we would like to move Mr. Harrington as a witness to address the Lowry Ranch CAP Development Project, Rule 314, and Crestone's operations.
You indicate he's just a witness, or are you trying to make him an expert witness?
Chair, he would be a lay witness at this point.
Okay. Go ahead.
Thank you so much. Okay, next slide, Kelsey, slide 27. With this, Mr. Harrington, I'd like to go ahead and turn it over to you to present this portion of our presentation to the commission.
Thank you, Ms. Jost, and good afternoon to the commissioners, ECM staff, and our various other attendees today. We'd like to start here by quickly running through a series of exhibits demonstrating fulfillment of information requirements of Rule 314, information maps and other documentation. Next slide, please. Thank you. The relevant local government for all Lowry Ranch CAP locations is Arapahoe County, and we have 3 proximate local governments, which are the city of Aurora, Douglas County, and Elbert County. We have provided GIS data, and completeness certification is in place for this project. And with that, we'll get into the actual project. Here we have a couple of base maps showing our 8 forward operation sites, including 1 PSA site, the State La Plata. In addition to that, the CAP does consider 1 pre-approved OGDP site at the north end, the Bierstadt, that has already been drilled, as well as some legacy sites not planned for expansion. On the right, we have the same map showing with diagrammatic well sticks up to 166 planned horizontal wells. Right up front, I'd like to address the delta between these maps and the maps submitted in the second amended post-completeness Lowry Ranch CAP submission. The differences are only in the State Blanco West and the State Sunlight Long sites. Those sites were both shifted post-completeness to comply with the latest round of 2023 Arapahoe County rulemaking, specifically to increase setbacks relative to RBUs, reservoirs, planned reservoirs, and a county DOAA. As part of this modification, we added the wells formerly planned for the State Sunlight pad onto a combined State Sunlight Long pad, reducing the total pad count by 1. Since none of these sites were submitted with a PSA request, they are subject to change prior to OGDP submittal, and those changes are consistent with Rule 314, particularly since the changes were made in response to local regulation. These sites have been in place for most of this year during our public meetings. Next slide, please. Thank you. Sorry, can we go to slide 31? Thank you. This is our CAP overview map showing the same sites. The only real difference here is you can see that the La Plata site is a different color, as it is our sole preliminary siting analysis request site. Next slide, please. Here's a similar map showing our state land board occupancy tiers. The state land board surface occupancy tiers are a requirement of the state Lowry lease and dictate where oil and gas surface disturbance may occur and where it is preferred. Tiers range from green here, preferred occupancy, to red, no surface occupancy. Note that that color bar is flipped relative to the state land board's presentation earlier today. Tiers are driven by a number of factors, including prior surface disturbance, existing structures, wetlands, and anticipated future use, in this case specifically planned reservoirs. Can we go back to the prior slide for one moment? The State Land Board have visited all proposed sites, including after the multiple rounds of revisions, and have approved each in principle. Formal SUAs will follow along the terms of the Lowry lease prior to construction. State Land Board biologists and land stewardship experts were present at 2 separate CPW site visits in 2022 and 2024, following the site revisions as well. Next slide, please. Here's the same map with surface topography contours. Topography is important, especially on the west side of the ranch, as it will provide visual barriers between sites and areas to the west of the ranch, especially for the state sunlight law. Topographic barriers are also important to setback requirements set in Arapahoe County rules relative to reservoirs. Next slide, please. Map A2 is the same map with future proposed reservoirs, which are under the control of Rangeview Metro District. These reservoirs have been planned for many years, and the timeline of development is uncertain. They are important in that they drive setbacks in the Arapahoe County rules, and our sites are in full compliance with those setback requirements. We have met several times with Rangeview to discuss our plans with them. Rangeview has already submitted comments as part of the Arapahoe County permitting process for the State La Plata and State Wetterhorn pad sites, 2 of the closest to the future planned reservoirs. Rangeview recognized that each is in a separate drainage basin from the reservoirs and over 3,000 feet distant, thus compliant with Arapahoe County regs, and Rangeview supported the county approving the oil and gas sites. Rangeview did ask Civitas for some additional groundwater and soil sampling, which we've already agreed to. Next slide, please. Okay, map B shows our planned haul routes. As you can see, 6 of the 8 forward sites will be accessed off Quincy Ave via 3 existing north-south roads on the Lowry Ranch. The 8th is accessed off Yale or Jewel to the north of the ranch. All traffic routes to Watkins Road and thence north to I-70, and it's important to note that no traffic will route through the neighborhoods to the west of the ranch. Of particular note, for the northern access route, CPW has requested in the final cap review that the haul route from the Wilson pad follow Yale Avenue rather than Jewel Road, as there is an eagle nest near the intersection with Jewel, and we have already agreed to make this change to that haul route. Next slide, please. Exhibit C is our pipeline map. It shows pipeline routing in a variety of colors. The bright green on the northern part of the ranch are existing oil and gas takeaway pipelines. Pipelines will comprise oil and gas, produced oil and produced gas takeaway for every pad site. And additionally, a produced water pipeline will be installed along the Western Ridge Road to reduce truck traffic on that road near Aurora Reservoir. That pipe will terminate at a loading site along Quincy Ave and will not connect directly to the disposal well. This recommendation was made specifically by CDPHE. We're happy to implement it. Oil and gas pipelines will connect to the Civitas-owned system in the vicinity of the state massive site, about a half a mile north of Quincy, southern terminus of that bright green line. Fresh water for completions will be transported to the sites via lay flat pipeline. Of note, the vast majority of right-of-way here is on state land board land and is generally allowed via the Lowry lease, subject to our usage limits. We're working with the state land board to establish specific right-of-ways, and will have oil and gas takeaway in place prior to production at each forward site. Next slide, thank you. This is a slide map showing existing electric utility lines. This map indicates feasibility of pad electrification. We have been in conversation on the Lowry Ranch cap with Xcel Energy since 2022, and we have already secured positive reviews to provide power to the La Plata, Sunlight Long, and Beaver sites for the drilling phase. In fact, we've already paid our invoices to have Xcel do that work. We are optimistic we'll be able to drill on grid power at those sites and likely more sites as the Xcel review process moves forward. Next slide, please. This is a slide showing electrical pad connections over the area, essentially showing the same thing as the prior slide. Next slide, thank you. Map F1 is our high priority habitat map. Here we retain the high priority habitat as mapped in 2022 when the cap was originally submitted, and it's primarily mule deer, severe winter range. In 2023, additional pronghorn HPH was established for the area. We retain the original HPH maps in place at time of filing for rule. However, we have already been working with CPW extensively on our application and are considering the 2023 pronghorn HPH in our designs. The most recent HPH maps will be used for the OGTP purposes at the time of each OGTP filing. Next slide, please. Map F3 is the same map with roads. The one area I'd like to note here is the northern extent of the Western Ridge Road. We are adopting additional BMPs per the request of CPW in Arapahoe County, where the Western Ridge Road approaches the reservoir and slightly intersects aquatic HPH. We'll get to that in more detail on a future slide. As previously mentioned, per CPW, we will plan to modify the Wilson Hall route at the northwestern corner of the map to follow Yale Avenue to avoid the Bald Eagle Nest south of Jewel Avenue. Next slide, please. Map G is a map of buildings and state designated outdoor activity area, of which there's none. Unlike other caps this commission has reviewed in recent years, the Lowry Ranch cap has a very low number of RBUs within it near its surface locations. Only 3 on the Lowry Ranch itself. Crestone has consulted and obtained informed consent letters from all 3 households within the Lowry Ranch cap boundary, only one of which is within 2,000 feet of a proposed site. Considering the neighborhoods to the west of the ranch, the closest pad is over 3,000 feet from the nearest RBU, complying with both state and the revised Arapahoe County setback needs. Next slide, please. Exhibit H shows our surface ownership. Every Lowry Ranch cap site is on state-owned land on the Lowry Ranch itself. Next slide, please. Next, we have a series of depth maps to aquifers under the ranch. These are developed from geologic databases and inform our casing plans. We can kind of just scroll through these if you don't mind. There's 6 of them. Thank you. Map J is our disproportionately impacted community map. As you can see, there is no disproportionately impacted community in the cap boundaries south of Quincy. There are no homes in the Lowry Ranch cap in DIC, and no homes in DIC within 2,000 feet of any pad site. The neighborhoods to the west of the Lowry Ranch cap are not in DIC, and the DIC adjacent to the northern cap boundary is very sparsely populated within the 1 mile cap buffer zone. There's only 1 house within 3,000 feet of the State Wilson pad site in DIC. Civitas representative have met with this household who did not object to the cap plan, and we intend to continue our outreach as the project moves forward. Next slide, please. We have a couple map Ks. These are a series of surface and public water system maps developed from public sources. K1 includes ECMC Rule 411 buffer zones around the reservoir with no site within internal, intermediate, or external buffer zones. Go to next slide, please. This is the same map, and this one focuses on streams and the reservoir itself. Next slide, please. Lastly, we have Exhibit L. This is a map showing existing operating vertical wells in the cap and the buffer area. None of the, and they're in faint blue dot format here. None of these vertical wells are Civitas operated. Quick note here, please note that the consolidated sunlight long location was not revised for this map. That was an error, and we have submitted a revised version in the backup section of this deck. Next slide, please. Thank you. So the Lowry Ranch cap is designed for up to 10 wells per lateral section in each DSU. Lateral lengths vary between 2 and 3.5 miles, with up to 1.5 miles of side sail. These long lateral lengths and long side sails are beneficial in allowing us to consolidate pads and optimize the locations of the surface sites relative to surface features. At Lowry Ranch, due to the stress field, east-west laterals are most advantageous to efficiently develop the minerals. Civitas carefully designed the development plan at Lowry Ranch to minimize surface disturbance as required by ECMC rules and in line with the guidelines of the State Land Board Lowry lease. The current development plan represents a significant improvement in mineral development per surface disturbance acre relative to prior development plans. It's about 3 times more efficient. Total surface disturbance on the ranch is anticipated to be under 300 acres, which, if you recall from this morning's presentation by the State Land Board, is about half of the Lowry lease allowance. Siting pads along existing roads wherever possible further reduces new surface disturbance acreage. As stated before, Colorado State Land Board staff have visited each proposed Lowry Ranch cap site and approved each with respect to lease terms. Slide 55, we have our nominal development schedule. This development plan is built around a single rig continuously operating in the area. This plan is subject to change pending operational and regulatory progress. Next slide, please. There were some questions about future land use on Lowry Ranch. The future surface usage of the Lowry Ranch is discussed in the 2007 Arapahoe County Lowry Range Sub-Area Plan, and which is further reflected in the Colorado State Land Board 2020 Asset Management Plan, which the State Land Board discussed this morning. Those documents show the area of the ranch south of Quincy as conservation area, not generally open to surface development beyond the current usage in State Land Board leases, which are to say ranching, oil and gas development, and certain recreational uses. The area north of Quincy is shown as potential future urban development area. In conversation with the State Land Board, as of middle of 2024, no active planning is underway to converting that land into development area. Any conversion is subject to lengthy negotiation and rezoning and is many years into the future. And of course, oil and gas operations do not preclude future development with appropriate setbacks. Next, we have a summary of road infrastructure planning. Wherever possible, we are utilizing existing roads on the Lowry Ranch surface and anticipate less than 1.5 miles of new road build throughout the entire project. Pipeline right-of-ways also generally parallel roads to consolidate and minimize disturbance. I spoke earlier of a request for additional BMPs along the Western Ridge Road. Here, we have agreed to certain BMPs along that Western Ridge Road where it is close to Aurora Reservoir. As stated, this road already exists, sitting on or close to the ridge line of the west side of the ranch. We plan to improve it to county standards to reach the Sunlight Long and Beaver sites. This road has never been and will never be open to the public. As shown, in the vicinity of Aurora Reservoir, this road will be constructed at a gradient away from the reservoir with an up-gradient berm and a down-gradient ditch. Along the entirety of this road, dust mitigation measures will be employed, and oil, gas, and produced water pipelines will be installed to minimize truck traffic during the production phase. Slide, please. As to pipeline, as stated, oil and gas pipeline takeaway will be in place prior to the start of production phase on all sites. For sites on the western edge of the ranch, Beaver, Sunlight Long, and Blanca, a limited produced water takeaway system will be installed, piping the water to a takeaway point on Quincy Ave, approximately 3.5 miles east of the western edge of the ranch. From there, produced water will be trucked to commercial disposal facilities. Of note, there are no disposal wells in the vicinity, and the latest round of Arapahoe County rulemaking proposes to ban disposal wells within the county. As stated, infrastructure planning, Civitas began consultation with Xcel Energy in 2022. To date, we have positive engineering reviews for electrification, including drilling for La Plata, Sunlight Long, and Beaver sites, and we have already paid for the upgrade work. Civitas meets with Xcel frequently, and we will continue to work with Xcel to provide power to the other sites. As with all pads in the area, actual electrification in time for drilling is depending on Xcel capacity, load, and construction timelines. Next slide. Here we have mineral interest, leasehold, and surface ownership maps. Starting on the left side, showing mineral ownership, we have majority state minerals in blue, with additional federal in green and fee in white to the west of the ranch. On the center leasehold map, Crestone holds the State Lowry lease itself on the ranch, Proceeds, as you heard this morning, proceeds from which are designated by the State Land Board to fund Colorado public schools. We've nominated certain BLM tracts for auction in 2022 and are awaiting bid schedules for the federal acreage to the west. Lastly, we have acquired additional fee leasehold to the west of the ranch. That fee leasehold comprises both larger tracts and individual residential lot tracts. Our total leasehold within the Lowry Ranch cap boundary is over 70%, and we will continue our leasing efforts moving forward. And lastly, the map on the right does show surface ownership in blue of the state of Colorado State Land Board, with all of our pad sites located on that land. With that, I will take a break and hand it over to Mr. Bennett.
Wonderful. Thank you, Mr. Harrington. Mr. Bennett, just a couple quick qualification questions for purposes of the record before you start your portion of the presentation. For the record, can you please provide your full name and business address?
Nathan Bennett, 555 17th Street, Denver, Colorado.
And can you please provide your role with Crestone?
I'm the Director of Permitting and Compliance.
And what is your educational background?
I have a BA from St. Bonaventure University and an MS from Shippensburg University in Geoenvironmental Studies.
And how many years have you worked in the oil and gas field?
Approximately 20.
Can you please provide the commissioners with a background of your experience with oil and gas development in the state of Colorado?
Certainly, beginning in late 2016, I've worked the DJ Basin from both the regulatory as well as the subsurface planning disciplines.
Wonderful. And can you please provide a short background on your experience with oil and gas development in Arapahoe County?
Beginning in late 2019, I have overseen the permitting of projects in Arapahoe County.
Wonderful. And can you please provide your familiarity with the Lowry Ranch CAP application being heard today?
Yes, I was involved in the preparation of the Lowry Ranch CAP application.
And have you been a witness in front of this commission before?
Yes.
Approximately how many times?
Approximately 24.
And have you prepared exhibits in support of the docket at issue today?
Yes, in accordance with certain subject matter experts.
Wonderful. Have you reviewed the final exhibits to be submitted to the commission today?
Yes, I have.
And to the best of your knowledge, are they true and accurate representations of the information and interest they purport to show?
Yes.
Thank you so much. Chair, again, I'd just like to move Mr. Bennett as a lay witness to address regulatory process, procedures, and protections relating to the Lowry Ranch CAP and Crestone's operations solely for purposes of making a record.
Very good. Go ahead, Mr. Bennett.
Thank you, Chair.
Thank you. Thank you, Ms. Jost. Good afternoon, commissioners. Crestone carefully evaluated potential impacts to key resource areas, including air, water, ecological resources, and communities within the CAP. One of the benefits of this cumulative impact assessment was the identification of strategies that can be implemented before, during, and after development to reduce potential impacts to these key areas and foster best management practices to reduce the cumulative impact in the CAP through avoidance, minimization, or mitigation measures. The evaluation of potential cumulative impacts was undertaken using widely accepted scientific methods, including those employed or prescribed by governmental agencies such as the United States Environmental Protection Agency and the Colorado Department of Public Health and Environment, among others. In addition to performing calculations in accordance with valid scientific test methods or procedures, air monitoring data from Civitas operations were used as a basis for comparison between calculated emissions data and real emissions data from the same operations in the same field. Lastly, a series of existing data were used during Crestone's cumulative impacts analysis, including baseline water quality data, wildlife data and associated mapping, and natural resource reports. Much of this information was collected via boots-on-the-ground surveys, and observations were made over the course of the last several years, enabling a forward-looking approach to avoiding and minimizing impacts.
Wonderful. Thank you, Mr. Bennett. Chair, we'd like to bring up Ms. Kathy Stearman to address the air emissions portion of our cumulative impacts analysis. Ms. Stearman, thank you. Same questions to you for a minute, just for purposes of the record. Can you please provide your full name and business address for the commission?
Name is Kathy Stearman and address is 555 17th Street, Denver, Colorado.
And what is your role with Crestone?
I am the Director of Air Programs.
And what is your educational background?
I have a BS in biology from Missouri Southern State College.
And how many years have you worked in the oil and gas field?
25.
Can you please provide the commissioners with a background on your experience with oil and gas development in the state of Colorado?
Yes, it began as a consultant for large and small operators, and then took me through a lot of the air rulemakings in early mid 2015 and on.
Wonderful. And can you please provide a short background of your experience with oil and gas development in Arapahoe County?
Yes, I've been called in to assist with subject matter topics that pertain to air, whether it's monitoring or new regulations.
Great. And can you please provide your familiarity with the Lowry Ranch CAP application being heard today?
Yes, I have been involved since approximately 2019 and was part of the rulemaking review for Arapahoe.
Wonderful. And have you been a witness in front of this commission before?
Yes, approximately 5 times plus.
Wonderful. Have you prepared exhibits in support of the docket at issue today?
Yes.
And did anyone assist you in preparing these exhibits?
Yes, subject matter support from outside consultants.
Great. And have you reviewed the final exhibits to be submitted to the commission today?
Yes.
And to the best of your knowledge, are they true and accurate representations of the interest and information they purport to show?
Yes.
Wonderful. Thank you. Chair, once again, and for the final time, we would like to just confirm Ms. Stearman is a lay witness for purposes of addressing air emissions and Crestone's operations under the cumulative impacts analysis submission.
Very good.
Thank you so much. Ms. Stearman, go ahead and take it away for purposes of your slides in support of our CAP application.
Thank you, Ms. Jost. Civitas has submitted a couple of revisions to the CAP emissions that followed changes in the development plan. That first cumulative impact report was in September of 2022, and then a resubmission was filed in April of 2023, and that was best to reflect the changes in the project. The project's undergone even more refinement and pad consolidation, and we can now actually pinpoint, like Dan Harrington said, where we can drill some of these pads on line power. So this slide is depicting the delta in the NOx and the CO for the 11-year duration, because we're drilling 4 of those original 12 pads on high line power, and because anything that's not on line power will be drilled using generators that meet a Tier 4 standard or better by using natural gas. So as you can see, those modifications to the drilling program have reduced the NOx by 63% over the 11-year duration, and the CO emissions have been reduced by 14%. We received a public comment that reminded the commission that we are required to adhere to the new rules that may require enhanced modeling and monitoring. So of course, we wouldn't perform dispersion modeling as early in the process as when we performing the cumulative impact summaries, because we really want to hone in more on the details of a project before we set up a dispersion model. But now that we are honing in, we can predict that modeling will in fact be required for all of the Lowry Ranch well pads as lined out in this table. Either the thresholds to perform modeling are going to be triggered by the permit modeling unit, or the permit modeling unit's requests when a facility is in a DIC or a CIC. So as you can see, every proposed pad in the Lowry CAP will undergo a NAAQS, or a National Ambient Air Quality Standard modeling exercise for NO2. This is a slide where 2 things are true. Civitas has reduced greenhouse gas emissions in Colorado during a year with a 3% increase in Colorado oil production. Our publicly disclosed target was to reduce Scope 1 greenhouse gas emission intensity by a fixed 2.5% annually, averaged over 10 years. We achieved that goal early, and we've marked it complete in 2023. These are Colorado greenhouse gas reductions, which is a 42% reduction you can see here in methane, and a 20% reduction in CO2 equivalents. I want to point out that this data is reported into the EPA through the EPA Subpart W onshore petroleum and natural gas production reporting platform. The EPA prescribes how we report the data, and it prescribes what sources are reported, and it ensures consistent reporting across basins and across companies through those prescribed methods. So Civitas is a company of mergers, but we now have some really good consistent data for the last 2 years, which allows us to make these comparisons and makes the data meaningful. These data are reviewed by outside technical experts. We have consistency now within the company with the people who collect the data, who report the data, and who QC the data. And anyone can look this data up through the EPA flight platform, which is where the data is published. I also want to point out that this data undergoes a rigorous QC through independent consultants, and you actually could check the work on this. We wanted to show the truck hauler emission savings resulting from the installation of oil and water pipeline within the development area. For reference, we use the EPA MOVES model to calculate these emissions. The oil pipeline will eliminate the need for trucks to transport oil, equating to 6,552,755 less miles traveled over the course of the first 3 years. The additional intra-development water transport between State Blanca West, State Sunlight Long, and Beaver will eliminate 327,212 miles traveled. This graph shows the tons of NOx and greenhouse gas emissions that will be saved with that infrastructure. We use 3 years here because that's the truck and mile count that goes in with the reporting process, but the emission benefit will continue for the life of the wells because these are permanent installations. And finally, just reiterating the effect of the pipeline and takeaway infrastructure and how that will have an effect on the development program. The oil pipeline is eliminating over 200,000 truck trips from the project for the first 3 years. So at about 28 miles per trip, this equates to over 6 million miles less traveled. The water takeaway system eliminates over 300,000 miles traveled for the first 3 years as well.
Wonderful. Thank you, Ms. Stearman. Mr. Bennett, I'd like to go ahead and turn the presentation back over to you.
Thank you, Ms. Jost. Over the course of the next several slides, you will see the various best management practices Crestone has committed to throughout the CAP process. In many instances, these BMPs were agreed upon during agency consultations and are consistent with Crestone's standard operational procedures. For example, more than 30 BMPs were incorporated into future Lowry Ranch development following consultation with the Colorado Department of Public Health and Environment. Crestone contracted HWA Wildlife Consulting, a third-party wildlife consulting firm, to assess the Lowry Cap area for sensitive wildlife receptors and aquatic features. HWA has been conducting annual surveys at Lowry Ranch since 2012, resulting in the most extensive data set of wildlife activity on this property. This data has been provided to the State Land Board and Colorado Parks and Wildlife. HWA has also conducted site-specific surveys for each proposed location in the CAP. According to CPW, quote, between HWA's studies and CPW's wildlife knowledge, this is one of the most extensive wildlife data sets of any oil and gas consultation in CPW's Northeast region, end quote. Crestone has conducted several consultations with CPW as part of this CAP preparation process. Crestone and CPW conducted site visits in September 2022 and April 2024. We met virtually in May and June of 2024 and have exchanged dozens of emails. CPW will also continue to be involved in this OGDP preparation process for each location in high priority habitat. It should be noted that much of this area was not designated as high priority habitat when the application was filed in October 2022. U.S. Fish and Wildlife Service was also included in the consultation process. CPW engaged Fish and Wildlife in March 2024 regarding the Preble meadow jumping mouse, a federally and state listed species that was a subject of concern for some community members. Crestone is implementing several overall BMPs in this development. First, Crestone is proposing to use the existing pad in this area for the first proposed location, the State La Plata pad. Crestone will prioritize avoidance of development operations during sensitive wildlife seasons when possible. When applicable, Crestone will also apply minimization measures, including the use of sound walls to reduce noise and light impacts, and the use of pipelines to reduce truck traffic. Crestone will pay compensatory mitigation fees to CPW to offset direct and indirect impacts to wildlife. Additionally, Civitas is actively having discussions with CPW and the State Land Board about the possibility of a wildlife mitigation project to offset the impacts to HPH for one of the future OGDPs. As a general practice, Crestone provides wildlife education training to staff through annual presentations, team-specific trainings, and various seasonal refreshers. Last but not least, Crestone will continue to consult with CPW through this process and use HWA as a third-party subject matter expert to conduct surveys and provide guidance. 5 of the 8 proposed locations overlap a pronghorn winter concentration area high priority habitat. 2 of the 8 proposed locations overlap a mule deer severe winter range high priority habitat. Initially, the state Blanca pad overlapped this HPH also. However, in working with State Land Board staff, Crestone was successfully able to relocate the pad outside HPH, although the existing access road that will be used for this location remains within that habitat. 2 locations are completely outside of any HPH. Seasonal avoidance will be implemented whenever possible as these locations are developed. Compensatory mitigation fees will be paid to CPW to offset impacts. Sound walls will be installed where necessary to reduce noise and light impacts. The existing roads in the ranch are being used for main access to reduce surface disturbance and reduce further habitat fragmentation. Crestone will use a water takeaway pipeline for some locations and oil and gas takeaway pipelines for all locations to reduce truck traffic throughout high priority habitat. Crestone is not proposing any pad locations within CPW's recommended buffer zone around any known active bald eagle nests or within any other CPW mapped nest site high priority habitats. HWA has a very thorough record of nesting history in the CAP area, and this data was thoroughly reviewed by Crestone and CPW. The main concern identified and discussed with CPW was the potential presence of burrowing owls near the Wetterhorn Sandy's pad due to historic documentation of owls occupying that area. However, there has been no burrowing owl occupation of this prairie dog town during the last 2 breeding seasons in 2023 and 2024. The last documentation of owls in this particular habitat was 2022. Additional nesting surveys, including burrowing owl surveys, will be conducted prior to construction based on applicable seasonal timeframes. Based on those field surveys, if it is determined that a location is within the species-specific CPW recommended buffer zone around a nest site, a CPW consultation regarding appropriate next steps will occur. BMPs may include maintaining a buffer zone around a particular nest site, delaying activities, having a biologist with stop work authority on site to monitor wildlife response to activity, or other appropriate BMPs recommended by CPW based on site-specific conditions. The swift fox is listed as a special concern species in Colorado, which is not a statutory category. However, Crestone assesses for potential impacts to den sites when operating in swift fox habitat and complies with CPW recommendations to protect active den sites. HWA has extensive data on swift fox den sites and swift fox presence throughout the Lowry area. There are no known active den sites within a half mile of any proposed location. HWA will continue to collect swift fox data prior to construction. If any new active den sites are identified near a proposed location, CPW will be consulted and appropriate BMPs will be implemented. The Preble's meadow jumping mouse was a subject of concern for community members, especially in relation to the Aurora Reservoir. This species, is a federally and state-listed threatened species. CPW and U.S. Fish and Wildlife both concluded that they do not have concerns about this species being impacted by this project. Fish and Wildlife further noted that they do not typically see this species associated with reservoirs and ponds, and that the CAP is located immediately adjacent to a mapped, quote, block clearance zone, end quote, for this species. Additionally, the proposed development complies with the county setback requirement for Aurora Reservoir. The northern leopard frog was another subject of concern for community members. Similar to the swift fox, this species is neither endangered nor threatened, but it is listed as a special concern species in Colorado. HWA surveyed for northern leopard frogs throughout the Lowry area in 2012 through 2015, again in 2018, and again in 2024. They identified northern leopard frogs in multiple drainages, including Black Shack Creek. Crestone discussed these findings and appropriate BMP options with CPW. As a result, Crestone is committing to conducting construction of the Black Shack Creek crossing associated with the beaver pad between November and February, which is outside the northern leopard frog sensitive season. Furthermore, there was concern about oil and gas vehicle traffic impacting potential dispersing frogs. The main access routes will be via existing roads on the ranch, which are already consistently traveled by other land users. Following the U.S. Army Corps of Engineers wetland delineation protocols, wetland delineations were conducted by qualified wetland scientists to determine the boundaries of these sensitive habitats. There is no proposed disturbance to any wetland or waterway as part of this cap. The proposed road crossing at the Beaver location will be via bridge structure and will not require any alterations to the creek or fringe wetlands. As discussed before, this construction will occur outside the sensitive northern leopard frog season, consistent with CPW recommendation. Stormwater and erosion controls will be installed at each location to further protect the surrounding habitat. We would like to thank CPW and State Land Board teams for their time visiting these locations and providing valuable input, and U.S. Fish and Wildlife Service for their feedback on the Prepples meadow jumping mouse. We would also like to thank the local community members for their questions and feedback regarding wildlife species in this area. As a direct result of your questions and feedback, our team ordered additional wildlife field surveys, engaged in additional agency consultations, and implemented additional BMPs. We are dedicated to being good stewards of the land and responsibly coexisting with the wildlife that live around us. BMPs have been established for and will be implemented in all phases of development, including pre-production and production operational phases. There are several BMPs that undoubtedly apply to all oil and gas locations in the CAP. The locations have been cited to avoid residential building units as demonstrated throughout the presentation today. Furthermore, locations have been consolidated wherever possible. Our development is generally aligned in existing corridors, which in turn provides for fewer miles of access roads and pipelines. Commitments have been made to address the potential for spills, the protection of topsoil and water resources, as well as the minimization of dust, odor, and light intrusions. Crestone has also taken steps to reduce potential impacts resulting from sound propagation during operations. These BMPs include, but are not limited to, continuous sound monitoring in accordance with Rule 423 at all locations, regardless of whether or not there is a residential building unit within 2,000 feet. Utilization of a quiet completions fleet during hydraulic fracturing operations, and the electrification of permanent production facilities wherever possible. Further, Crestone will utilize sound walls at all locations to minimize the likelihood of impacts to nearby residents. Final reclamation will be done in accordance with ECMC rules and guidance provided by the State Land Board to ensure these activities are aligned with the Lowry Ranch management guidelines. Crestone's parent corporation, Civitas Resources Incorporated, has implemented company-wide best practices for forecasted ozone action days, including but not limited to reducing ozone season commuter traffic through various telecommute policies. Following completeness determination, Crestone received a number of comments around the potential for increased wildland fire risk as a result of our proposed development. Crestone has safety policies in place to reduce the potential for ignition events and employs site construction practices to reduce fire potential. More importantly, Crestone continues to work with Bennett Fire and the Arapahoe County Office of Emergency Management for the development of site-specific fire mitigation plans in accordance with local permitting requirements. I will now ask Ms. Jost to introduce the next session of our presentation.
Ms. Jost, before you do that, because this is quite a bit of information, I think it would be great to take a bit of a break. Let the commissioners and everyone stretch out and take care of business, etc. So let's take a break. Let's return at 10:50. That's a little more than 10 minutes.
Thank you, Chair.
All right, this is the Colorado Energy and Carbon Management Commission. It is July 30th. It is 2:50. We will continue docket 221000282, Lowry Comprehensive Plan. Ms. Jost, your next witness.
Thank you, Chair. Mr. Harrington, I'd like to go ahead and turn it back to you to wrap up this portion of our presentation.
Thank you. We would like to address briefly our single preliminary siting analysis approval site, the State La Plata South, and we'd like to run through several exhibits here outlining the ALAs we looked at. As we stated before, we did look at several alternative sites for the La Plata OGL location. The original siting was picked specifically because it is an expansion of an existing oil and gas location. It is in the preferred State Land Board tier it sits along an existing road and it already has gas pipeline connection. So with that, we can kind of run through some of the ALAs if that's all right. Go to the next slide, please. Here's a map of the ALAs we considered. The proposed site location is in pink, and the ALA sites are in red. Two of those sites, the 1A and the 1B at the east and the west, would pair together to accomplish the same development as a single site. That's going to be a major knock against them in the ALA, as you'll see in a moment. And then we have 3 other alternative central sites. If you don't mind going to the next slide, please. All right, we did consider a site close to the proposed Blanca location. This site was rejected because it would not be capable of developing the eastern DSU. It would have to be paired with ALA site 1B. Next slide, please. This is the State La Plata ALA drawing 2. We considered this site slightly north along the central road. This site was rejected because it doesn't solve the HPH issue with the desired La Plata site, and it would represent a new oil and gas location rather than expansion of an existing location. Next slide, please. Here's a site further to the east. This site was rejected due to it being a new oil and gas location rather than an expansion and requiring a long access road crossing 2 potential wetlands. Next slide, please. Here's location 1B. Again, this pairs with the 1A. This site is located far to the east near the EL location. This site would have to be paired with the 1A to do the development. It's thus inferior to the centralized site. Next slide, please. Here's alternate site ALA 4. This is similar to site 3 in that it is a new site, not a site expansion, and will require a long new access road. This site is also outside of state land board preferred usage tiering, unlike the preferred site. Lastly, on the State La Plata oil and gas location, we would like to talk about our neighbors. As stated before, there are 3 RBUs on the entire Lowry Ranch proper. 2 of them are in relative proximity to the La Plata site, one just under 2,000 feet, one just over 2,000 feet. These sites are occupied by the tenant ranchers, and they have all signed informed consent letters here. We communicate with these individuals on an ongoing basis. Next slide, please. Here we'll run briefly through ECMC consultations as reported in the director's recommendation. ECMC here acknowledges a consultation with Arapahoe County, which is the RLG on the Lowry Ranch CAP. A meeting took place between ECMC and Arapahoe County on June 20th, and Arapahoe County confirmed during that meeting that the new Sunlight Long met setback requirements. Civitas was not invited to or present at that meeting. Next slide, please. In this paragraph, the ECMC staff outlines a consultation with the city of Aurora. At this consultation, Aurora indicated appreciation of the late Sunlight Blanca move, which moved to improve setbacks from Aurora facilities, and that their concerns with that site have been alleviated. Aurora also reviewed the changes to State Sunlight Long. Aurora indicated no geologic concerns related to the Aurora Reservoir Dam or seismicity there too. And lastly, Aurora did request certain COAs, including additional water testing wells, sound walls on pads near residences, and utilization of electric power for drilling rigs. We'll get into our responses to those the COAs a little bit later. Next slide, please. There were minimal or no comments from Douglas County, Elbert County, or the city of Denver, other PLGs. Next slide, please. ECMC also met with CPW. Discussions covered CPW's consultation with Crestone, including 2 field visits to the Lowry Ranch CAP sites, and expressed certain areas requiring additional attention by Crestone. CPW will consult further on individual OGDPs. Next slide, please. ECMC met jointly with CDPHE and Crestone this spring. Certain BMPs were requested, which Crestone agreed to. CDPHE will also consult further on individual OGDPs. Next slide, please. ECMC met with the EPA in summer of 2023. As a follow-up to this meeting, EPA requested shortening of wellbores to avoid penetrating under the Superfund site, supported by the BLM who control the minerals of the Superfund site. Crestone agreed to that wellbore shortening. This agreement was clarified in April 2024 to avoid penetration under the small part of the Superfund site in Section 31. And we'll show a map of this a little bit later. As legacy contamination at the Lowry landfill Superfund site is limited to the very shallow subsurface, the proposed Lowry Ranch cap wells will be at minimum 7,000 feet distance from the Lowry landfill contamination zone. Next slide, please. ECMC consulted with the BLM on federal minerals within the Lowry Ranch cap. BLM noted multiple tracts in the area, and we'd like to take a minute to present an overview of those tracts to clear some questions. Next slide, please. BLM identified minerals fall into three categories in Lowry Ranch cap. We have what we'll call regular BLM minerals in sections 31, 32, and 6 here in yellow. These minerals have either been cut out of the cap, section 6, the Superfund site, or have been nominated for lease. These were nominated again in 2022, and we are awaiting the bid date. There are also within Lowry Ranch cap what we're going to call federal municipal minerals. Those are BLM minerals under incorporated municipalities that are not open for leasing. These comprise parts of section 17, 4, 9, 18, and 8. Civitas is planning to work with the BLM to determine solutions for working around these tracts, potentially unperforated traverses above the mineral zone. Next slide, please. Lastly, the BLM did identify certain tracts for which Crestone holds verified title, showing no current BLM ownership. In most cases, the BLM did own parts of these tracts in the past, but have since ceded that control. Crestone has provided titles to the BLM and will continue to work with them to resolve these title issues. Next slide, please. Next, I'd like to run through our history of public and external consultations with stakeholders. This is probably can't read this. This is a non-comprehensive list of the external consultations Civitas has had with local, state, and federal governmental agencies and other stakeholders over the course of the past 2.5 years. On it, we see the Colorado State Land Board, the ECMC, CDPHE, CPW, BLM, and EPA, Arapahoe County, City of Aurora, City of Denver, Mile High Flood District, and SEMSWA, offset operators and utilities, and individual citizens and citizen groups. The vast majority of these are multiple consultations each. Next slide, please. Here's a quick overview of some of our community outreach. The Arapahoe County regulations require site-specific neighborhood meetings for each pad site, and our Arapahoe County permitting process has been proceeding in parallel with the CAP. After the 2023 rulemaking, the notification list for those meetings was expanded to 1.5 miles from the working pad surface. We have completed these meetings for all 8 sites. Additionally, we held a Rule 314 community meeting this spring, to which we invited all 5,900 interested parties. And we have had hundreds of individual touch points with stakeholders via email or phone conversation, and we maintain a project website. Next slide, please. Exhibit X is a summary of outreach that was submitted with the application. I don't need to read through this, but it is in our filing, and this is a continuation of Exhibit X. Lastly, a quick overview of our 314 F3 informational meeting. Invitations were sent out, as I said, to over 5,900 individuals. 109 individuals attended all or part of the informational meeting. During that meeting, we presented on the Lowry Ranch CAP and then responded to pre-submitted and live questions. All questions were addressed at the meeting or shortly thereafter. A summary of this meeting has been submitted to the ECMC. This meeting was held virtually to provide ease of access and to ensure sufficient room for all parties. Next slide, please. We have a number of letters of support filed for the Lowry Ranch CAP. These include letters from an Arapahoe County resident who lives within 2,000 feet of a site we developed in 2022. Pure Cycle Corporation, associated with Rangeview Metro District, controller of the planned reservoirs B and C. Bennett Watkins Fire and Rescue, the primary emergency response department for the entire Lowry Ranch, as well as offset operators and other community partners. Next slide, please. You've already heard from Crystal Caranda, the mineral director of the Colorado State Land Board. This is the letter submitted from the Colorado State Land Board to Arapahoe County Board of County Commissioners in 2023, outlining the Colorado State Land Board's mission to generate revenue from state land to the benefit of Colorado public schools. This letter also notes Colorado State Land Board's requirement of lessees to comply with federal, state, and local regs, in addition to the State Land Board's own stringent stewardship requirements. Next slide, please. Civitas also held an open house in February with emphasis on the 4 sites most proximate to neighbors. Invitations to this event went out to all residents and owners within 1.5 miles of those 4 western sites, nearly 2,400 individuals. This meeting covered both site-specific plans for these sites as well as cap-wide materials. And there's an image here of that meeting. We did receive numerous individual public comments as part of the 314 process, over 100 in the initial submittal period. This is a map of the addresses of the public commenters were discernible, received prior to the public comment period ending in early May 2024. Approximately half of these comments were from individuals in the Arapahoe County Aurora area, and approximately 1/3 were from individuals in the same zip code as the proposed cap sites. Next slide, please. As referenced in the director's recommendation, additional public comments were received via bulk PDF uploaded to the portal, and some additional public comments were logged after the public comment period ended in May. Crestone has reviewed all comments, and responses will be addressed in this presentation. Here's an accounting of direct stakeholder engagement, including email, phone, and public comment question versus during neighborhood meetings. All direct contacts, whether via our email hotline or our phone hotline or direct emails, were responded to in turn, and meeting questions were addressed live or shortly after the neighborhood meeting. Of note, a significant portion of these comments, at least 1/3, regarded a desire to enter into lease negotiations with Crestone. All right, here I'd like to talk about a comparison of Arapahoe and ECMC reservoir setbacks, as well as the status of our permitting progress at Arapahoe County. So looking at the left table first, there are a couple of tables in the slide. On the left, we have a comparison table between the new Arapahoe County reservoir setback rules, which are 1 mile in general, with an administrative waivers down to 3,000 feet if an operator can show topographic barriers between sites in the reservoir. These are contrasted with the ECMC setback rules, which are significantly more lenient, maxing out at 1,000 feet. For all proposed Lowry Ranch cap locations are compliant with both Arapahoe and ECMC reservoir setback rules at present. On the right, you'll see a summary of the progress of the individual pad permits at Arapahoe County. 4 of the 8 permits have been submitted and are working through the Arapahoe County review process. By design, that's a multi-phase review with revisions. Every pad goes through that process. Of the 4 that have been submitted, no basis for denial has been identified. We're happy with the progress. I want to thank Arapahoe County staff for working on this with us. Lastly, I'd like to take this opportunity to address some comments made during the 7:15 public comment meeting by Arapahoe County and the City of Aurora on the pending applications. So there were some questions about fire mitigation. Crestone is working closely with Bennett Watkins Fire and Rescue and other neighborhood emergency response agencies. Bennett Watkins Fire has committed to reviewing the site-specific fire mitigation plans for each site. Bennett Watkins Fire issued a letter in June of this year on the Lowry Ranch Cap project in general to the ECMC, in which they acknowledged Crestone's engagement and satisfaction with our general mitigation measures and commitment to safety and further engagement. The mitigation measures discussed include removing vegetation around pad sites to create fire breaks, centralizing engines and idling vehicles away from pad edges, developing emergency response plans, and providing training to Crestone staff. It's important to remember that per Arapahoe County regulations, Bennett Watkins Fire must agree with our proposed plans and mitigation measures in writing prior to local permit approval. Otherwise, the permit will not be approved. I'd also like to address the request for an ALA for the Sunlight Long pad. Crestone has discussed Arapahoe County's suggestions on further modifications to the Sunlight Long pad with the Arapahoe County LGD. We're happy to review some slides outlining those proposed changes later, but the short answer is the proposed move isn't feasible for several reasons. The current Sunlight Long siting is the fourth location picked specifically for compliance with state and revised local regulations, and by no ECMC rule triggers an ALA. Therefore, Crestone volunteers to interface further with the county on this siting, but would prefer not to commit to an ALA at present. We also had a request for air quality monitoring and groundwater quality monitoring from both Aurora and Arapahoe County. We are aware that the Arapahoe County is moving forward with a 2024 phase of rulemaking that will include air quality monitoring, groundwater quality monitoring rules. We would suggest awaiting the conclusion of that process rather than committing to specific AQM and GWQM plans here, aside from what is already required in local and state regulation. We had a request for additional spill mitigation, dust mitigation, and pipeline installation along roads. As discussed some slides ago, in slide 58, Crestone has already agreed to these measures. Sound walls, Crestone is committing to sound walls for all sites within 1 mile of the Aurora residences, so notably Sunlight Long, Beaver, and Blanca. On rig electrification, Crestone is committing to seeking and installing grid power for the drilling phase at every Lowry Ranch Gap site. That commitment is subject to Excel capacity, load, and operational capability. Lastly, there was a COA request for compliance with Arapahoe County rules. Compliance with Arapahoe County rules is a requirement of all operators in the county, and we don't see a need for a specific COA as relates to this. Next slide, please. I'd like to run through a few slides talking about the evolution of the Lowry Ranch Cap, both to make everyone aware of why we made the changes we made and what they were triggered by. So this is an overview. The Lowry Ranch Cap has obviously been in planning for over 2 years and has undergone multiple changes in response to stakeholder feedback, regulations, and other factors since the original submittal in October 2022. This slide is an overview of those changes, which comprise both boundary and pad siting changes, and we'll get to those in detail as we move forward with the slides. Let's jump to the next one, please. Specific to the Lowry Ranch Cap boundary, we've made several modifications. The changes on the east side, First Amendment, were made prior to the April 2023 filing, and these include removal of Section 1, which was an ECMC requirement as part of the Alamosa OGDP approval. Removal of Sections 15 and 16. That was made on request of staff, it being a DSU that was already developed by an offset operator. And then we pulled out 8 sections on the southeast corner of the cap. Within these sections, majority of leaseholds actually held by another operator who did not want to be included in our cap, so that they have their own development plan down there. Changes to the boundary on the west side were made as part of the January 2024 Second Amendment filing, and these include removing the bulk of the Superfund site in Section 6 and associated fed minerals, as well as removal of parts of Sections 16, 17, and 18, driven by the southward shift and consolidation of the state Sunlight site and removal of certain federal municipal tracts. Next slide, please. This is a detail of the changes made around the Superfund site. As you can see, no well will penetrate under the Superfund site, including in Section 31, as we committed to. All surface locations are over 2.5 miles from the Superfund site, and all well bores in the vicinity of the site are located at a depth of 7,500 feet in the Niobrara Formation. It's important to note that when we normally think about subsurface setbacks, For example, when it comes to DSU and drainage, we're considering setbacks versus formation at approximately the same depth. Here, the proposed Niobrara wells will sit at least 7,000 feet deeper than any legacy contamination at the Superfund site, providing an ample vertical setback from the area concern. It's important to think about this in 3 dimensions, in other words. Next slide, please. Next, I'd like to talk about the modifications we've made to the State Sunlight and State Long sites. This is a very busy slide, and I apologize for this. But let's start with the State Sunlight site. The original location was significant, marked by the red 1, was located significantly closer to Aurora Reservoir and homes, albeit across the topographic barrier and complying with ECMC rules in place at the time of the filing. Sunlight was first shifted east to Site 2 in the April 2023 filing in response to stakeholder feedback that it was too close to the reservoir. It was further shifted slightly south in response to the first phase of the 2023 Arapahoe County rulemaking to improve reservoir setbacks, and it was shifted again after the final Arapahoe County rulemaking in November 2023 to Site 4 to establish a full 1 mile setback from planned Reservoir B, which you can see in teal in the northeast corner of the map. This new site still maintains a 3,000-foot setback from RBUs, County DOA, and 3,000-foot setback from Aurora Reservoir across a clear topographic barrier. If we look at State Long in blue, State Long version 1 is marked via blue circle. That was shifted east to Site 2 in April 2023 in response to stakeholder feedback to improve setbacks versus RBUs. And it was modified again in late 2023 to establish a full 3,000-foot setback from the RBUs and County DOAA to the west. As part of this consolidation, and driven by the limited available land, total well count for the consolidated pad site dropped from 40 to 32. This combined site is significantly topographically lower than the road and from the ridge to the west, which will provide a visual barrier and a topographic barrier versus the reservoir. Further eastward movement, as you can see, is constrained by the State Land Board non-surface occupancy zone in red, in addition to other topography, riparian setbacks driven by Arapahoe County rules, and limitations to the length of our horizontal wells. And we have some more detailed slides about that a little bit later. Next slide, please. Here we have the State Blanca site location. The original State Blanca site, here marked in 1, was consolidated on a State Land Board preferred surface occupancy zone in green. However, it was within 2,000 feet of the City of Aurora DOAA surrounding the Aurora Reservoir, as well as within Mule Deer HPH. As part of our final Lowry Camp Ranch filing, we shifted this pad northeast. The advantages here is that we maintain now a 2,000-foot setback from the City of Aurora DOAA, as well as move the site entirely out of Mule Deer HPH. The City of Aurora has issued a letter supporting a 2,000-foot setback from the DOAA in this case. Next slide, please. Lastly, we have changes made to the Beaver site. Beaver version 1, marked with the green 1, was the original siting. We moved that in advance of the April 2023 filing to improve setbacks from RBUs to the west. This new site is actually better positioned relative to some wetlands near the old site as well. Next slide, please. All right, a lot has been made out of Lowry Ranch Cap potential for seismicity. We'd like to go into this for a few slides here. Next slide, please. We got some direct questions from ECMC staff on seismicity. We'll get into some of the exhibits shortly, but specific to the question, yes, Civitas has licensed high-quality 3D seismic data over the project area. The geology, both stratigraphy and structure in the area, is similar to the geology in the Box Elder Cap to the north, as well as to the DJ Basin in general. Thank you. There are some concerns about a couple of geologic factors. Again, another busy slide, if you don't mind me running through this. It's important to note, the questions are really whether hydraulic stimulations in the Niobrara Formation could potentially contaminate aquifers, surface waters, or directly damage surface features via rupture through the intervening geology. And the second question is whether stimulation can trigger earthquakes. We'll get to seismicity in a couple of slides, but I'd like to address the idea of direct fracturing here. Short answer is this is not a risk in the DJ Basin. Here we have a cross-section across the project area. You can see the surface, the aquifer intervals marked in white letters, Denver, Arapahoe, and Fox Hills, and a horizontal well. We've overlain on the well down in the horizontal fracturing zone to scale actual well fracturing events measured in 3D via a high-quality microseismic survey nearby. As you can see, the rock-breaking events induced by hydraulic fracturing are confined to within hundreds of feet of the wellbore. Simple physics constrain these fractures. We have over 9,000 psi of pressure from the overlying mile plus of rock working against the fractures. Further, we have over a mile of the Pierre Shale Formation, a mudstone-rich interval with a particularly ductile lowermost member, the Sharon Springs, that also constrains fractures. Lastly, empirically, we know that there are tens of thousands of horizontal wells throughout the DJ Basin, including over 130 drilled and fractured recently in the Box Elder Gap, immediately north of Lowry Ranch. There is zero evidence of hydraulic fracture rupture to aquifers or to the surface for any of these wells, and there is zero evidence that the geology at Lowry is somehow more conducive to such events relative to the neighboring townships or the DJ Basin as a whole. All right, now we'd like to address seismicity. In an attempt to mitigate some concerns, and on the request of the city of Aurora, we conducted a surface vibration study this spring. This study was done in conjunction with the hydraulic stimulations of the Chico Watkins South Pad, 1/3 of a mile north of the Lowry Ranch Cap boundary. Here, we set out 4 sensitive triaxial accelerometers designed to detect seismicity over the fracture area. 2 sat about 1 mile apart along Watkins Road, and 2 more sat about 1 mile east out in the fields. All were recording during hydraulic stimulation of the wells of the Niobrara immediately underneath, and were left recording after the job was finished to provide a control period. And you can see there a photo of what one of those the accelerometers looks like. Next slide, please. Here are the results. The short answer is the surface sensors didn't detect any appreciable differences between the test period and the control period. We've got 3 plots here. They show a time series for each of the 4 sensors. So for the 4 rows are the 4 sensors, and the 3 plots are 3 different time periods. I'd like to start with the one on the right to calibrate you. It's a little bit difficult to see on this slide, but the y-axis on the slide is actually zoomed out 100 times the middle and left plot. And that's why the baseline is such a flat line here. You'll see that there is minimal signature except for 5 spikes. These spikes are a jump test. That's literally me jumping up and down a few feet from one of the sensors. As you can see, by a factor of nearly 100, that's the biggest vibration we saw from this sensor, either during the control period or during the fracturing period. Next, I'd like to compare the leftmost set of signatures to the middle set, the left set being the test period, the middle set being the control period. You can see a few noise signatures on 2 of the plots still in the left set, near sensors 101 and 102. Again, I want to remind you, these are 100 times less magnitude than the jumping. Only 2 of the sensors really showed any signature here. These are cars driving by on Watkins Road, about 100 feet away from the sensors. If you zoom out in time, these traffic signatures follow a clear daily pattern. The 2 sensors out in the east in the field during the hydraulic fracturing period are complete flat lines. You can see that the control period also mostly flat lines. There's some noise here on near sensor 102. That is a hydraulic pump running about 10 feet away from that sensor. Next slide, please. Next, we'd like to address another concern, contamination of the reservoir and aquifers from the pad sites. We commissioned an independent, highly skilled hydrologist to investigate our sites and their position to Aurora Reservoir. Had a few key findings. One, all proposed Crestone sites sit across drainage divides in separate sub-watersheds from the Aurora Reservoir. Two, the strict ECMC casing and cementing requirements are sufficient to protect aquifers in the area. Three, the water level of Aurora Reservoir relative to the free water level in nearby wells indicates aquifer flow generally away from the reservoir. And four, as we covered a few slides ago, the Pierre Shale provides an adequate frac barrier relative to height between the Niobrara and surface formations. Next slide, please. This slide speaks specifically to slide 3, and it bears a little bit of attention here. Here we have a cross-section starting north of Aurora Reservoir through the State Blanca West site, across the reservoir, and then angling across the State Sunlight and Beaver sites. Excuse me. As you can see, the water level in Aurora Reservoir is higher than the free water level as measured in surrounding water wells. That means that if the reservoir were communicating directly from aquifers, hydraulic pressure would push water from the reservoir into the aquifers and not vice versa. Again, our casing and cementing designs completely protect the aquifers, but in the theoretical case of contamination, that contamination will be flushed away from the reservoir. Also, this is a good slide to point out that local topography along a section from the State Blanca through the reservoir to the Sunlight, Long, and Beaver. Blanca is downgrading from the reservoir, and Sunlight and Beaver are across a prominent drainage divide. Lastly, we have a diagram of the geology in the area showing the aquifer intervals, planned depth of surface casing and cement, as well as our world-class seal interval, the Pierre Shale. All right, go to slide. We're going to jump ahead here. We would like to provide some direct testimony regarding STAR's petition here. Here we've seen this map before. This is a map of the proposed site that is closest to Aurora neighborhoods to the west, the Sunlight Long, with a 3,000-foot buffer around the pad site. As you can see, both the residences and Aurora Reservoir are more than 3,000 feet from the pad in full compliance with Arapahoe County regulations. We've also shown here the official STAR petitioners, the closest being approximately 3,500 feet from the Sunlight Long proposed pad surface. One thing this map doesn't show clearly is the topography at the west edge of Lowry Ranch. We'd like to play a demonstrative video demonstrating how this topography will serve as a visual barrier relative to the homes at the west. We developed this video for our 314 neighborhood meeting. Can we play this, please, Kelsey?
So I was playing it. Was nobody able to see it?
No.
I think you're not sharing YouTube.
Let me try again.
Thank you. Thank you. If you don't mind rewinding that video to the start. So this is a virtual drone flight that starts in the neighborhood to the west of Lowry Ranch. You can see that the virtual drone here is flying due eastward. During the drilling phase, the tip of the derrick is visible from the west, but you can see that the barrier blocks out the sub-derrick as well as surface features. So this is what the excuse me, this is what the pad site will look like during drilling and completions. We're going to zoom out vertically here to show a bird's eye view. And we'll convert the pad to what it will look like during the production phase. You can see the pad surface has shrunk significantly via interim reclamation. And we're going to zoom backwards here. Here we're flying due westward back into Aurora. You can see the pad site and production facilities. You can see the prominent ridge. And by the time we get to the ground level in Aurora, there's nothing visible. Thank you. Appreciate that, Ms. Weslinski. We also have some comments here about our Sunlight Long reservoir setbacks. There were some questions about how these setbacks relate to current Arapahoe County rules. So here's a map showing the position of the state Sunlight Long site relative to Aurora Reservoir, Planned Reservoir B with topography. The Sunlight Long site, as stated, was moved to provide a full mile setback from Planned Reservoir B as required by Arapahoe County regulations. State Sunlight Long is also over 3,000 feet from Aurora Reservoir with a very clear topographic divide between the pad and the reservoir. That divide has been confirmed by our hydrogeologist as the separator between two drainage subbasins. Next slide, please. I'd also like to talk briefly about riparian setbacks. There was a question whether Sunlight Long meets Arapahoe County riparian setback rules. We have conducted, as stated before, extensive field surveys in this area to delineate wetlands and riparian habitat. Near Sunlight Long, there is no riparian habitat within 500 feet of the pad surface, and only one feature within 1,000 feet in intermittent stream to the southwest, marked here in green. The pertinent Arapahoe County regulation is a setback of 1,000 feet waivable to 5,000 feet with support of CPW and a third-party expert recommendation. We have submitted a report from a third-party expert recommending a 500-foot setback waiver for this site to the county, and CPW is in direct consultation with the county as part of their permitting process. This plat also demonstrates the setback constraints of the Sunlight Long site. It's truly wedged right in between an RBU setback to the west, reservoir setbacks on the northeast and northwest, and riparian setbacks in the southeast. That said, it is compliant with all of those setbacks. Next slide, please. We're getting very much into the details here, but zooming in, you can see that there is some confusion because publicly available GIS data on wetlands is incorrect. In teal here, you can see the U.S. Fish and Wildlife Service GIS coverage of this stream bed, but you can also see our maps in a darker green that mirror closely the topographic imagery. So as we know, streams do move over time. Next slide, please. I'd like to get into some specific concerns about fault zone and seismicity risks raised by the STAR group. The Agate Harbor report attempted to raise concerns about through-going faults allowing frac fluid to reach the surface through geologic formations where such faults are rooted in the basement rock. Again, I want to make clear there is zero evidence of this ever having occurred for over tens of thousands of horizontal Niobrara wells in the DJ Basin, but we'll try to respond to some of the specific concerns here. The AH report does discuss major basement faults as fluid conduits. To be clear, to be clear, basement faults do not create fluid conduits to the surface anywhere in the DJ Basin. But further, major basement transfer faults are well mapped and well understood, and they're generally confined to the steep western flank of the basin. You can see here how they very obviously stand out at the Windsor Fault Zone, the Johnston Fault Zone, and the Longmont Fault Zone. By contrast, the Lowry Ranch Cap is at the gently sloping eastern flank of the DJ Basin. The basin axis here runs from the southwest to the northeast corner of the map. There is no evidence of any significant basement faulting here. Next slide, please. Here we've zoomed into some of these major basement fault zones to the northwest of Lowry Camp. So again, we're here up in Johnstown in the Windsor area. As you can see, these faults are well imaged in 3D via 3D seismic, but moreover, there are hundreds of Niobrara horizontal wells drilled and completed near and through these fault zones. None of this activity caused completion fluids to escape to the surface, and none of this activity reactivated these faults or caused any kind of seismicity. Next slide, please. Here we show a couple of 3D seismic lines across Lowry Ranch. Again, we have 3D seismic data over the ranch. Our geoscientists have scrutinized this data and have identified no concerns. This is modern 3D seismic onshore data, 110-foot trace spacing. This is industry standard and well capable of imaging faults. As you can see, there is some minor basement faulting, which do not develop into these massive 3-going faults. I'd like to thank GPI for their permission to show this data publicly. Next slide, please. We also wanted to address the general state of seismicity in Colorado. We pulled historical seismic data from the USGS for all earthquakes above magnitude 2.5 in the DJ Basin since 2000. Over the period since 2000, there have been a grand total of 6 seismic events over magnitude 2.5, with the biggest at 3.2 in June 2014, which is not a damaging earthquake. The earthquakes that did occur were clustered around injection wells in the area at depths of around 16,500 feet. As you probably know, you can locate the epicenter of an earthquake in 3D. 16,500 feet is over 8,000 feet deeper than the Niobrara Formation, but it is consistent with injection depths. No horizontal producing wells were being stimulated in the vicinity of any of these vents at the time of the earthquakes. As a reminder, over the last 20 years, there have been tens of thousands of hydraulic stimulations of producing wells in the DJ Basin, and none of these have been linked to seismicity. And lastly, as a reminder, Civitas is not proposing any injection wells within the Lowry Ranch cap, and Arapahoe County would not allow us to permit them even if we tried. I'd like to turn for a moment to stratigraphy. Here we have a couple of cross sections across Lowry Ranch and up into Box Elder. The squiggles you see are gamma ray signatures, which are indicative of the makeup of the rock. The Niobrara at the bottom here in the colored lines is overlain by the Pierre Shale, which is over a mile thick in the area. The Pierre Shale is a late Cretaceous marine deposit, which is to say it is continuous and relatively homogeneous over large distances and is considered a world-class seal rock, trapping hydrocarbons in deeper intervals. If you look to the right, this is simply the same cross-section zoomed in. The lowermost member of the Pierre Shale, the Sharon Springs, is a particularly ductile, clay and bentonite-rich layer that is a particularly good fluid barrier. Claystones like this are resistant to fracturing and tend to self-heal if fractured. Next slide, please. We did have some comments on our water sampling protocol. This is a lot of words on this slide, but what it amounts to is that wells are prioritized per rule based on proximity to the site, and that not all existing water wells are appropriate for sampling. Our sampling plans are designed according to ECMC and Arapahoe County rules and are in full compliance with those rules. With that, I'll turn it over to Mr. Bennett for some sound modeling slides.
Thank you, Mr. Harrington. Crestone and its sound consultant have reviewed the comments provided by STAR and their Pennsylvania-based consulting firm. The result of that review is captured by way of a technical memorandum, which has been incorporated as part of Crestone's pre-hearing filings and appears on the next several slides. In short, STAR's expert asserts several inaccurate statements and proffers misleading accusations, including an outright attack on ECMC noise regulations. When planning new development, Crestone will typically collect several ambient sound surveys prior to finalizing the deliverables required for ECMC permitting. Oftentimes, an initial sound survey may be commissioned far in advance of finalizing the proposed oil and gas location as part of the process in identifying potential impacts to nearby constituents. Moreover, the sound information provided to STAR in mid-June were reports prepared for the relevant local government, which does not provide specific procedures or guidelines for conducting ambient sound surveys like ECMC Rule 423 prescribes. To date, the only cap-related Rule 423 noise mitigation plan filed with ECMC is for the State La Plata South OGDP, docket number 240600148, which was received by staff on July 22nd. More importantly, this document was not reviewed by STAR or its consultant as part of their petition. This report conforms with all regulatory requirements contained in ECMC Rule 423, including properly acquired and processed ambient noise data in accordance with applicable ANC and ISO standards. The State La Plata location is the only location in the CAP that requires that has a residential building unit within 2,000 feet of the working pad surface. The noise mitigation plan prepared for the site-specific OGDP application clearly demonstrates that Crestone will be compliant with Rule 423. As previously mentioned, Crestone will employ full perimeter sound walls at this location to aid in reducing potential sound impacts. And with that, I'll turn the presentation back to Ms. Jost.
Wonderful. Thank you, Mr. Bennett. I'd like to thank Mr. Harrington, Mr. Bennett, and Ms. Stearman for their direct testimony today. And Chair, that concludes our direct presentation. And I would like to request that all of the exhibits presented in our direct presentation this afternoon, not this morning, this afternoon, be admitted into the record. And with that, the three witnesses would welcome cross-examination at this time.
Okay. So I think we've got Mr. Foote available for cross-examination for the witnesses. Mr. Foote, do you have objection to admission of the exhibits before we get to cross-examination?
No objection.
Okay, so the exhibits are admitted. We now will have Mr. Foote do whatever cross-examination he desires.
Thank you, Mr. Chair. So since there's three witnesses, I'm going to call on the witness I think would be most appropriate here, but please correct me if I'm wrong. First, I want to call on Ms. Stearman and draw her attention to slide number 63 in the presentation. And I suppose if Ms. Wozlinski could pull that slideshow back up, I think that would be helpful.
Yeah, of course. So Ms. Wozlinski, if you could put the slideshow back up and just sort of navigate along with Mr. Foote, that would be helpful.
Great, thank you. So Ms. Stearman, I believe you were the one that, or at least one of the witnesses that talked about electrification efforts that Crestone's going through when it comes to the locations within this cap. And am I correct in recalling that?
That's correct.
Okay. Now, you talked about the electrification, but my question is, are these electrification efforts occurring because of the cap, or is this something that you would normally do for individual location applications?
Thank you for the question, Mr. Foote. Civitas does want to drill on high line power when we can. There are a lot of efforts that go into those applications with the utility provider. In many cases, the utilities either can't guarantee it for us or may have allocated that power elsewhere, depending on development in the area. However, recent events, like Dan said, we have actually paid and engaged with the utility to guarantee what's here represented as 3 locations, really 4, because we did consolidate 2 pads.
Okay, so I think the answer is, when possible, regardless of whether it's a cap or an OGDP, you will try to tap into electric power, correct?
That's correct.
Okay. Slide 67 talks about the oil pipeline takeaway system. Right, thanks. So the point you were making here is that this oil pipeline takeaway system will be implemented and it's going to reduce truck traffic, correct?
That's correct.
All right. But the same kind of question applies here. Wouldn't you normally do that for an OGDP? And that's not special to this cap, right?
There are always synergies to consolidation of pads and bringing pads together. We absolutely always want infrastructure where we can bring it to our development, and this reflects some of the emission savings from that infrastructure.
So you would do this for just one OGDP if you could?
I would defer to Dan Harrington on development plans.
Okay. Mr. Harrington has highlighted himself, so maybe why don't we just move on to some questions for him? Mr. Harrington, I'll pick up the electrification questions with you because you also talked about it, right? In your direct?
I did.
Okay. Crestone's indicated that it will use electric power in this case for pre-production activities if feasible. Does that sound right?
That's correct.
And if feasible, not only means whether or not you can tap into the electric power, but also if you can tap into the electric power during the timeline that Crestone has in mind for its operations. Is that fair to say?
The feasibility of electrification to any given site is controlled by Excel's capacity, load, and construction timeframes. But we have limited control over what Excel can and cannot do. Let's put it that way.
Right, I understand that. Let me just ask you a question about, say, sunlight long, for example, since you indicated that in your testimony, that was one area that you're trying to focus on electric power for sunlight long. Crestone, it looks like Crestone has in mind to develop the sunlight long pad first in the first quarter of 2025. Is that correct?
I don't believe so. I believe it's a little bit later. The La
Okay.
Plata would be the first site in early 2025.
Well, I should say that the first new site instead of the expansion of an existing site.
It is among the first of the new sites, yes.
Okay, and so you're saying that it may not be the first, but you're still looking at developing sunlight long in the first quarter of 2025?
I believe it's later than that. If we can jump to the Gantt chart, that would be helpful right now.
Dan, do you have a slide number for that?
Slide 55.
55?
Yes.
Thank you.
Oh, that's right. We do have it in. I apologize. It is here in relatively early in the rotation relative to La Plata. Yes, and perhaps to answer your question, the reason we began conversations with Excel as early as we did is to maximize the chance of having electrification of these sites in time for operations.
Right. But if Excel, for whatever reason that even could be beyond your control, does not have electric power available for sunlight long during the first quarter of 2025, you're going to get started and drill anyway, right?
Well, we would fall back on our tier 4 equipment at that point. But as I said, we have already paid the invoice to have Excel do the work for sunlight long as well as La Plata, and we anticipate no problems having that installation done in time for those sites.
Okay.
I'd also add, oh, sorry.
I wanted to move on to, well, we're still on sunlight long, so let's talk about sunlight long a little bit more here. So you testified earlier that the sunlight long pads were previously separate, but now you're proposing to combine them, correct? It's just going to be one site, not two.
That's correct.
And you've testified and your materials indicate that the proposed location of this one new site, sunlight long, has moved around several times over the past year, correct?
That's correct.
Did you say 4 times it's moved?
I believe if you think of them as separate sites, State Sunlight is on its 4th version and State Long is on its 3rd version.
Okay. So you know what your preferred location is for sunlight long at this point, right? I mean, you submitted that location for approval with Arapahoe County. You know where you want it to be.
That's correct. Once Arapahoe County finalized their 2023 rules, we redesigned the site to be in compliance with those and submitted it to the county.
But you also decided not to ask for preliminary siting approval for sunlight, even though you know where you want it to be now?
At that point, the CAP application was ripe for its final submittal, and developing PSA materials for sunlight long would have been time prohibitive, essentially.
Do you think that location is going to change from what was submitted to Arapahoe County?
I don't anticipate it will change materially. always specific elements of the pad design are ironed out during the Arapahoe County process, and that's very normal.
And you talked a little bit about the Arapahoe County request made to this commission to require an alternative location analysis of Sunlight Lawn, correct?
That's correct.
You indicated there was two reasons, I believe, why Creststone's not interested in doing an ALA at this point. One was this is the fourth location, and the other was ECMC rules don't require it. Is that a fair recitation of what you said?
I would add a third that the specific request is not feasible for other reasons.
Okay, other reasons being cost?
No, operational limitations, access, and we have slides on this matter actually that we can bring up if you'd like.
Well, but so cost would be a factor though, wouldn't it? I mean, if you're moving the pad a little bit further to the east or to the south, that's going to cost more.
I actually wouldn't say that that is a factor here.
Okay. But regarding the Sunlight Lawn location, you would agree that if a proposed location, no matter where it is not protective of public health, safety, welfare, the environment, or wildlife, it doesn't really matter if it's the first iteration or the 10th iteration. It's something that can't be permitted, right? Because it doesn't follow the rules.
We believe this site is protective.
Okay, but the question was, if it's not protective, it doesn't matter if it's the first or the 10th iteration. It doesn't follow the rules, right?
You're speaking about a theoretical site that doesn't exist, I think.
Okay. So we're still down in kind of the south area here, not with Sunlight Lawn, but Secret Stash. You're familiar with the Secret Stash location, correct?
I am somewhat familiar with it. It is not a Creststone operated site, so we didn't design it, or we're not intimately familiar with it.
Okay, but you're familiar with the location of where it's proposed to be?
Yes.
And you're familiar with the fact that Creststone and the operator GMT came to an agreement that the Secret Stash location could be located within the Creststone cap area?
That is correct, yes.
Okay. You're familiar that the Secret Stash location is supposed to include up to 20 wells, correct?
I believe it is 20.
Okay. And do you recall how close it is to the proposed Beaver and Sunlight locations?
I believe it's approximately a mile east.
Okay. And whatever that operator does with the Secret Stash location, even though it's within the Lowry Ranch cap area, none of those impacts are accounted for in your cumulative impacts assessment, are they?
Our cumulative impacts assessment focuses on our operations.
Okay. So not any of the other operations in the cap.
Well, there are limited operations within the cap. This would be one site that's barely within the cap boundary, yes. But it is GMT's site. We can't speak to their plans, their timing, that kind of thing.
Okay. Are you familiar with mechanical integrity testing?
I am somewhat familiar with it. It's not my area of expertise.
Is there any one of the other two that are currently here that have more expertise than you do on this area that I should talk to?
What?
Mr. Foote, if I may, you may want to ask your question about mechanical integrity testing, and then we can determine who would be best to respond, if that might help.
I will. The question is, I suppose for Mr. Harrington right now is, do you know how many Civitas wells have failed mechanical integrity testing?
That is beyond my knowledge. I'm not an expert in this.
So,
Chair, I guess I
go
would
ahead.
Sorry, Mr. Foote, I would form an objection to this. This question seems very vague. Mr. Foote, are you referencing Crestone wells or Colorado wells or wells in Colorado in general? There's a difference in that.
Well, the question was about Civitas wells, but I'm happy to narrow it down to Crestone wells.
Do either of the other two witnesses have information to be able to answer said question? I'm not seeing that. They are unmuting themselves, which I'll take as a, perhaps that's not within their wheelhouse of information.
Okay, fair enough. Mr. Harrington, I'm going to ask you questions about the Superfund site, but I think both you and Mr. Bennett talked about this, so please let me know if I should speak with somebody else, or Mr. Bennett. But regarding the Superfund site, Crestone's worked with EPA over the last several years, and the result of which at this point is that Crestone decided not to drill under the Superfund site, correct?
That is correct.
And that was in response to EPA's concern that induced seismicity from hydraulic fracturing underneath the Superfund site could actually occur and cause contamination, correct?
I don't recall them phrasing it that way.
Do you recall what their concerns were if it wasn't about induced seismicity?
It was more in general, we don't want these wells there. They were joined by the BLM who control the minerals under the site, such that we couldn't penetrate it anyway. We didn't issue an.
So you don't recall if they brought up induced seismicity as part of their objection?
I don't recall that.
You're also aware of the EPA recommendation in front of the ECMC that the commission imposed some kind of buffer zone between the Superfund site and your laterals, correct?
I'm aware of that, yes.
But Crestone has not revised its plan to reflect that buffer zone request from EPA, correct?
Our wells are 7,000 feet deeper than the site. That is a very adequate buffer zone.
Okay, so the answer then is no, you haven't revised your proposal as a response to the EPA concern about buffer zones?
I would say we built the buffer zones into the original response.
Okay. Mr. Bennett, well, thank you, Mr. Harrington. I think that's all the questions I have for you. I have some wildlife questions for Mr. Bennett. There we go. Okay. Mr. Bennett, do you mentioned in your testimony about the third party that you contracted with to do wildlife surveys? Do you recall that?
Yes.
And do you know when that third party did those wildlife surveys? You know, what time in the calendar year they did those surveys?
Off the top of my head, I'm unable to give you specific dates. However, HWA has been surveying that property during various seasons since 2012 and as recently as June of this year. And so it is reasonable to assume that those surveys have taken place during the appropriate time of year to survey for those species that have been that we are required to survey for.
Okay, do you know whether or not that includes if the surveys have occurred inside or outside of each species breeding season?
To the best of my knowledge, I believe those surveys have occurred in the appropriate seasons to include seasons of periods of flowering times as well as breeding seasons.
You spoke about, I don't know if we need to pull this up or not, but on slide 71, you spoke about some of the measures that Crestone would take if there was a swift fox or burrowing owl that's found around one of the locations. Do you recall that testimony?
Yes.
Okay, thank you. So it's been unclear what you plan on doing about it. What if you do find those species to be in that area? Are you planning on just ejecting them?
Absolutely not. I believe in my testimony, I clearly stated that if these species were identified in subsequent surveys, that we would coordinate with the appropriate wildlife agency, either Colorado Parks and Wildlife and or U.S. Fish and Wildlife Service, to determine the appropriate next steps.
Okay, you also talked about in your testimony the installation of sound walls around the locations. Do you recall that?
Yes,
And I think you indicated that sound walls will be installed around each of the locations, correct?
Crestone intends to install sound walls around each location within the Lowry Cap. Yes, that's correct.
And that's not just for population, human population that may be around there. It's also for the protection of wildlife, right?
We understand the importance of minimizing disruption to nearby habitats, and so we see the use of a sound wall in this instance to be protective of not only residential populations greater than 3,000 feet from our locations, but also any wildlife and their associated habitats that are proximal to what our proposal contemplates.
Okay. Thanks, Mr. Bennett. That's all the questions I have at this point.
Thank you.
And Mr. Foote, is that all the questions you have for all three of the witnesses then?
Yes, it is, Mr. Chair.
Okay. Ms. Jost, do you have any redirect based upon the cross?
I just have one redirect, Chair. Thank you so much for Ms. Stearman. Great, thank you. Ms. Stearman, just one question regarding electrification. When Mr. Foote asked you about the electrification and if Crestone would do it as an OGDP anyway, did Crestone consider the electrification of pads in order to reduce comprehensive area plan air emissions as part of your cumulative impact analysis?
No, Ms. Jost, that was not part of the consideration. We seek electrification either at the OGDP level or at the pad level or any level. We just kind of wanted to see where we are today with the benchmark and what do we know today, and we thought that slide would be valuable to the commission to make a comparison.
Great, thank you so much. Thank you, Chair.
Okay. So next on the agenda would be commissioner questions. I'd like to maybe take 5 minutes before we jump into commissioner questions, if that's okay, Ms. Jost. So let's return at 4:05.
Great, thank you.
Recording started. Maybe recording never ended. This is the Colorado Energy and Carbon Management Commission, docket 221-000-282. It's 4:05 on July 30th. And we are at the place within this docket in which commissioners have a chance to ask Crestone's panel questions that may have come to mind as a result of the presentation. Who would like to start? Commissioner Messner.
Thank you, Mr. Chair. Well, it's such a long presentation. My notes are a little bit all over the place, so I apologize in advance if I'm jumping around here. So I'm gonna start with just talking about some of the plans that were submitted and some of the concepts that have been testified upon here, and make sure that I understand what's being proposed here. We heard testimony earlier today from the State Land Board around a review that they've done. At least the testimony we heard this morning is that the individual had not reviewed any information associated with the cap. You've provided testimony that says that the State Land Board has been out on site a number of times and have created some sort of approval. I'm looking through the evidence. I don't see any documentation or evidence associated with any kind of opinion or approval from the State Land Board. And what you're testifying to conflicts to the testimony provided by the State Land Board earlier. So I wonder if someone could provide clarity to me on that.
I can provide that, Commissioner. Thank you for that question. The State Land Board surface stewardship staff requires an on-site boots on the ground visit following every site proposal and every site modification. Those site visits have occurred both after the original pad sightings and after they were revised. And I believe there is a letter on file that acknowledges those site reviews approving the sites. When Ms. Caranda spoke, she is the mineral director of the Colorado State Land Board, and I don't want to speak for the organizational structure. She isn't the one who reviews surface siting. That's a different individual.
And Mr. Harrington, we're pulling up that exhibit if you'd like to see it.
If you could just tell me the exhibit number, that would be helpful because I wasn't able to locate it.
Happy to, Commissioner Messner. That would be Exhibit AA, Bates number 854.
Thank you.
You're welcome.
So still on the state land board piece, and I wonder, well, I'm going to ask this question, although understanding that I may have not reviewed this piece of evidence that has just been indicated, the answer may be within that. But as I reviewed some of the lease stipulations associated with the different tiers and understanding that some of the sites that you're contemplating are on tier 2, I wonder if you could talk about this one piece around the tier 2 standards from your perspective that talks about that the total amount of acreage identified as tier 2 land shall not increase over the life of this lease by more than 10%. Or wait, sorry. It's not that section. It's this section that talks about roads in tier 2. And I think that's what I was concerned about. If someone could talk to not the lack of allowance for, significant road improvements in tier 2 designated areas in the lease.
Thank you. I can handle that question. To be clear, tier 2 is the tier 1 is no surface occupancy, and tier 2 is the less desirable surface occupancy. Surface disturbance in tier 2 costs us double relative. So every acre counts for 2 against our land allocation in the cap. And by that, the state land board is trying to discourage that. Where we have pads cited in tier 2, we do it where we have to. As an example, and I know I'm going a little bit off topic here, but the State Blanca original version was in tier 4, and it was required to be moved out. And if you recall, the move improved our situation relative to HPH and improved our setback versus rural reservoir. That's the kind of conversation that we have with state land board staff, saying, hey, we're moving from tier 4 to tier 2, but there are very good reasons, both regulatory and for stakeholder feedback for doing so. And those are part of those site visit consultations that we have with state land board service staff. With respect to roads, we are sticking to existing state land board roads wherever possible in tier 2. And as such, we minimize the additional disturbance to build those roads out. Now, they are 2-track, as you remember, but so they are going to get wider, but that's better than a brand new road.
Yeah, and I understand that. I guess, and I found this section, sorry, I'm jumping all over a bunch of different documents here, but it indicates, in the lease on page 4 that no new road shall be allowed on or in tier 2 lands unless the leasee demonstrates that there's no technologically or economically feasible alternative. So I'm trying to understand, if the state land board is reviewing this and applying these, or as the surface owner, and I'm still working on the relationship between the state land board and ECMC in this process. And so these are just questions that I'm asking to better understand.
No, it's a very good question. And I would say that the largest stretch of new road on tier 2 land is the road that leads to the Blanca site. But again, Blanca moved away from the existing road, driven by very specific local and state regulations. And the state land board, I would say, understands that.
Okay, and that's explained in the opinion letter that I haven't read yet.
The opinion letter, I think, is more general. It simply states that the service staff have visited the proposed sites and agree with them in principle.
Hey, Commissioner Messner, can I weigh in real quick? I had asked the state land board person, I forgot her first name, Christelle Coranda, about the lease, and she actually emailed me and Mimi and Elias a response, and I would like to maybe have Kyle or AG Davenport read it into the record. It is relevant evidence. It gets at some of your questions, and I just think it's appropriate at this time to get it into the record.
Sure.
AG Davenport.
Thank you, Chair. I'm also, of course, happy to email this to the attorneys, so they don't have to wait while we get it into the record. Would that be acceptable?
Yeah, that's fine.
Okay. This is an email, as the chair just noted, from Ms. Coranda. It's to Hearing Officer Thomas and Deputy Director Mimi Larson. It states, Elias, Mimi, as requested at this morning's hearing, I reviewed I'm adding Crestone's Exhibit N. I can confirm it is a copy of the oil and gas lease originally issued to ConocoPhillips that is now held by Civitas. Additionally, we have issued lease amendments since 2011 to reflect acreage clarifications, a release of deep rights, and a modification to the tier map that removed a planned reservoir that was located in Tier 1 because the reservoir is no longer being built. Lease amendments are a standard practice for the land board. I have included the lease amendments and the updated tier map for your records. In addition, to date, I can confirm Civitas is in compliance with its oil and gas lease. In regard to the proposed pad sites that are in the CAP application, our staff has reviewed all current pad locations that are listed in the Lowry Ranch CAP application. We can confirm those locations are in compliance with the terms of the lease. Should any modifications arise to the pad locations during the ECMC CAP hearing or ECMC staff review process, State Land Board staff would need to do a new review to ensure lease compliance and staff approval. I'll get that out to the commissioners and the attorneys right now, and then also work with ECMC staff to ensure it gets into the record as quickly as we can get it in.
Thank you, AG Davenport.
Okay, I'm going to move on from state land board then. So currently in the application, which I think has been amended today to commit to, correct me if I'm wrong, so it's a little confusing to me because in what you're committing to from an electrification standpoint and what you're not to. I mean, the application currently indicates that you're not committing to any electrical. So no commitment on production facilities, no commitment on drill rigs. There's, information in there that we'll do our best, but there's no commitment to any of those. You've indicated today that you're committing to 3 pads for drill rigs only, but then in cross-examination testimony, you indicated that if it doesn't work out in time, then you're not committing to that. So I'm trying to understand what you're committing to so I can put it in my notes.
Thank you for that question, Commissioner. I hear your point here. What it boils down to is, unlike a pipeline system, we are not a public utility. We can't take over. We can't install our own electrical lines. If we could, we would be committing to all this 100% upfront. We wind up at the mercy of Excel. As I said, we can't always foresee problems with capacity, load, ability to construct the lines. So, and this comes up frequently. I know you've heard this from me before in other OGDP applications, but we We commit to seeking and paying for these upgrades wherever possible. In the case of the Lowry Ranch cap, there are synergies for us trying to electrify multiple pads on the same line at the same time. And there are also synergies in that we started the process very early. To date, as I said, we have gotten positive engineering reviews from Excel and have paid our upgrade invoices for La Plata, Sunlight Long, and Beaver. And with high confidence, we feel we will get electrification to those sites. But again, it's hard for me to commit to something I can't control, whereas we are committing to pipeline takeaway.
That's fair. It's also impossible for me to review something that's a maybe. And so I can only review something that is a yes. And so I wonder, let me ask this question, because this isn't an OGDP. This is a comprehensive area plan with an extended timeline associated with it that has been contemplated throughout the rules to encourage the build out of the necessary infrastructure in order to address cumulative impacts. Can you provide evidence from Excel on steps that have been taken to secure electrification and provide testimony or evidence from them indicating the level of certainty that they have that they're going to be able to provide that and what timelines that may be?
That's something we can ask for. One thing I might refer to you is that slide where we have our timeline of outreach that has several touch points with Excel on it, so that can at least give you a baseline of our outreach to Excel. We can submit our the engineering studies that came back from La Plata and Sunlight Long if you'd like to see those as well.
Yeah, and I'm more interested in that evidence or testimony from Excel, because it's one thing that I hear from you that you're taking steps. I need evidence that confirms that from an independent source in order to be able to go further than not than just saying, okay, you're committing to something other than electric. And so that would be helpful for me to get that. I think my next question is, this is going to go all over the place, so I'm sorry. So I'm going to do wildlife here for a second. I wonder if, and Mr. Bennett, you're probably the one to answer this one. Why is the approach that Crestone's taking on this to do the significant amount of wildlife evaluation and specific BMPs at the OGDP level versus utilizing the benefits of the comprehensive area plan process and the timeline allotted with it to work with CPW to look holistically over the entire timeline of the project and develop a comprehensive wildlife strategy that addresses the project as a whole comprehensively, which is the whole idea of a comprehensive area plan, versus waiting till the OGDP level?
Appreciate your question, Commissioner Mesner, and I hope I understand what you're asking. So forgive me if my response misses the mark. But we've engaged twice with CPW in on-site reviews of all the locations that have been proposed in the CAP, both in September of 2022 and again in April of this year. We've continued to go back and forth with CPW via virtual meetings as well as email exchanges as we move forward with our site-specific plans and develop those site-specific wildlife mitigation plans that are required as part of that OGDP process. CPW has been engaged and will continue to be engaged in what we propose. And we've had some very long-lasting conversations regarding potential mitigation projects for this piece of property that would help offset some of the perceived impacts to the surface within the CAP area.
I mean, that's fine. I'm still, so you understand what I'm trying to evaluate here is the benefit of the utilization of the cap versus individual OGDPs. Because a lot of what you're proposing here is just site-specific BMPs and practices for individual OGDPs versus the utilization of the benefits to the state in addressing cumulative impacts by addressing and evaluating these things holistically at the cap level. And so that's where I'm struggling, because I understand that you've been engaging with CPW, but I don't see a lot of detail or a very holistic look from a wildlife standpoint in at least the plans that I've looked at. I appreciate your wildlife consultant who did have some recommendations in there, but I don't see those following through in any type of commitments. So
I appreciate the clarification again, Commissioner Mesner. You know, as I mentioned in my direct testimony, this area has been studied since 2012 and continues to be studied to this day. There's a lot of data that's been collected that we have provided to State Land Board and CPW. If that's something you're interested in seeing, we can, you know, get that compendium over to you as well for your review. Again, if it would be of interest to you and potentially Commissioner Ackerman as well. The site-specific approach it is really a result of this comprehensive review, right? So as part of our siting practices, we were able to ascertain kind of the wildlife history throughout the cap, and then with a number of other siting considerations, identify locations, for example, that are greater than a half mile from a swift fox den. And so I would counter with saying that given the comprehensive nature of what we have done, both in the cap application and more importantly, with the boots on the ground wildlife surveys for the last 12 or so years, that we are taking and will continue to take a comprehensive approach, even if those BMPs are tailored for site-specific occupancy.
okay, thank you. So this is a question for you, Ms. Stearman. And Mr. Foote had talked about this as well, but I struggled a little bit with those bar charts that you had put up around reductions and classifying as a reduction versus a best management or even a requirement in certain situations. And so for the NOx reduction piece, I did have, and I might have misheard, but I think you indicated that those bar charts were an 11-year duration in order to gain those reductions, but the cap has a 6-year timeline associated with it. And I assume that the vast majority of the NOx emissions associated with that are going to be in pre-production activities. And so I guess I scratched my head on that.
Yeah, I'm glad you asked that question. I actually kind of looked into that myself. That's why we use the word duration a few times, because we're checking a procedural box when we look at the 11 years. So the duration kind of ties us back to 314C and 314E10, which is the duration of the cap plus 5 years. But you're right, like the original impact is kind of really the first 3 years. And looking at those reductions, it does have an ongoing impact, but we tied it to the 11 years specifically for that procedural box.
Okay, that makes sense. And so, I mean, just this is a comment more than anything, but I would say that's a comparison and not a reduction, right? Because generally speaking, you know, some of the things like comparing it to truck traffic versus pipeline, those are comparisons, but not necessarily a reduction, because particularly when we're looking at cumulative impacts or comprehensive area plans, the allowance of trucking in our rules would probably not occur. So that's just a comment. So one of the things, I'm jumping back to you, Mr. Bennett. One of the things that at least I clearly heard from CPW, both in the director's recommendation, well, mostly in the director's recommendation, because there wasn't a clear summary of CPW's review of this, but was the importance of timing stipulations. And throughout your testimony and your submittals, it talks about wherever possible that you'd commit to timing stipulations holistically through the CAP. The timeline that you've proposed inside the CAP doesn't contemplate timing stipulations at all. And so, and timing stips seem to be not, have some site-specific characteristics to it, but also, comprehensive area scale elements with it as well. So I wonder if you could comment on why, whenever possible, and not a firm commitment to the timing stipulations that ultimately will be very important to CPW, I would assume, in their consultation.
I appreciate the question, Commissioner Mesner, and CPW is aware of this statement as well. As I think you're very well aware, given some of the uncertainties around not only permit timing and approval, but also operational durations, it's difficult to make commitments that would otherwise result in greater impact, quote unquote, from operations being elongated due to having to stop for several months of the year, relative to continuing through certain windows as it relates to the high priority habitat in this area, which, as I stated, was not, a majority of which was not under high priority habitat designation when the application was submitted back in October of 2022. And so to ensure that we can continue with our business as seamlessly as possible, we will do what we can to avoid those windows. However, when those windows are unavoidable, we are prepared to take the necessary steps to minimize and mitigate our operations on the surrounding landscape.
And let's talk a little bit about the high priority habitat designations at the CAP level versus the OGDP level. Understanding that there are two different high priority habitat maps that will apply, one at the CAP level, one at the OGDP level, but we're also evaluating impacts to wildlife holistically through a 6-year timeline or more associated with, a comprehensive cumulative impact evaluation. And so how are you viewing the juxtaposition between the two high priority habitat maps in your comprehensive evaluation of wildlife?
I appreciate the question. As luck may have it, those two designated high priority habitats overlap in a very general sense from a timing restriction standpoint, those both being in the winter months, effectively January through April or thereabouts. And so that was taken into consideration as part of our application development, and will continue to be taken into consideration at the OGDP level. And more importantly, when we get to our operational scheduling, trying to balance, our operational needs and timing with the needs and potential restrictions associated with these lands.
Thank you. I want to talk a little bit about the benefits of site-specific versus comprehensive planning with emergency response and fire mitigation. And while it's clear that you indicated in testimony that you're working with Bennett Fire Department, has there been any attempts to develop a more comprehensive emergency management or fire mitigation strategy for the CAP lands, or are you intending to just leave it to the individual OGDP locations?
I appreciate the question, Commissioner Mesner, and I may start this and then turn it over to Mr. Harrington. As a company, we have company-wide safety plans as well as field-wide plans required for our operations that are more location-specific in a general geography, let's say, than perhaps a company-wide plan. And so those, in accordance with, adhering to the 600 series rules, really set a nice framework for what's expected from an operational standpoint to eliminate safety hazards, including but not limited to the fire potential. As it relates to site-specific plans, as I mentioned, we are working with the local responders to ensure that we have plans ultimately that will tie to a greater field-wide plan, but for those individual sites to satisfy any concerns relative to the potential for wildland fire risk. And with that, I'll turn it over to Mr. Harrington.
Thank you, Mr. Bennett. I will just add that when we have consulted with the local fire department on this, and the feedback we got is that the mitigation measures that will be required for any given pad site are particular to the geography, vegetation, location, winds at that pad site, and there is no one-size-fit-all plan for everywhere on the cap. So we did present some cap-wide general fire mitigation measures. Bennett Watkins Fire was happy with those measures, and we look forward to working with them to converting them into bespoke plans for each individual site.
Okay, I'm jumping to the landfill. So from your perspective, so this gets confusing for me, because we've got waste management contractor, we've got the city and county of Denver, we've got EPA, we've got CDPHE. From your perspective, who's the responsible entity for that landfill, for that Superfund site?
To my understanding, there are multiple agencies that coordinate on operations of that Superfund site, so I don't think there's a single entity there. EPA, being the federal agency, is probably the front runner, though, with multiple other consulting agencies, let's say.
So EPA is the regulator, CDPHE is a regulator. My understanding is the city and county of Denver is the owner and contracts with a waste management company. We don't have any comments on the record that I'm aware of from the city of Denver, nor the waste management company. We've got a comment from EPA that talks about appropriate setback distances. And the way I read the letter, at least, it's not talking about surface setbacks, it's talking about setbacks from underground fracturing operations. Have you provided evidence, in your opinion, on the record that backs up your testimony earlier that indicated that you feel that what you proposed is an adequate setback?
Thank you, Commissioner, for that question. If you don't mind, I'll answer a sub question you had earlier. I think in that at the majority of the EPA meetings we've had with the EPA, representatives from the city of Denver and for waste management were also present. And without speaking too much to their authority structure, my feeling was they defer to the EPA as the lead agency in providing comments. So that but Denver and waste management were certainly involved in those meetings. To the question of the proposed setbacks, as I said, the contamination at the Superfund site is limited to the couple hundred shallowest feet of the subsurface, and our proposed wells are at 7,500 foot underground. So we're looking at 7,000 feet of rock between our well bores and the Superfund site. You saw my presentation on seismicity. You saw my presentation on surface rupture to aquifers. We see no evidence of hydraulic fracturing in the Niobrara, sending fluid up that far, causing seismic disturbance that shallow in the subsurface. There's really none of that. I think some of the confusion around the setbacks that are coming up here are simply people not thinking in 3 dimensions. As I said, when this commission normally considers DSU setbacks, you're talking about setbacks between wells that are in the same formation at the same depth between the earth, below the earth. Here, we're talking about the setback between a well at 7,500 feet and a Superfund site near the surface. So that 7,000 feet of Z setback is every bit as good as lateral setback.
So I appreciate the answer and the testimony. I am not a public health expert. I'm not a landfill expert, and I'm not a geology expert or a seismicity expert. And so I guess, don't take this the wrong way. I'm not trying to be mean, but are you an expert on these things?
I have degrees in geology, yes.
Okay. Are you an expert in public health?
No, I am not.
Okay. Have you, I mean, the question is, because I'm having to make a determination if it's protective or not. I've got the regulatory agency that, as you indicated, is responsible for ensuring that it is protective, providing comment about adequate setbacks. Have you provided evidence that indicates, beyond your testimony as a geologist, that it is that the setbacks are adequate?
I'd refer you to our geologic exhibits showing a full mile of pier shale, 7,000 feet of rock, about the lack of any seismicity attributable to hydraulic fracturing in the DJ Basin, about the lack of any surface rupture of fluids, about the overburden of rock layers confining fracks to within a few hundred feet of well bores. I mean, that's all very pertinent testimony to this.
Thank you. Jumping to the BLM comments and some of the testimony around federal minerals. I've followed a lot of it. It seems like there's still a lot of uncertainties around that. At least as I'm reading between the lines between BLM comments and your testimony, help me understand, are you intending to acquire mineral leases with the BLM in the areas that you've indicated? And I think you've indicated that. You've already applied for them. B, in areas where there are federal mineral leases that do not allow for mineral extraction because it's within a municipal boundary, you're intending on drilling through and accessing minerals on the other side. Is that my understanding?
We're intending to have those conversations with the BLM for a non-mineral zone traverse of the lands. And at the end of the day, if they say no, we can't drill those wells.
Okay. And when do those conversations happen? When does that certainty happen?
That's a good question. We have consulted briefly with the BLM on this, and we'll continue that moving forward. And like I said, those wells can't be drilled until we have certainty there. So it is a prerequisite to those areas.
All right, I think I'm almost done, but let me just jump over here to another set of notes. Okay, I do have a few more questions, but I'm gonna pause there, collect my thoughts, and let other commissioners ask questions, and I may do a do-over.
Other commissioners that would like to ask questions? Commissioner Ackerman?
Thanks, Mr. Chair. I can jump in next and appreciate your presentation today. Appreciate you being here and answering our questions. Predictably, my questions are largely wildlife and environmental questions, and some were touched on during your case in chief and or your conversation with Commissioner Messner just now, and some weren't. But I do want to reiterate and talk to Commissioner Messner's earlier point that I think these issues that I'm going to point to are the types of inclusions in the overall cap, if they were to be included in the overall cap, that would go a long way toward the type of comprehensive wildlife planning that Commissioner Messner alluded to. And that said, even if all of these issues that I'm about to discuss are included at the cap level, I would also note that there are certainly other inclusions that will be appropriate during the individual OGDPs. And I wanted to reiterate Commissioner Messner's point that one of the primary benefits to the state of CAPS is master planning in order to help meet the state's priorities on a number of fronts. And in my opinion, the planning commitment at the CAP level that would most fit within the spirit of CAP master planning would be adhering to all HPH timing limitations. As was pointed out in detail, your commitment is to the maximum extent feasible, which you have to understand also potentially means not at all from a legal perspective. And the schedule on the very first site, the only site for which you're seeking location approval in this hearing, doesn't bode well for the operator's commitment to operate outside of the HPH restrictions. And so as part of your testimony, I think this was you, Mr. Bennett, you testified that you don't have, might have been Mr. Harrington, I apologize. I think it might have been, but you testified that you don't have control over electrical tie-ins, but from my perspective, you do have some considerable control over drilling operations. And to your point earlier, I recognize that there are certainly uncertainties and modifications to drilling timelines as you go, and all things can't be planned on a date-by-date basis. But I also recognize that you moved some of those sites, and thank you for doing so. You moved some of those sites outside of HPH. And I wanted to ask if after those adjustments, do you believe you'd be able to devise a schedule whereby you could commit at the cap level to conducting construction, drilling, and completion now on pads that are in HPH outside of HPH timing limitations? Or if the fact that you've moved some outside of HPH doesn't sway that point of view for you?
Appreciate the question, Commissioner Ackerman. And we've given some thought to that, where we could relocate proposed locations outside of HPH, we did, to your point. As it relates to those stipulation windows, you know, and this is a very frank way of saying it, that if we were to adhere to those stipulation windows, we would extend our development timeline by several years in this area, given kind of the I'll use the word choppiness of the cadence that we would have to undertake to move equipment out prior to January 1, for example, and back in at the end of April. And so it would be a very difficult and arguably more impactful development if we had to cease operations for a period of 5-ish months. To be clear, we will avoid when we can. We will do everything we can to avoid those windows. However, based on a number of scenarios we've run since the inception of this idea, it is not going to be, we will be unable to avoid everything all the time. I would also like to mention that CPW did provide a series of robust comments as part of the director's recommendation. I think it was a total of 7 pages or thereabouts, somewhere beginning page 45 or 50 and running shortly thereafter. I assume you all read those, but they were useful comments and wanted to make sure you were aware they were in those materials.
Yes, I am. Thank you, Mr. Bennett, and I appreciate your frankness in your response. Thank you for that. And just to be clear, I'm not suggesting cutting off development during the timing stipulations. I'm simply suggesting examining the prospects of moving the rig to sites that are outside of HPH during those time periods and scheduling those sites that are within HPH outside of those time periods. It does seem to be, I'd have to go back and look at the numbers as to which of those pads are at least currently in HPH, but it appears to be around half to me. And so even with that clarification, you feel that there's not enough work outside of HPH, outside of the HPH timing limitations of generally December to April that would keep the rig busy if you were to schedule it in that manner.
I'm going to ask Mr. Harrington, kind of as the development manager, to speak to kind of the scheduling components and operational phases, if you don't mind, Commissioner.
Sure, thank you.
Commissioner, thank you for these questions, and it's a very good point. As said, we can't examine the schedule and see how the pieces fit together, and we will. I would like to note that the consolidation of pad sites as required by 314 to minimize surface disturbance into fewer pad sites with more horizontal wells puts us at a disadvantage here, right? Because any individual site is going to have a very extended drilling to completions phase. If we were to say double the number of sites in the cap, right? It would be a lot easier to organize them according to HPH, where we do a small site that fits in non-season and then do other sites during season offsetting. But some of these sites, the operational time frame, drilling and completion actually exceeds the entire non-HPH window for a year. And then we get into multiple occupations that has other disadvantages, as you know.
Yeah, thank you for those clarifications, Mr. Harrington. I appreciate that. That major point kind of somewhat exhausted for the purposes of the conversation today. I wanted to touch base on just some of the other points that I think inclusion at the cap level would be appropriate, and from a wildlife perspective. Noticing that I believe that some of them you may have already committed to, and what I am looking for here, if possible, is a commitment to include these at the cap level. I think some of that you might be able to do without a lot of conversation. Some of that might need some conversation, but wanted to touch on those points really quick. And one of those is with regard to the ongoing surveys and studies for pre-construction migratory birds and raptors, including burrowing owls and swift foxes that Mr. Bennett touched upon during his portion of the presentation. And those are committed to as I can determine, but CPW has also asked for a commitment that if such species are observed, that data would immediately be reported to CPW, and you would work with CPW to determine the next steps in any of those circumstances. Is it your intent to commit to that at the cap level?
Yes, sir, especially if it's within a species specific buffer.
Thank you, appreciate that. CPW also requested in their comments that recognizing that some truck trips, you're moving a lot of produced water, as I understand it, to the east side of the cap boundary and then trucking from there. And that would increase some heavy truck traffic on that side, which is beneficial to remove it from the human populated west side. But CPW requested that pickup at those locations be timed, and that the development of those locations be timed so that the spike of produced water would not be within the mule deer or pronghorn wintering seasons. Are you familiar with that recommendation? And if so, can you comment?
Yes, sir. Generally speaking, I'm aware of that recommendation, and that is something that we will have to talk about and provide a response at a later point.
Thank you, Mr. Bennett. And again, to beat a dead horse a little bit, to Commissioner Messner's point, I think these are the types of considerations that can be included in a CAP process and determined, outside of the regular OGDP processes. Can we master plan these things legitimately into our programs? With regard to the state La Plata pad, which is the pad, as a reminder to all who are listening, is the pad that we're seeking location approval for during this hearing. CPW noted that the pad construction and drilling is currently planned is not entirely outside the mule deer winter season. So pad construction and drilling sounds like it's planned for fourth quarter of 2025 to first quarter of 2020. Fourth quarter of 2024 to first quarter of 2025, which would be squarely within those timing limitation seasons. CPW recommended that for that pad, you move that outside of the timing limitation seasons, and that you also complete all 3 phases of development for that pad outside the winter season. So they would add completions to construction and drilling. Have you had conversations about that recommendation, and do you have plans to address it?
We have had some internal conversations about that recommendation, and we have not yet arrived at a final solution. To that end, I think our development timing is predicated on permit approval, and so that could slide one way or the other. But that pad is targeted for initial development, assuming this CAP gets approved, as does the corresponding OGDP.
Thank you, Mr. Bennett. Excuse me, Mr. Harrington, please go ahead.
If I may, on the site, thank you for recognizing me. La Plata Phase 2 is a large multi-well pad up to 17 wells. As paced out in our project development schedule from construction until startup production is almost 11 months. It's not possible to contain that in a single non-HPH season.
Understood.
That's longer than the season, yeah.
Thank you, Mr. Harrington. I appreciate that, which would then require multiple occupations. You can see, though, from a master planning standpoint, how the one site seeking approval begins in the midst of HPH timing limitations would be difficult to give a lot of confidence to efforts to avoid timing limitations. With regard to bats, I think CPW requested that you perform regular site checks for animal mortalities and immediately notify CPW if any bats or other species are observed. I don't think you touched on this during your presentation. It's in the details to some degree. And CPW also makes a recommendation for no surface occupancy within 350 feet of a roost from October 15th through April 15th, but then recognizes that the 500-foot HPH buffer from Aurora Reservoir and the 2 creeks should probably protect roosting bats. Have you addressed that, and do you intend to make a commitment to immediately notify CPW of mortalities and avoid roost sites as recommended?
Thank you, Commissioner Ackerman. To the best of our knowledge, we have not identified any roost sites proximal to any of our proposed locations. All that said, that is certainly a practice we can agree to. So if we do identify mortality, we will report that to CPW immediately.
Thanks, Mr. Bennett. Appreciate that. And I believe that is your current common practice as well. You mentioned burrowing owls during your testimony, and my understanding is that you continue to commit to work with CPW on burrowing owls and follow the CPW survey protocol if warranted. And if a burrowing owl nest is present, create a quarter-mile buffer until the nest is no longer occupied and fledglings are no longer dependent on the area. Did I understand that that was your commitment in your burrowing owl comments?
Yes, that's correct.
All right, thank you. There was some discussion about a few different times during the questions today about the stormwater protections, particularly for that access road that runs near the reservoir. And CPW chimed in on that as well and asks you to ensure that no sedimentation or you take protection measures to ensure that there is no flow toward the reservoir with the road improvements that are making to the east. I couldn't quite discern where we landed on that, but is my understanding that it's your intent to move that road or to position that road in such a way so that it minimizes the potential for flow of sedimentation and stormwater toward the reservoir?
Thank you for that question, Commissioner. We did show a slide, and I'm trying to get the slide here, showing our proposed design for that road. That is slide 58. That slide is essentially the same thing that we provided to CPW. So we're designing that road carefully so that sedimentation off the road couldn't flow west towards the reservoir.
Thank you, Mr. Harrington. I thought that was the case.
Mr. Ackerman, can I follow up real quick? I have another question on that same point. I believe there's supposed to be a pipeline as well near the road, and I believe it would be more protective for the road and the pipeline, or the pipeline to be on the east side of the road, for protections compared to potentially being on the west. Is that a commitment that you guys can commit to?
Thank you, Commissioner. That commitment is actually on the slide, and I just didn't verbalize it. Yes, the pipeline will be on the east side of the road.
Thank you. And Commissioner Ackerman, thank you for letting me jump in real quick.
Thank you for doing so, Mr. Chair. And my understanding is that CPW is not the only one concerned about that issue, and I appreciate you addressing that. I'm just about done with the wildlife points here. I wanted to ask you about the standard language that we see come up often, that if Civitas did they examine to see if any wetlands or creeks will be within 500 feet of chemical storage? And CPW said, if so, as you develop this, they recommended that you hire a professional wetland scientist or the equivalent to find the wetland creek, ground truth it, and then provide CPW with a map with distances if those aquatic resources are within 500 feet, and will require a 1202A3 waiver from CPW. Is that something you're comfortable to committing to as well?
Yes, that's standard practice for us, and all proximate wetlands have been delineated.
Thank you. And then finally, on the specific wildlife concerns, I think, Mr. Bennett, you touched on this during your testimony as well, but you agreed to survey for swift fox den sites in identical or suitable habitats prior to any new oil and gas operations between March 15th and June 15th, and that you would preclude any new oil and gas operations within a quarter mile of an active swift fox den. Did I hear that correctly?
Yes, that's correct. We will certainly consult if we identify a new resource.
Thank you. And before I kind of complete here, I wanted to just make a general statement for those who may be listening, as well as this operator. We've continued to evolve a little bit how we look at caps, how we execute caps. I want to commend operators that do address caps. They're, as you can see, a great big undertaking that require an amazing amount of work and a lot of coordination. Hopefully the benefit in the end is that they allow for better protections through comprehensive planning on all of the fronts, not just the wildlife fronts that I've talked about today. And I want you to know that I'm in discussions with CPW to talk about what level of a potential cap-wide wildlife mitigation plan at the cap stage might be appropriate, as Commissioner Messner suggested as well. And think that's something that for the future we should continue to consider. Just a couple of other items, if I might, Mr. Chair. I also, this is just a comment, and again, while I understand the frustration with the lack of control that you may have over electrification of sites, we do have a time frame under which you can hopefully start with electrified sites and commit to as much electrified drilling as you possibly can. My understanding is that you have a high confidence that you'll be able to electrify the production sites once they are underway. I just wanted to, without going into further detail, state that I'm on the exact same page as Commissioner Messner as he vocalized those concerns. And then the last issue also you've talked about a couple of times, but I wanted to clarify the point on drilling under the landfill. The EPA, of course, requested that the state of Colorado and the operator establish an adequate buffer zone around the actual site boundary, including the extent of the contamination to the north that won't negatively impact the effectiveness of the site's remedy, leaving it as such that EPA, I believe, left it to us and to you to determine what those appropriate boundaries would be and what the potential buffer zone should be. And you mentioned vertical setbacks during your testimony, Mr. Harrington, and you didn't really specify proposing horizontal setbacks, stating that we should think of the issue in 3D. And then during your cross-examination, you mentioned that you believe setbacks were built into the proposal. And I wanted a clarification on that. Did you mean this to refer to the vertical distances you referenced during your testimony? And if not, can you clarify, and can you also state what specifications you're relying on, to Commissioner Messner's point again, to determine that vertical setbacks would be sufficient when EPA and BLM has asked for no drilling under the landfill from kind of a horizontal perspective?
Absolutely. Thank you for that question. I was referring to vertical setbacks, again, that vertical setback being over 7,000 feet between the tips of the horizontal wells and the overlying front site. And as I said to Commissioner Mesner, our testimony around seismicity, intervening stratigraphy, and faulting is very pertinent to show that that setback is sufficient. I would add that if you want to think about horizontal setbacks and you do the essentially the Pythagorean theorem, a increase in your horizontal setback relative to a very tall depth, the hypotenuse of that, it doesn't materially increase that setback distance, right? 7,000 feet to 7,050 feet. So from a percentage basis, no matter what we do, the vast majority of setback is going to be in that Z direction.
Thank you, Mr. Harrington. Even with my significantly limited math skills, I understood your point there and appreciate you making it. So my final, I guess, soliloquy on this issue is I've stated a lot during this these questions that master planning from a wildlife perspective is very desirable under a cap. I didn't intend to state that master planning has not taken place with regard to this cap. I think a significant amount of master planning has taken place with regard to this cap. I'm hoping that we can be a little more purposeful about articulating that master planning and setting forth kind of the what that story looks like, at least from a wildlife and environmental perspective, as we continue on in the future with caps. Appreciate you answering my questions here today. Thanks, Mr. Chair. That's it for now.
Thank you, Commissioner Ackerman. Further questions, Commissioner Cross?
Thank you, Mr. Chair, and thank you everyone for putting in this long day. And that goes to stakeholders as well who continue to listen in. I know this is a lot, but I do think it's a very important issue, as has been demonstrated through the significant public comment that we have received on this and interest that we have received on this application. I want to ask some questions, and really my questions are going to be focused on some clarifying issues, both with respect to things that were talked about in your presentation, as well as some issues that have been raised by some of the previous public comment. And so I will admit one of the first things I was going to ask about was the western access road there and the pipeline with it. So I do appreciate that being talked about. But I'd also like to talk a little bit about some of the traffic. And in particular, one of the things that was raised is that, especially on the western part there's limited produced water takeaway. And then where is that being picked up, and where is the thing going to for the injection site?
Thank you for that question, Commissioner. Our proposed takeaway site for the limited produced water gathering system along the Western Ridge Road, excuse me, is a legacy site close to Quincy Avenue called the State Harvard Blanca site. That is easy access from Quincy. It is fully 3.5 miles from the Western Cap boundary and would provide a good pickup point to truck that water away. Does that answer your question?
It does. And I guess to get an idea, what are some of the difficulties in also having produced water takeaway from there to your ultimate injection sites?
Thank you, Commissioner Cross. And we've addressed this in multiple OHVPs. The produced water pipeline that would be required to be installed to get from there to the nearest commercial disposal well would be upwards of 25 miles or more. And given the relatively short time period of heavy water trucking for DJ wells, again, DJ Niobrara wells produce a lot of water up front that very rapidly tapers off to very little. We're confident that the impacts of installing 25 miles of pipeline would exceed the amount of traffic, again, mostly in the initial year per site for each of these sites. And I should add to that, for reasons we've discussed, the idea of installing a commercial disposal well closer within Arapahoe County is a non-starter.
And one of the other things that was discussed during your initial, your opening presentation here is you have some of the reductions in emissions, and one of them specifically talks about, let me make sure I get the correct slide here. I believe it's slide 66. So the pipeline installation having reduction, and I apologize, it's exhibit quad G, Bates number 1134. But it talks about some of the different greenhouse gas emission savings and nitrogen oxide emission savings over 3 years, in particular because of the emissions or because of the water pipeline and the reduction in truck traffic. I wanted to highlight this for 2 reasons. Number one, I know that there was a lot of public comment talking about truck traffic not being analyzed. And so one, to talk about that, but 2, to make sure that we are clear in what you have looked at is the additional truck traffic that is now taking place off of the cap boundaries from this limited pipeline takeaway on the western portion. Are those truck traffic numbers included in your overall estimation? And I apologize if that was a bit convoluted.
Yeah, I think I can try to answer what you're getting at. These reductions are within the cap boundary. So not being able to speak to like a barrel per barrel equivalent trucking off site, I'm not sure we can answer that.
Okay, so the answer when looking at this slide 66 is yes, there is going to be reduced traffic, but it may not be this big of a reduction because there still will be some traffic trips from that site mentioned on Quincy Avenue.
I think that's right.
Okay, and how many of the sites will go along that produced water takeaway to that Quincy Ave? Because I assume that there still will be some sites that still will go to an ultimate injection site, or are they all going up to that site?
I can answer this. It's contemplated currently for water takeaway for 3 sites specific to the Western Ridge Road. And those are Beaver, Sunlight Long, and Blanca.
Okay. Is there a way that we could get some kind of estimation on what the numbers will look like for that truck traffic takeaway once it does get off the cap site? And I don't need it immediately now. Perhaps that's something that could come up as we continue this hearing on Friday as well. But I just want to make sure that's something that we could at least get some numbers around.
We have that delta and we'll have to pull it out and provide it if you don't mind.
Okay. I appreciate that. I want to go into a little bit of discussion on the seismic, which I know, again, has been brought up a lot during public comments and has come up numerous times today. And again, this is more for clarification because I do appreciate what you discussed during the presentation today, and I think it did answer a lot of the questions. But as we look at it, so there's been some discussion of the boundaries around the Superfund site and the 7,500 feet with that. Now, Mr. Harrington, one of the things you talked about was the Pierre formation and it really creating a 5,500 foot, so more than a mile separation of quality buffer, in addition to some of the other formations as well. And to clarify for everyone listening in, that formation is going to be present throughout the entirety of the cap area, correct? Okay, so everyone knows this is not like, okay, just by the reservoir, there's this area over here, but you're going to have that 5,500 foot level throughout the entire cap boundary and surrounding areas as well.
The Pierre Shale was deposited in the Lake Cretaceous when this area was a sea. And yes, the stratigraphic continuity is very good over wide areas.
Okay. And one of the things that I wanted to try and focus on as well was the idea of the seismic events. And as you mentioned, there's not been any indication of any earthquakes, and I believe you said it was over 2.5 on the Richter scale, occurring in Colorado, or specifically the DJ Basin, sorry, as a result of fracking. But there have been 6 instances, and all 6 of those instances were related to injections for wastewater, correct?
That's correct. So the 6 earthquakes that were identified between 2.5 and 3.2 magnitude were linked at depth and geographically to injection sites, not to hydraulic stimulation or producing wells.
Okay, and I think one of the key things that came up in a lot of the public comments was this concern, especially with relation to not just something from the fracking fluid going up into the reservoir, something causing fracking issues with the Superfund site, but also there was discussion from public comment about damage to the dam. And I know a couple of the public commenters specifically said the dam wasn't built with oil and gas in mind. Now, I'm not going to speak to that one way or another. I'll let the U.S. Army Corps of Engineers talk about what the dam specifications were. But do you do any kind of analysis related to the dam structure or any potential impacts happening to the dam?
To answer that, Commissioner, I'd again point to the study we did measuring surface vibrations during a frac. And again, by the biggest vibration we saw was somebody jumping near the seismometer. So if we're comfortable with me jumping on top of the dam, we're comfortable with leading 7,000 feet below it.
Okay. And again, to try and put things in perspective, the bigger issue is the injection of wastewater, not the fracking, based on what your information shows. Where is the closest injection site to the reservoir?
It is in Wells County, to my knowledge. It is in Wells County, roughly 20 miles away, and don't quote me on the exact number.
And that's an existing use injection well?
Correct.
So we haven't seen any issues with the well that's currently being used having any kind of seismicity issues with respect to the reservoir, the dam, et cetera.
That's correct.
You mentioned that there was numerous existing wells in the Lowry Cap Ranch area, or sorry, the Lowry Ranch area, but none of them are operated by Civitas or Civitas subsidiaries, correct?
Yes, there are a number of vertical wells that are not Civitas operated, but which still are producing.
They're producing. Do you know if any are shut in?
I don't know, but I suspect some may be shut in.
Have you had any discussions? Well, I guess we'll take a step back. Similar to looking at, I believe you answered questions about GMT and not sure what their impacts would be, and so therefore their impacts not being part of your cumulative impacts analysis. Given the ongoing operations there, were those operations included as part of your cumulative impacts analysis?
I believe they were included qualitatively. They were noted, but they did not, as non-Civitas operated sites, they were not included in the numbers. But again, these are very, very few, very low producing vertical wells that are kind of a separate beast from the horizontals we're proposing.
And one of the things that, and this is where my initial question was going to go with it, have you been in contact with the operators about either them plugging some of those wells or about you plugging some of those wells, given their proximity to some of the ongoing operations or being within the cap boundaries at all?
We have had those conversations. The bulk of the wells we're talking about here are not Niobrara producers. They're J-sand, deeper intervals. So completions and production in the Niobrara don't directly affect them. However, we do recognize that as part of our development process, we will need to evaluate those wells, their casing, their cementing, during the Form 2 process.
In looking at and having discussions with the operators about potentially plugging some of those wells, no offsets have been taken into account with respect to the cumulative impacts based off of those wells being plugged, correct?
No, the answer is no, because we haven't had any commitments from the other operator to P&A specific wells. As those wells can viably continue to produce from the J sand during and after our Niobrara formation, development.
Can you go into some detail about the planning for potential spills at some of these sites? Because I think one of the things that sticks out to me, especially as you look at some of the seismicity issues that you brought up, I don't think that there's going to be the issue of any kind of fracking fluid going up to the reservoir, but clearly the drinking water, the reservoir itself being nearby is an issue. And so to me, the bigger concern is a spill happening, it getting into some sort of tributary that then leads to the reservoir. So can you go into a little bit of detail on some of your best management practices, on some of your plans to make sure that that doesn't happen?
Absolutely. Thank you for that question. So first, we have our primary containment, tanks, wellheads, etc. We also install secondary containments around tank vessels. That is a low-lying rubber-lined metal berm around those. Third, we have our pad control measures. So the pad is designed to outflow into a controlled sediment basin, or should the first two measures fail, any spill would go there. But lastly, and you saw this in some of our hydrogeology slides, any spill off a pad site would not flow to Aurora Reservoir, period, because we are either over a drainage divide, and that turned into sunlight long, or we are literally below the dam in the case of State Blanca, so down gradient of the reservoir. There's no surface path for a flow to the reservoir.
Okay. And building off of the water issue, again, a lot of the public comments that we heard both in the 511 hearing back in May, as well as some of the public comments that we've received in written form, as well as that were presented last 2 weeks ago, apologize. There is obviously a lot of discussion about the fact of the water usage that will occur with this, with this proposed development, especially with respect to fracking. And I believe the number that kept coming up was 4 billion gallons. And so could you provide a little bit of information on where that water comes from, whether it's drinking water, whether it's not drinking water, and how that water is set aside, and could it be used for other things?
Thank you for that question. The bulk of our completions water used in our operations in the area is excess agricultural water purchased from agricultural collectives to the north. So again, this is water that is available for agricultural uses. It's not direct drinking water, and it's sold to us at market prices. Additionally, we have some contribution from Rangeview Corporation on the Flowery Ranch cap itself. Again, that is aquifer water. It is not drinking water. It is not coming out of Aurora Reservoir.
That is helpful as well. And before I get to one of the questions about the preliminary siting, another set of questions that came up a lot during the public comment was, why can't you move these sites further away? Now, at the beginning of the day, we heard from the State Land Board in terms of where some of this no occupancy areas would be, some of the areas that would kind of cost more. But can you provide a little bit more detail responding to those comments with respect to why can't you move these pads further away than I think the closest one is currently 3,200 feet. Most of them are in the 5,000 foot range, but why can they not be further away?
Thank you for that question, Commissioner. I believe Ms. Joseph is going to pull up a slide, but let me just start in principle by pointing out that our original pad settings were compliant with state and local rules. We modified them in response to revised Arapahoe County setback rules that are the strictest in the state. They're minimum 150% of state rules. And now we're fully compliant with that. So our one point we could make is, what is the point of regulation if compliance with the regulations doesn't allow siting of a pad site? However, we were asked specifically about the feasibility of moving State Sunlight Long eastward. And we did prepare a slide to address that. I believe it's at the end of the deck. Ms. Jost?
Mr. Harrington, sorry to jump in, but are you referring to slide 147?
Let me, I apologize. Let me be,
That's okay. Just
I don't
want to
have every number.
if it's in the supplemental slides, is that the one you're referring to?
It is supplemental. It is 167, please.
167, Kelsey, thank you.
So we prepared this analysis to address Arapahoe County's request to move the site further east. Arapahoe County suggested a potential site over here in eastern section 26, the alternate Sun Long site. As you can see, our current state long site is situated between the Aurora Reservoir, Land Reservoir, homes to the west, and if you recall, some riparian area under 1,000 feet to the southeast. So a short range move isn't possible, right? Because we'll violate one of the setbacks, or we'll wind up in this north surface occupancy zone, the red here in the state. So the concept of moving a full mile east, a couple of issues. One is it would require wells like this. Wells are a 1.5 mile side sail into a 4.5 mile lateral out to the edge of our development area. No one, certainly not Civitas or any other operator, is capable of drilling wells like that at this time. So operationally, this just doesn't work. You know, jump to the next slide, please, Ms. Just. Further, we have some issues around road access. If we attempted to connect to our Western Ridge Road, we would obviously need to cross some drainages, some NSO area where no current road exists. So that's new road disturbance. Were we to connect to the south, we would have to build through some drainages. And it's not clear that we would even have rights to use the road in the vicinity of the secret stash pad down here, as that is not our lease. Next, we have pipeline connection. Were the site to be here, our closest pipeline connection point is the La Plata pad up here. As you can see, that's a very challenging build across Natural Creek.
And I appreciate that. And so I have two topics left. The first I want to talk about is the preliminary siting analysis. And then the second, just to give a preview, is going to be about the BLM leasing. With respect to the preliminary siting analysis, you are seeking preliminary siting approval for just one of the sites, correct?
That is correct, Commissioner, just the state La Plata site.
And at the state La Plata site, it's an existing one that you're planning on expanding.
That's correct.
And can you go into a little bit of detail on the makeup of what the pad will look like? In terms of what's currently there, are there currently some oil and water tanks?
Absolutely. So there are currently at that site either 6 or 8 oil and water tanks. Our ultimate design will have 6 tanks, 4 oil, 2 water. Excuse me. The site already has produced gas takeaway in place, and we will install additional oil pipeline takeaway that is not there currently. It will minimize the impacts from the new wells as well as the old wells, as they'll be tied into the same takeaway system. Physically, the pad itself currently sits on a bit of a flat land between the current State Land Board access road and a ridge. The new pad site will simply expand that pad site a bit north along the road. And we consider it to be an advantageous siting because it is predominantly in the state land board preferred tier occupancy and very close to, no new road bill will be made. Actually, the road will get shorter because we're building out over the existing road.
Okay. And can you go into some detail as to why, given the additional pipelines that will be there, why tanks will remain?
Thank you. That's a very good question. Water tanks are needed for water offloading. As discussed, we don't have produced water takeaway to a disposal well in the area, so those can't change. The oil tanks are required because our oil system is what you might call a dead oil system. In other words, we need to allow the oil to devolatilize and put the gas into the gas pipeline system. We can't put that, let's say, pressurized oil with a lot of gas in it directly into our pipeline system. It isn't built for that. So those oil tanks serve as a buffer between the producing wellheads and the oil system.
Okay. And then I think what's my last topic is the BLM. And so either Ms. Jost or Ms. Wasilenki, it might be helpful if we bring up some of the BLM leasing issues here. And I know that there's still some ongoing dispute about both access to minerals, as well as Commissioner Messner brought up the ability to go through some of these leases to access some of the minerals. And so I'd first like to get again, just a little bit of explanation from you on kind of where this sits, and then I might want to dive into a little bit more some of what was included onto your slides. So if you could just kind of start with what are kind of the outstanding issues as you see them, and kind of how you foresee that moving forward.
Ms. Jost, that's slide 106, please.
Yep, we're getting it, Dan.
Thank you. So if I can run, I'll run through it by type. If you speak to the sort of yellow acreage, some of it has been cut out of the gap. That is the Lowry Landfill Superfund site. It will not be developed. Sections 31 and 32 just north of there. Just can we point? That might be helpful. You pointed sections 31 and 32 at the northwestern corner of the gap. Those are fully leasable federal sections. We nominated them for lease in April 2022. We are still awaiting a bid date. If we look at the blue minerals, sections 4 and 9 in particular, those are the first mile of the state Sneffels and the west-facing state Blanca wells. Our concept is to seek approval to drill through those unperfed, develop the lands beyond. That is very much subject to BLM negotiation and approval. And if we don't get there, we won't drill those wells.
And I guess to interrupt there, if you don't get approval to perf through those sections, what, I guess, will that change the overall design of the cap, the way you have it designed now with the kind of the north to south layout of some of the sites? If not, why? And if so, how will it change it?
Thank you, Commissioner. To be clear, I think you said we would seek permission to perf in those tracks. That's not on the table. Just to traverse past, yeah. I think what this the answer here is our surface locations are all located on Lowry land. So those locations are all east of the blue tracks. We are not planning to propose additional sites should this traverse issue not be solved. So if you're asking whether we're going to put a site on top of the section 32, that's not really in the cards. We're going to stick to our existing sites. And if we can't drill those west-facing wells, we just won't drill them.
Is it possible there could be consolidation of some of the wells, given that it won't be going as far to the west at that point in time?
The way, and we unfortunately don't have a plat with our pads overlaying on. Actually, we may. If you could jump to Miss Jost, slide 61, please. So this plat does not differentiate among the different types of federal acreage, but if you look at the middle site for the green, that's federal acreage, and the state Sneffels and state Blanca sites just to the east of that federal acreage. State Sneffels, frankly, if that traverse doesn't work out, that site will probably never be built. And for State Blanca, half of its wells drill eastward. Those are garden variety Colorado mineral wells, and we'll plan to develop those. The site will shrink if we do not drill the west facing wells.
So for that one, it would probably still be the same site proposal, but with the fewer number of wells just heading to the east, not to the east end.
Significantly smaller, half the size. Yeah.
Okay. And if you could go back to, I think it's 107 or 108 after the previous one, it talked about some of the ongoing discrepancies, and I'll come back to the awaiting leases soon, but can you give an update? And I partially want to talk about some of these. Obviously, it comes down to some title issues, but can you give a brief overview of what some of these title issues are? And then I'd like to discuss where we are in terms of getting this resolved with BLM.
Of course. So we have conducted title research in the area, and we feel that we have clear title showing federal ownership in these areas. I would note that if you look at the gray tract kind of in the northeast here, that tract conflicts with Colorado records. We believe that to be Colorado land, as does the state. So that's one example. I can point to other examples in the gray boxes in the southwest where we have signed leases with fee owners in those areas. And we don't sign leases with owners we don't think own the tract. So we do feel our title research here is fulsome. We have provided it to the BLM. We are probably due to have conversations about the status of their integration of that title research.
And depending on the outcomes of that, do you foresee any potential issues with drilling should they continue to argue that those are BLM lands?
I believe those are issues we will have to resolve before we drill, yes.
And do those issues play in at all to your scheduling or proposed scheduling for the cap?
I don't believe so. The first site we plan to develop, the State La Plata, does not contain any of those gray boxes, and that we have some significant time in once we get through the development there.
Okay. And then finally, I just want to talk a little bit about the leases up there in 31 and 32, which again, for everyone's reference, is the far northwest part of this. You mentioned that they've been submitted for the leasing process. There's obviously been a lot going on under recent years in terms of leasing occurring, challenges to leasing. Have you built any kind of protections around the drilling of those minerals should either those leases not be leased or be challenged in court for NEPA purposes? And would that affect your schedule?
I believe the short answer is if those minerals aren't leased, we won't be drilling wells through them.
Would you still have a site similar to the one talked about before where you would still drill east? It would just be smaller number of wells in a smaller pad instead of going east and west.
That particular DSU is intended to be drilled by a single site, State Wilson, with west-facing wells, 3 miles in length. So I'm speculating here. I don't want to get too far ahead of myself, but I would anticipate if leasing fails in that area, we might simply drill shorter wells.
Okay. So at this point in time, this is still kind of an unknown especially with respect to sections 31 and 32.
That's correct, but as I said, we don't see any particular encumbrances to that acreage, and it is leasable. But we plan to move forward.
Okay. I believe those are the only questions I have for now. Thank you.
All right, commissioners, we've had a bunch of nice questions here. I unfortunately need to call a hard stop. I've got some obligations this evening. We do have this set for a continuing hearing on Friday, starting at 9 a.m. Ms. Jost, the one thing that I would ask is there is a letter from Representative Crow to the EPA, and there's a response letter from the EPA to Representative Crow concerning the Lowry cap. That has been delivered to your inboxes. I will have questions about those letters and Crestone's take on those letters on Friday when we resume. Unless someone's got something really pivotal to ask now, I would suggest we continue the hearing to Friday at 9 a.m. That is Friday the 2nd at 9 a.m. Commissioners, are you comfortable with that approach at this point in time? And hello again, Mr. Foote. Did you have anything further at this point?
No, thank you.
Okay. And we will probably start up with any additional final questions for the applicant. I will then provide Ms. Jost with a bit of a chance for any redirect that results from commissioner questions. And then Mr. Foote will turn to you and to your case in chief, and then just continue to follow this along. And I believe we should be able to work through all the matters on Friday the 2nd. Seeing no further objections, I would move continuance of this docket to Friday morning at 9 a.m., August 2nd.
Second.
Motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? Great. Thanks, everybody. Appreciate the 103 people still with us. We will see everybody Friday morning on this docket. We do have a docket tomorrow morning. It has nothing to do with this. But if you're bored and want to watch us with that docket, come join us. See commissioners 9 a.m. tomorrow morning. See all those that are interested in Lowry Cap on Friday, August 2nd at 9 a.m. Bye.